Hey, what's up, guys? I'm going to turn this thing on. We're not doing an intro or anything. Here we go. Here we go. Sorry.
And,
fucking power outage.
these are just basically shots off the internet. Is that fair?
Just
these are screenshots taken from the Google Photos application that was installed on the phone.
Okay. There's a date, at least on the first page, that says Saturday, February 12th, 2022. Is that correct?
Yes.
And then on the last page, it says Saturday, December 18th, but it doesn't have a year. Is that fair?
Yes.
So are these different pictures from different time periods?
So the date correlation would be, so the first one, Saturday, February 12th, 2022, you would start looking at everything underneath that belonging to that date and time. And I take screenshots in chronological order, and I always try to include the image above and below just to make sure there isn't any way to say that images were skipped or passed over. So you'd want to follow along chronologically, that any image that is after the one on page 1 that goes to page 2, which then goes to page 3, would all be under Saturday, February 12th, 2022. I'd have to see the screenshot below the December one to make a decision on that one, but from the ones I'm seeing, these would all be under the February 12th date.
But the last page, you would agree, it does say Saturday, December 18th, correct?
It does, yes.
Okay. And these are pictures where? In the Google Photos of this phone, or where were these pictures found?
These were located in the Google Photos application. Photos can be added to that application in many ways. A lot of times there's a regular gallery that's on a phone, and when you take pictures or you download pictures from the internet and save them to your gallery, they're later backed up and synced to the Google Photos application. So likely these photos at some point were on the gallery of the phone, or they could be added by logging into this account on a computer and then adding them that way.
just finishing getting everything set up. I'll start yakking more in a minute.
Is it possible that these pictures could have been downloaded and put into the Google Photos app on all different dates?
Usually the Google Photos application is going to take the same date that that photo was captured. So that photo was likely captured Saturday, February 12th, 2022. It's just going to grab that date from the gallery and bring it right in with Google Photos.
But you don't know 100% when these photos were downloaded. Is that fair?
We would have to click on that photo and click information, and then it would give the exact date and time that photo was taken, or we could look in the original phone extraction under the regular images tab, which would be associated with the phone's gallery.
But as you sit here today, these photos in Exhibit 102, you don't know what date these photos were downloaded and put into the Google application, correct? Is that fair?
I would say the pictures were taken on Saturday, February 12th, 2022, or saved at that date or time.
How do you know that?
Because that's how Google Photos associates dates and times with pictures and images.
Can you say that 100%?
Very certain, yes. In my experience when looking at this application, it's been very consistent.
Do you have any trouble with the fact that this Exhibit 102 has February 12th and December?
No, she doesn't have any trouble with anything regarding this stuff.
No, so that likely was the order that the other pictures were placed onto the phone. So that there could have been a time lapse of when the phone wasn't being used or when photos weren't being taken or added to the Google device. The phone usually has to be connected to Wi-Fi at some point for this backup and sync to occur. So maybe the phone wasn't
That's not true.
connecting to the internet at any point, or the Wi-Fi for that to happen. I can't say for sure without looking at the phone.
And in your occupation as a forensic analyst, you see all kinds of searches. People search for bizarre things for shock value. Is that fair?
I don't object. I think this is beyond the scope of what we're trying to accomplish here this
Oh,
morning.
is this beyond the scope?
Being present.
I'll withdraw it.
Oh, so this is
Nothing.
Wadir before the jury's present. Okay,
Any
my
other questions?
there we go.
Not for the witness. No.
Thank you, man.
Thank you.
So that's a forensic phone analyst. There is a challenge to her to her testimony before the jury
Anything else?
about certain
Just to
photos
clarify, I think
and
what
searches.
what I would ask to do, Your Honor, is recall Ms. Luberta when we come forward. I have very brief questions for her regarding these issues. I don't intend to go into depth regarding these photos. I think we simply want to put in the fact that the searches were made and the photos exist. I would ask to briefly recall Analyst Danelski after Ms. Luberta, just to clarify the technical aspects of it, if Attorney Freilich has those specific questions, because she's going to be in a better position to answer those questions.
Okay. Any objection to that, Mr. Freeman?
Your Honor, I'm going to object because these witnesses have already been called, and now they're going to be called again.
Well,
I guess if he doesn't cross on those points, I'm not concerned, but if he starts crossing on points that raise the technical issues, then I want to be able to recall her to answer those questions.
well,
for
we'll
the
see
hearing.
where.
Well,
the-
wouldn't
where the
you do
testimony
that
leads, and then I will,
In your
address the
rebuttal
issue.
later?
So, just
I mean, that's
to,
4.
run through again, I've had the opportunity now to look at the exhibits that are being.
It's like
offered,
we have
and
a
that's
process for
specifically
bringing someone in to
99,
rebut
101.
something that was brought up by another witness.
100 has been withdrawn. I think yesterday I addressed some of the issues. I've had a chance overnight to frankly review the elements of the offense that the state has to prove, just in thinking through this issue. And one of those elements, of course, regarding homicide is an intent. Is an intent element. That's element number 2 on the homicide. And then if you look at the jury instruction, it explains to the jury what they can look at. It certainly indicates that the jury cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case
Okay.
bearing upon intent. The second count, the
I
mutilating the
think I'm
corpse,
ready.
that has an intent element with
Look
it.
at that tie.
But
Well then.
reviewing
Hello,
what's
Judge.
being offered.
Hey, thank you,
particularly
Jonathan
99
Phillips, for the
and
super
then
chat.
100,
Tyler Reeves
I've
says,
indicated
"Sup,
that,
Nick? What's up?"
Items 1 through 9, I don't believe are. I'm not going to allow those to be referenced. If this were to go to the jury, I would want those redacted because I don't think those types of references are such that their probative value outweighs the prejudicial effect. On the other hand, the items 10 through 35 relate to Jeffrey Dahmer, and the circumstances of the events of Jeffrey Dahmer's homicides are frankly conventional wisdom, not just in Wisconsin, although particularly here, but other places.
Wait, what?
And people are familiar with the nature of what occurred in that case. The events, now having listened to some of the events, particularly from the coroner, about the events of this case.
Listening
there's
from the
similar
corner, you
elements.
cuck.
And while the court has to be cognizant of issues relating to prior bad acts, that's not what this relates to. This relates to someone's demonstrating an interest in these, and there's numerous searches. So I'm looking at 10 through 30.
Okay, everybody, you just have to listen to how retarded this reasoning is.
And I think that's relevant. Relevance, essentially, relevant evidence means evidence having a tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And I think this really goes to that intent element. The state referenced that. I also referenced yesterday the concept of motive. And while the state doesn't have to prove that, that kind of evidence often comes in. I'm satisfied for those reasons that this report.
Searching
is
for
relevant
Jeffrey
to
Dahmer
the
is
extent
not
that I have
motive for
redacted.
murder.
101, I'm also satisfied.
This is
that the
baffling.
findings yesterday, as well as the additional findings I made today, remain the same. I'm going to allow that to be admitted. We've now voir dired these two witnesses, and I think the status of the case is such that we would bring the jury out and have Lieutenant Liberta come back to the witness stand because that's where she was when they left. Anything before we bring the jury in, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay. Then we'll bring the jury in.
Sending out a couple invites. Look, this is just frustrating because it's highly prejudicial to reference Jeffrey Dahmer in a case like this and make out like a search on a phone has anything to do with a drug-fueled murder. It takes what the prosecution is able to do with this is cherry pick a selection of search terms amongst all the search terms that she has on her phone and decide that Jeffrey Dahmer is
Ladies
the
and gentlemen,
search
welcome
term
back.
that goes
We had a
to her
pleasant
intent
evening.
and state of
We are ready
mind
for day 3 of the
on
trial.
different
I
dates
think,
at
the,
different times
the
to show
last
that that's what
witness
she
that
was
was on the
doing for
stand,
murder.
Ms.
It's
Liberta,
so
if you could
fucking
step
weird.
forward, please. We'll get underway where we left off.
It's not an obscure search either. If it was an obscure specific search, like how to
We're gonna put
dismember
you in
a
row again
body
here in front of
around the
jury.
date, okay, you got something. But Jeffrey Dahmer is a ubiquitously infamous serial killer in the United States. So to suggest that that search is particularly important over all of the others is weird to me.
Ms. Liberta, I believe yesterday we discontinued when you were discussing your analysis of Ms. Schabusiness's phone and then a subsequent Google warrant.
What up, Strong Chin?
obtaining
How
the
you
data
doing,
from the
girl?
phone. Can you explain the two different searches that you did on the phone and then on the Google warrant?
Sure. The first search I did of the phone, the cell phone device itself, was done on March 2nd. And that was just the contents of the phone. And then in discussing it with computer forensic analyst Danowski, she suggested that an additional warrant could be done for further information regarding the email addresses, the Gmail addresses that were connected to the phone. And that would have been a whole separate warrant and a separate search.
And when you were reviewing the phone itself, the extraction of the phone itself on March 2nd of 2022, did you note any searches related to Jeffrey Dahmer?
Yes.
Was there one? Was there more than one? How many?
A million.
4 total.
Oh my God.
Searches.
How many
Such
total
things like
searches did she
Jeffrey
do
Dahmer,
on her phone?
Jeff Boyardee, Jeffrey Dahmer's butt, Jeffrey Dahmer walking into court all sexy.
Jeffrey
And
Dahmer
did you
walking into court all
subsequently
sexy
look
is
for that
definitely about
same type of
murdering
information
someone.
when you reviewed the
fucking hate this shit.
warrant return from Google?
Yes.
And did you find essentially corroborating or similar information when you reviewed the Google search warrant data?
Yes, they were similar.
And Your Honor, is Exhibit 99 available?
Oh yeah, so people asking about my power outage last night.
And Ms. Luberta, what is Exhibit 99?
We had intermittent
This is
power
a celebrate
outages.
extraction report from the Google warrant return.
Power was going
And
in and out
what
like
is
the man of the
contained
Nash
in
farm.
that exhibit?
Searched
Bad.
items.
And I would draw your attention specifically to items 10 through 35 on that. Are they numbered? Is that correct?
Yes.
And items 10 through 35, generally what is contained within those numbered items?
The searches that I had referenced earlier, Jeffrey Dahmer, Jeff Boyardee, Jeffrey Dahmer's butt, Jeffrey Dahmer walking into court, Jeffrey Dahmer walking in all sexy in court.
And is that?
I'm looking up Jeffrey
is that an
Dahmer
extraction
walking in all
report
sexy in
consistent with
court.
Reports you've generated in the past or that
Jeffrey
you've seen generated in
Dahmer
the past using this Cellbrite software?
Yes.
Walking in court,
And then I would
looking
move for the
all
admission of
sexy.
Exhibit 99.
No objection, Your Honor.
Okay. Well, there were objections, but
Yeah.
those were noted, and I'm
Yes.
going to receive 99.
Yes, there were objections, but the court already ruled on that.
Then, Ms. Luberta, did you also, on March 2nd of 2022, when you were looking at the device extraction, did you do a search of photos on the defendant's phone?
I did a search of the device screenshots.
I didn't find
And
anything on there.
what are the
Jeffrey
device
Dahmer's butt.
screenshots?
So the device screenshots are screenshots taken by analyst Danelski of the photos contained in the Google Drive of the device.
And are those photos that she manually took?
These are all from
herself
the
based
show
on the
now.
photos that were on the Google Drive of the phone?
Yes.
And did you review those screenshots?
Yes, I did.
And did you likewise see any photographs of Jeffrey Dahmer?
Yes.
Was there one, more than one?
Yes, there was more than one.
How many?
Approximately 10, 12, maybe more.
And did those have a date associated with them?
Yes, they did.
What were those dates or date?
The date that I remember is February 12th, 2022.
And are those consistent with the dates of the searches that are referenced earlier in the Exhibit 99?
Yes.
Is Exhibit 102 available for the witness?
I'm not even finding a good picture of Dahmer's butt except for the Evan Peters guy. By the way, I like Evan Peters, not in a gay way, but as an actor.
Ms. Luberta, what is Exhibit 102?
This is a Celebrate extraction report of the screenshots taken by forensic analyst Danelski.
So this is a report from the device itself, is that correct?
Correct.
And does 102 depict the photographs of Dahmer that we had just discussed?
Yes.
Does it also contain photographs of Ms. Schabusiness?
Yes.
What is she doing in the photographs that are depicted in that report?
She's got a cell phone next to her head. There's a picture of Jeffrey Dahmer on the screen of the cell phone, and she's taking a selfie with it and smiling like they're taking a selfie together.
And what is the date of that photograph?
That was February 12th, 2022.
And is Exhibit 101 available for the witness? Ms. Luberta, what is depicted in Exhibit
Something
101?
about this chick is unsettling
The
to me.
photograph I just described.
I think it's the fact that her shoulders are bigger
And I
than
would
mine.
move for admission of 101 and 102, and I would ask for permission to publish 101.
Same objections. as-
Brian Miller says,
Okay, I'm going to receive.
latent gay
101,
bigot,
102.
1 to 10 on this witness. She's cute though. I mean, like a 7 maybe. Legal mindset. You put me in a battle royale, brother. You better hope I'm coming for you. Patty Leather. She's not gorgeous. She's kind of attractive.
Your Honor, I think one of the jurors has his hand raised.
Swim team chick, lumberjack chick, man. Oh, by the way, 7 in the Midwest, right? Like,
And
this is a key.
Ms. Luberta, is the screen now depicting?
Depending on where you are, you would rate her
101.
differently.
Yes.
And that's the photograph from Ms. Schabusiness's Google Photos from February 12th of 2022.
Correct.
Thank you. I have no further questions of the witness.
Okay, cross-examination, Mr. Fralick.
Ms. Liberta,
That picture of her laying
You
next to
talk
Dahmer
to-
can't be a joke or anything.
Taylor Schabusiness, correct? Did you talk to her?
No.
You found out that Detective Groff had spoken to her, correct?
Correct.
And did you find that, did you find out that Ms. Schabusiness said that she was only able to
I'm
utilize
going to
her?
object, Your Honor. He's asking for hearsay information. He's not allowed to admit statements of the defendant through a witness. Only the state can elicit those things. And this witness also did not speak with Ms. Schabusiness herself.
I'll withdraw that, Your Honor.
Okay, questions withdrawn.
Did you find that a large portion of the data from this cell phone from Ms. Schabusiness was stored on the cloud?
No,
Did you put that in your report?
I don't recall.
the, this picture when you were working as a police officer, you would see various images and photos on all kinds of people's phones, correct?
Correct.
People search.
How many images on her phone? How many searches on her
bizarre
phone?
things.
Simple fucking
Correct.
questions.
Correct.
And based on your
Mitigate the
training and
24
experience,
number, you dummy.
People look at things for shock value sometimes. Is that fair?
I don't know if I can answer that question. Maybe.
This photograph in Exhibit 102 is basically a close-up picture of Miss Schabusiness with a phone right by her, correct?
Correct.
You don't see any knives, you don't see any weapons, you don't see anything, correct?
Well, you see a picture of Jeffrey Dahmer on the phone.
But besides that, you don't see anything else, correct?
Correct.
And can you say that this photo was actually taken on Saturday, February 12th of 2022?
Yes.
These, did you see those other photographs of Jeffrey Dahmer and the other exhibits?
Yes.
Do you know when those photos were either downloaded or sent to the cloud?
I do not.
Okay, I have nothing further.
Redirect.
No, Your Honor.
Thank you. You can step down.
Why wouldn't you do this?
State's next witness.
Why wouldn't you just
Judge,
ask?
the next witness.
the
would be
basic
National
questions.
Victim, just for the media.
Okay.
So there are 24 photos or 24 searches, right? For Dahmer. How many were there total?
State
And
calls-
and I just want to clarify, the other media it needs to be notified too. It's not just live streaming, any other method of showing them anywhere is prohibited. Go ahead.
Thank you. The state calls Michael Theory.
There have been other women who've been obsessed with serial killers. Yeah. There's been everybody obsessed with serial killers. I was obsessed with serial killers for a long time. And despite the fact that there were 4 missing children in my neighborhood,
Michael B. Therian?
didn't have anything to do with me,
Okay. the
I
witness
think.
is yours, Mr. Saunders.
as far as you know.
Mr. Therian, how old are you?
60.
And do you live in the Green Bay area?
Yes, I do.
Did you have a son named Chad?
Yes.
And is he now passed?
Yes.
How old was Chad when he passed?
24,
Uh,
25.
Okay.
This is the victim's dad.
Mike, I want to ask you about Monday, February 21st.
Carrie girl, the 4 missing kids things was a joke.
2022.
It was a joke.
Do you remember the day I'm talking about?
There were no missing
Yes.
children in my neighborhood.
On that date, was Shad at your residence?
Yes, he was.
Was that a residence that is in Green Bay?
Yes.
And at some point, did Shad get picked up by his mother?
I believe somebody came and picked him up.
Okay. And then I guess that he left your home.
Yes.
Later in the evening, did Shad return?
Yes.
Was anyone with him?
Taylor.
And do you know who Taylor is?
Yes.
How do you know Taylor?
She's been at my place on.
And Levi, I'll hit your super chat in a second.
And I guess what was Taylor's relationship with Shad, to your knowledge?
They were friends from middle school and high school.
So there have been previous times. I'm sorry.
That was my understanding. They were friends from.
And you mentioned there were previous times she was at your home,
Yes.
and you've had the occasion to speak with her.
Yes.
About what time of night did Shad and Taylor get to your home?
Gonzo TW, there
9
is a
o'clock,
Rumble
9
stream.
p.m.
The Rumble stream is live right now.
Was anyone else with them?
Yes.
Do you know who that was?
AJ?
So the 3 of them arrived. Did you see how they arrived to your home?
No, I didn't.
How long were they there?
Short time, and then they left.
Short time. Are you able to approximate how long?
15 minutes, and then they left, and Shad and just Taylor came back.
So they came back for a little bit of time,
Yes,
and then did they leave again at some point?
yes, and they said they were going over to Terrace.
So when was that second time that Taylor and Shad came back?
It wasn't long after he left. I'm gonna say within 45 minutes.
During that second time that Taylor came to your home on February 21st, did you also have the chance to interact with her during that time period?
Small talk.
What was the nature of that small talk?
How to kill
they were
people.
they were looking for something, they were on some mission. I don't know. I was
Meth. They were looking
preoccupied
for
with other
meth.
things, and I don't even really remember what the small talk. Just asking.
Did you have the chance to kind of see Taylor's demeanor and how she was acting?
Yes.
Could you describe what you observed?
People don't stand up because the mics
Nothing
are
out of
down
the
at the
ordinary,
table.
just
So unless they need to
the
do
way she was,
something, if
she
they
was-
stand up,
wasn't
you won't
real
hear them and the
speaking
court
up,
won't
didn't
hear them
talk
as
a lot,
well.
But she was polite and respectful and always kind.
Was that sort of consistent with the prior occasions that you had contact with her?
Yes.
And then after they left, I guess that second time, did you see Shad again after that point?
No, I did not.
Thank you, Mike. I have nothing further.
Cross-examination, Mr. Freilich?
Mr. Therian, you live in Green Bay, correct?
Yes.
And your son, Shad Therian, was living with you in February of 2022?
Yes.
He stayed primarily with you, but sometimes he would go over to his mother's house on Stony Brook Lane. Is that fair?
That's correct.
Your son knew Taylor Schabusiness. They were friends, correct?
Yes.
They went to middle school together.
Yes.
They went to high school together at Bayport.
Yes.
On this particular date, Monday, February 21st of 2022, your son was at home
Yes.
initially, correct?
Yes.
Okay. And at some point, someone came to pick him up, correct?
Yes.
Do you know what time that was, sir? Like morning, afternoon?
I don't. I thought he left with Taylor and AJ.
And so they all three of them they left together?
Yes.
And then,
You know that AJ dude's the other guy on the
how long
dildo, right?
were they gone before they came back to your house?
Wasn't long. Half hour, 45 minutes, something like that.
Okay.
I don't know. It wasn't long enough. I don't really recall. It's been a while.
That's fair.
They did come back. Just Taylor and Shad.
Okay. When they came back, did they get something to eat? Did they watch TV? Do you remember?
No, they said they were going back. They said they were going by Tara's house.
They're not
And,
showing this
do you
witness
know
because
what
it's the
time
dad
they
of the
left your
victim.
house to go over there?
A judge must have some
I
order
wanna
on like
say
civilian witnesses
3, maybe not even that. I'm not sure.
or
Are you
something.
talking AM or
Family
PM?
witnesses for sensitivity, victim
And then at some
related.
point, is it your testimony that they came back again?
Yeah, that's when they left again. They left at they were there at 9, and then they left for a little while, and then they came back, and then they left over to Tara's, and it was just her, and Shad, and Taylor.
When you saw Taylor Schabusiness on either occasion, did you talk with her about anything?
Just small talk.
Did she appear to be acting odd or bizarre?
No,
How about Shad?
no.
Did you provide the methamphetamines they used?
You said they were on a mission, what do you mean by that?
I don't know. They just seemed like they were talking about, going somewhere or doing something, and I'm not really sure what was going on. I was preoccupied. And
Were you preoccupied searching for Jeffrey Dahmer's butt?
Okay, nothing further. Thank you.
Any redirect?
No, Your Honor. Thank you.
Okay, thank you. You can step down.
Levi the welder says, did you hear about the new butcher shop and barbecue pit called Halderson Schabusiness? They're pros at cutting meat and eating them as well. Also, Mr. Noseman, what's the deal with Nashville? Got hotel and plane booked. Nashville, I've got the event center booked. It is 3rd and Lindsley, September 16th in Nashville, which is a Saturday. 3rd and Lindsley is the venue. I will be live. Other creators will be there as well. We're going to have a party. We're going to drink. We'll do a live comedy
Return and
show.
Shall place you under oath.
It'll be a blast. I'm going to get the Eventbrite page up tonight. It was supposed to be up yesterday. Power went out. I was going to do it on my local stream, so, but we'll get it up today.
Kevin Kempf, Kevin, Kempf as in Frank.
Okay, Mr. Saunders, the witness is yours.
Wow, this is a law enforcement agent.
Can you tell us how you're employed?
I'm employed by the city of Green Bay as a member of the Green Bay Police Department.
Oh,
And do you have a
shocker.
current assignment with the Green Bay Police Department?
I'm currently assigned detectives,
How long have you been employed in law enforcement?
just over 27
What you
years.
should know is
And how long have you
based
been
on the
assigned specifically to the
entire
detective
roster
division?
of Green Bay police
Currently
we've
since
seen,
2017.
you could slowly outwalk any
Detective,
of
I
them.
want to ask you about February 23rd of 2022. Did you become involved in a investigation of the death of Shad Therian?
Yes.
And I guess generally, what was your involvement in the case?
My involvement in the case was to assist Detective Groff in an interview.
And who did you interview?
We would have interviewed Taylor Schabusiness.
And for the record, do you see the person you know to be Taylor Schabusiness in court today?
Yes, I do.
Could you point out where that person's sitting and what they're wearing?
She would be sitting to your left. She's wearing a black suit coat with a multicolored shirt.
I'd ask the record reflect the witness identify the defendant.
It will so reflect.
Prior to the interview of Ms. Schabusiness, did you have the occasion to view her physical appearance?
Yes, I did.
Did you note any potential cuts or injuries to her?
Yes, I noted a cut to her left thumb and some superficial cuts to her hands.
Brady, this
And is that
defense,
something that you subsequently documented?
this
in
defense
some way?
attorney's goal
Yes,
is
when I took photos
to
of
show
her,
that she was
I also
insane.
made sure I documented the cuts on her hands.
Rick Nikita, you know what method of transportation I'll be taking to Wisconsin or to Nashville. You know, you already know. I'm actually just going to give Taylor Schabusiness about 7 grams of meth, hop on her back with a saddle, and ride her all the way down. Killing and cleaving our way through every town on the path.
103 through 106. I'll ask if you recognize those exhibits.
Yes.
Actually,
And,
I'll be
what
in
do you
her
believe those to be?
golden van
These would
called
be
the
photographs that
Peganator.
I took of Ms. Schabusiness's hands.
And those appear to depict Ms. Business's hands as you observed them in the interview room on February 23rd.
Yes.
And when on February 23rd would this contact have occurred? When did you begin the interview?
I believe I took the photos at approximately 6 a.m. and I think the interview started at about 6:30 a.m.
By the way, Steel Leg of History, thank you for joining the channel.
Yes.
I'd move 103 through 107.
Any objection?
No.
103
Six.
through 107 will be removed.
Sorry, Judge, 106.
106.
And then I'd ask permission to publish as well.
Any objection, Mr. Freilich?
No.
You can publish 103 to 106.
Okay, and then it'll be in front of you, but also behind you, whatever's easiest here. So are we observing photograph 103 at this point?
Yes, you are.
Okay, and what does this depict?
This would be her left hand. There's a superficial cut in the palm below the thumb. And then you can see the cut on the thumb partially from a side view.
And then exhibit 104, is that what we're looking at now?
Yes, it would be. That would be her right hand and a superficial cut in the palm of her hand.
And then 105.
This would be the cut. on
Ooh,
her
that one
thumb,
looks fucking
her
painful.
left hand thumb.
Damn.
And then 106.
106 is kind of a superficial cut on the index finger of the left hand.
And then at some point during the interview, was Mr. Business transported for medical care with respect to the thumb?
Yes, when she requested medical care, she was transported to the hospital. Before that, she declined.
Okay. And did you accompany her during that visit?
Yes, I did.
And I guess, was there an attempt to have maybe the injury stitched up in some way?
Yes, we brought her up to get stitches or get medical treatment, whatever they felt was necessary.
And he said,
Was that
bitches
done
get stitches.
She did receive medical treatment, but they did not give stitches due to the time.
What do you mean by that?
Apparently it is, if it's outside the 8 or 12 hour frame, the stitches can't be put in. It doesn't work.
And you had contact
Wait,
with
really?
Mr. Business about 6 a.m., you said?
Yes, so that's about when I started taking the photos.
When you, I guess, first encountered Mission Business and were taking those photographs, what kind of clothing was she wearing?
At that point, she had like a black spaghetti strap top, I believe, on, and some black leggings, more tighter spandex, I guess.
And were her clothing
Did her
items
butt look good in those
subsequently,
spandex pants?
collected by law enforcement?
Yes, they did an initial collection of the outside clothing, and then I also had those items of clothing.
What's in the cookies? I'm looking high. That was an
And,
oatmeal
I guess
cream
was
pie,
a-
brother.
A
I also
female
have a-
officer involved in collecting the
Set of
inner clothing items?
methamphetamine
when the
Pop-Tarts.
clothing is collected, she's actually removed from the interview room to a room where it's not recorded, and a member of the same sex would be with them when the items are collected.
And was that done in this case?
Yes,
And then the clothing items that were, I guess, collected from Mission Business, were those subsequently entered into evidence?
yes, they would have been entered into evidence.
And that include the sweatpants or leggings or pants material that you talked about?
Yes.
After those photographs of Mission Business, did you participate in the interview of Mission Business?
Yes, I did.
And which other officer was with you?
Detective Groff.
During the course of the interview, did both of you sort of interject at some points and ask questions?
Yes,
No.
Have you
I hope they play this
had
interview.
a chance to review that February 23rd interview of Mission Business?
yes, I have.
Okay. And that appeared to be fairly and accurately and consistent with your interview, as you recall it, of the defendant?
Yes.
All right. Thank you. I have nothing further.
Cross-examination.
Thank you. Morning, Detective Kemp.
Morning.
So on February 23rd of 2022, you were contacted by the lieutenant at about 4:13 a.m. to come and assist. Is that true?
Yes, that'd be approximate time.
Were you told to go over to 829 Stony Brook Lane?
No, I was requested to come to the station, that we were all going to meet at the station at that point.
And from the station, then you went to the house?
No, when I initially arrived at the station, I was asked to assist in interviews.
Did you go to the home at all on that particular day?
It would have been later that day that I would have went to the home.
You went to the home after the interview was taken?
Yes.
Tell me when you got to the station, kind of like what occurred. What were the events that happened until you got into the interview room?
Basically, as I'm coming in, I called one of the supervisors to try to get a quick briefing, try to get some more additional information. When we arrive at the station, they give us a briefing of what is known at that time, and then job assignments are given out by our supervisors, and they ask us to do what needs to get done, and they start formulating a plan on how to go about the scene.
And what was your job assignment?
My job assignment was to assist in interviews.
Was it to assist Detective Ruff?
With Taylor Schabusiness, yes.
So when you got to the Green Bay Police Department or the station, was she there already?
She came in, I believe, about 5:30. She was brought into the interview room.
AM?
Yes.
And was there some things that had to be done before you started talking to her? Like taking pictures and things like that?
I believe patrol did snap some initial photographs, and like I indicated, I believe they took initially her outer clothing items.
Okay. And then she was put into a suit?
That would have been after I took my photos. I took additional photos.
Okay.
And then she was, when we collected the inner clothing, because we were taking all of her clothing, she was placed into some type of clothing that we had, which was basically a Tyvek suit at that time.
Okay. It was early in the morning. Did Taylor Schabusiness appear to be tired?
She appeared to be no more tired than I was. I mean, she was able to talk, able to speak to me, understand.
How about her eyes? Did they appear to be odd, like where she was having difficulty seeing?
I wouldn't say that she had a hard time seeing. It didn't seem like that.
She have any slurred speech?
Not that I noticed.
Only when she said,
When
I'll
she was
cut you up
talking,
and
was
eat
she
you,
making
Big
sense?
Daddy.
Yes, she was able to hold a conversation and answer questions.
This is not
It seemed
helping
to be
you, homie.
coherent about what was being said and asked.
Remember, you're trying to prove that she's crazy, man. What are you doing?
Was she calm?
Was she calm?
Yes.
Yes.
So then at some point, Detective Groff took some swabs, correct?
Yes, we would have swabbed her hands shortly after the photos were taken because there was some discoloration on her hands that appeared as it could be blood, so we decided to swab the hands.
And Mr. Saunders asked you about those exhibits 103 through 106. Ms. Schabusiness did have cuts on her hands, palms, and thumbs, correct?
Yes.
And the substance that was on her hands, you don't know where that came from, if it came from the cuts or something else, correct?
I do not know. No.
And then, so then you and Detective Groff proceeded with your interview of Ms. Schabusiness, is that fair?
Yes.
Then at some point, you took a break, correct?
There were several breaks taken during the interview.
But then there was a break where you had her go to St. Vincent's Hospital in Green Bay for some medical treatment of these cuts, correct?
Yes, I believe that was around 9:30 a.m. approximately. It was about 3 hours after the interview started, give or take a little bit.
So 3 hours later, approximately?
Yes, is when she asked for medical attention.
Did you accompany her to the hospital, or how did that work?
Yes, we had a MARC squad transport her up there. I rode up with her in the MARC squad, was in the room or just outside the room at points because I had to step out when they were changing her. And then when she was transported back, she was placed back in that MARC squad, and I rode back in that MARC squad with her.
Was Detective Groff with you when you went over to the St. Vincent's Hospital?
No,
You took her by yourself?
no, it would have been myself and another officer.
Okay. What time did you arrive back at the Green Bay Police Department?
I believe it was about an hour or 70 minutes later, off the top of my head.
Maybe around 10:30 or so?
10:30, 10:40.
And then you proceeded with further interview?
There was additional interview done.
I just want to watch the interview. That's what I want to do.
Okay, I have nothing further. Thank you.
Redirect?
No, thank you.
Okay, thank you, Detective. You can step down. State's next witness.
State calls Detective Groff.
Forward. Clerk will swear you.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter, now before the court, so help you God.
I do.
Please have a seat and state your name for the record.
David Groff, Graf.
It's like if Glenn Beck had an alternate
Detective
future.
Groff, how are you employed?
I'm a detective with the Green Bay Police Department.
And how long have you worked with the Green Bay Police Department?
I've been with Green Bay for 27 years.
Do you have law enforcement experience prior to the Green Bay Police Department?
I do. I have 30 years of total law enforcement experience.
And what is your current role with the Green Bay Police Department?
I'm an investigator detective in the investigative division.
And how long have you been a detective with the Green Bay Police Department?
17 years.
And what were some of your other job duties with the Green Bay Police Department prior to working with the detective division?
I was a patrol officer for approximately 14 years. As part of my 17 years in the investigative division, I was also a narcotics investigator with the Brown County Task Force for 2 years. And since then, since coming back in 2010, I've been a detective.
Were you working as a detective with the Green Bay Police Department on February 23rd of 2022?
Yes,
Were you called in to investigate a suspected homicide of Shad Therian?
correct.
And what was your role in that investigation at the outset?
My initial roles was to arrive at the police department and received a briefing of what was going on. And I was informed that some family members of Mr. Therian were at the police department. I was asked to interview Tara Pakinich.
And did you conduct that interview?
I did.
What was the purpose of having that interview?
Get some basic information as to observations that she had made when she had last had contact with her son, who was on the residence, and basic information.
And once you completed your discussion with Tara, then what did you do?
I was then informed that Taylor Schabusiness was now present at the police department. I was asked to interview her.
And that interview, was that on the morning of February 23rd of 2022?
Correct.
Is that an interview that was conducted in a recorded interview room at the Green Bay Police Department?
Yes, it was.
Did the recording devices work? Is everything operating well?
They did.
Subsequently, have you had an opportunity to review the recorded interview of Taylor Schabusiness that occurred at the police department on February 23rd of 2022?
I have.
And do you believe that the recording of that interview accurately reflects your conversation with Ms. Schabusiness on that date?
It does.
And who was present during the interview with you?
Detective Kevin Kemp.
Was Ms. Schabusiness Mirandized prior to the substantive portions of the interview?
Yes.
Yes.
Prior to moving into substantive questions with Ms. Schabusiness, did you make any physical observations of her?
Yes, I observed that she was wearing a tank top and some sweatpants that had dark colored, dark rubbed substances on her, on the clothing that I was told by patrol that they thought could be human blood, as well as some minor staining on her hands.
And what did you do prior to interviewing her with respect to the clothing items and the staining on the hands?
I had the clothing items collected by a female officer, Officer Whitman, with the Green Bay Police Department. And I also took what we call buckle standard from Ms. Schabusiness using a buckle standard kit. And then I also took swabs of both her left hand and her right hand.
Could you describe the process that you used in collecting the buckle swab?
Yes, we have a kit that we use that contains 2 sterile swabs and some packaging material. So the kit is open. The swabs are used on one swab on one side of the cheek, one swab on the other side of the inside of the cheek, because that's where the buccal cells are located. Then the swabs are both placed into the packaging, labeled and sealed.
And is that something that you have done routinely in the past through your work as a detective at the Green Bay Police Department?
Yes.
Did you follow your training and the department protocols with respect to the collection of that buccal swab?
Yes.
And can you describe for the jury what you did in terms of swabbing Ms. Schabusiness's hands?
Yes, I used, again, sterile swabs and basically 2 swabs. One, I would put some distilled water onto the swab, swab the hand, and then the second swab would be a dry swab, and then I would swab the hand. Place those both into packaging, sealed them, and then I would do the same for the second hand.
When you say you swab the hand, what portions of the hand are you swabbing?
I swab the entire portion, the palm, the top of the hand, and such.
And with respect to the buccal swab and the swabs of the hands, what did you do with those after you had completed them and packaged them and signed them?
They were placed into the evidence department at the Green Bay Police Department.
Is that something you yourself did?
Yes,
And did you maintain custody and control those items until they were placed in evidence?
I did.
We'll return to the specifics of the interview in a moment, but I want to move on.
Yes,
After
please
you
play the interview.
interviewed Ms. Schabusiness, well, about how long was the interview with Ms. Schabusiness on that date?
Well, it was over a period of time. There were several breaks. Let's see, maybe over a period of time of 6 hours or so.
And after you conducted your interview with Ms. Schabusiness, what did you do?
At one point, I did go to the scene briefly and just provided some information at the scene. I believe I also talked again with Ms. Pakinich because I had some follow-up questions that came up during that interview with Taylor Schabusiness concerning if Ms. Pakinich had in fact came down into the department or into the basement during a time period that Shad and Taylor would have been down there.
And I should also ask, while you're interviewing Ms. Schabusiness, are you remaining in communication with other investigators that are working on the case?
Yes.
And after the interview with Ms. Schabusiness, did you continue to stay in contact with other investigators about different aspects of the case?
Yes.
Subsequent to the February 23rd interview with Ms. Schabusiness, did you meet with her again for a second interview?
Yes.
And when did that take place?
February 28th, I believe.
And where was that interview?
That was also at the Green Bay Police Department in an interview room there.
Is that an interview that was also recorded?
Yes.
Was Ms. Schabusiness read her Miranda rights prior to that interview as well?
Yes,
And did she agree to speak with you on the 28th?
she did.
And who was present with you for that interview?
Detective Phil Scanlon?
Have you since had the opportunity to review the audio video recording of the February 28th interview with Ms. Schabusiness?
I have.
Does that recording accurately set forth what you recall from the interview itself?
Yes.
Is the quality of the audio the same in that one as it is in the 23rd?
No, it's not. The quality of the audio in the second interview was a little less than it was a little harder to hear.
Is there a reason for that?
The microphone in that particular room was not as sensitive as at other rooms.
Why didn't you use the ones in the other rooms?
And again, we'll get into the specifics of that interview, but I want to move into subsequent aspects of the investigation prior to doing that. At some point in time after the interview, did you assist in this investigation in other ways?
Yes.
What was the next thing that you recall doing after meeting with Ms. Schabusiness on the 28th?
Several things that I did was, one of the things that I did was I reviewed the evidence that was taken throughout the course of the investigation and chose several items that I wanted to send to the Wisconsin State Crime Lab for further analysis.
Is that generally how the process works with your department and the state crime lab? Is it the detectives select the items that will be sent to the state crime lab?
Yes.
And when you're deciding to send items to the state crime lab, are you aware of submission guidelines that the crime lab has?
I am.
What generally are the submission guidelines with respect to serious crimes such as this?
In these types of crimes, they ask that the first submission of evidence be limited to 10 items.
And did you send 10 items to the lab in this instance?
I did.
And when you were trying to select which items to send to the lab, what considerations did you have?
I took several considerations. There was quite a bit of evidence taken in this case. However, I was aware that there was at least 2 different scenes where evidence was collected, one being on Stony Brook Lane, the other being at Eastman Avenue, in which I had been information that Taylor and Shad had been at both residences. Also, I was aware that, several knives had been found in the basement on Stony Brook Lake that were covered in what appeared to be human matter. And my concern was that was Shad's blood and tissue. So I wanted to confirm that. So I took the one knife that I chose was the bread knife, so to speak, that she had used mainly to dismember the body, according to Ms. Schabusiness. And that had been found in, I believe, the Jimmy Choo bag in the basement. So I chose that knife as particular for testing. There were several other knives located in the same areas, but I just decided to take the one knife. I also decided to send swabs that I'd taken from her hands to see if that was, in fact, DNA from Shad on her hands. I know hers blood.
Adam says,
I also chose the swabbing from what was a rest substance in the apartment and the bedroom of Taylor Schabusiness' apartment. A, to determine what that substance was, if it was blood, and also determine if it, in fact, it belonged to Taylor or Shad, so he could be linked again to that particular residence.
And then do you recall the other items that you sent to the lab in this case?
The other items that I had sent also was the swab, the oral swab that was taken from Shad from the autopsy. And I had the penile swab that was taken during autopsy from Shad. And I also asked one of my forensic evidence techs.
did the swab
to swab
determine if the penis
dildo.
was attached?
And so I had the dildo swab, and I sent that also to determine again if any of their individuals whose DNA was on any of those items.
And how about any of the clothing items that were taken from Ms. Schabusiness? Did you send those to the lab?
Yes, I believe the sweatpants were specifically sent in.
And did you also send the known control buckle sample from Taylor to the lab?
Yes.
In addition to making the decisions regarding what evidence would be sent to the lab, did you participate in any search warrants in this case?
I did. 4 separate cell phones had been located during the course of the investigation, 2, I believe, at the Stony Brook in the basement, and 2 in the bedroom on Eastman Avenue. So I wrote a search warrant requesting that all 4 cell phones data be extracted.
And did you have opportunity to review the extraction from any of the cell phone devices that were seized and searched with a search warrant?
I did.
Specifically, there's been some discussion already about Ms. Schabusiness's primary phone. Did you have an opportunity to review the Cellbrite extraction from Ms. Schabusiness's device?
Yes.
And is that something that you have done regularly in the course of your duties as an investigator with the Green Bay Police Department?
I have.
You're familiar with the Cellbrite program, how it works, and how to navigate it?
Yes.
In
Yes.
particular, when you were searching
I
Ms.
am.
Schabusiness's device, what types of information were you interested in?
What was the type of data that was being accessed or used, or photos that were taken during the time period up until the date of the homicide? And you could do what they call a timeline report, and basically we'll put in chronological order every single time the phone is accessed or a photo is taken or there's a phone call, there's a text message. So I looked at that timeline into the days preceding the homicide. And it also records anytime a phone will connect to a Wi-Fi network. It can specifically state what Wi-Fi network that phone had accessed. And I found that to be interesting in this case.
And what was important about that Wi-Fi access? We'll touch on that first. What's your purpose in knowing where the Wi-Fi connectivity exists here?
It helps put a location as to where exactly that phone was during a specific period of time.
Now, when you say Wi-Fi connectivity, can you explain a little bit for the jury about how that process works, where the device connects to the Wi-Fi?
Well, everybody has a Wi-Fi. I should say mostly everybody has Wi-Fi at home, and everybody has a router, and that router has a specific title to it.
Has a
And it could
router.
be a self-made name, or it could be a name that is provided by the manufacturer.
My
And so
router's
then,
name is, this
You know,
is
when
where I
you
look
your
at
phone, you
men's
want to
butts
connect to
on my
somebody's
computer
Wi-Fi, you
screen.
ask them, what's your Wi-Fi name? And they'll say it's, Graph Family, whatever. And then you were able to connect to that. And so
My Wi-Fi name is
in
Fat
looking at
Glenn
that, I
Beck,
was
and
able
he's
to
already
determine
fat.
that over the course of several days, there was 2 specific Wi-Fi routers that phone had been accessing.
During the course of the investigation, were you able to obtain the name of the Wi-Fi router for the Eastman Avenue address where Ms. Schabusiness resided with Mr. Tomes?
Yes, I had personal contact with the owner of the occupants, Mr. Tomes, and he had forwarded me that he had used AT&T as his service provider and provided me with the Wi-Fi name.
And similarly, were you able to get the Wi-Fi name for the Stony Brook residence as well?
Yes, I talked to Ms. Pakinich, and again, I was informed that the Spectrum was their internet service provider and provided me with their name also.
And then were you able to look at the extraction from Ms. Schabusiness's device and create a timeline for when that particular device was utilizing the respective Wi-Fi networks that you discussed?
That is correct.
Adam says this guy looks like Dave Landau playing Robert Downey Jr.'s character from Oppenheimer. Squizgar says, Nick, if you considered a whole home generator UPS system, you could probably write it off as a business expense. Well, I could, but we lose power almost never. Last night was very strange. I mean, we might lose power once a year.
This is an extraction report that I completed from the data found in Taylor Schabusiness's cell phone.
And what specifically is addressed in that particular extraction report?
In this particular one, it is a
Once a year would be
timeline in
considered a
terms of
lot in
network
Europe.
usages.
Well, yeah,
in
but have you
terms of
considered
what
that being in Europe
Wi-Fi,
makes you gay?
the phone was accessing, and it provides dates and times.
And using that report, are you able to then determine at what times the device is utilizing which of the routers?
Yes.
And what is the significance, or what did you glean from that report then with respect to the dates and times?
Well, I know that on February 22nd, 2022, starting at 12 a.m., it was utilizing the Wi-Fi from the Eastman Avenue address. And there's several entries over the course of time from midnight all the way up until.
Yeah, that means Bronca's gay, guys. And look, I don't make the rules.
4 a.m. and it utilized the router of ATT5 FTC 9D E800, which I had confirmed was the same name of the router from Mr. Thalm's apartment on Eastman Avenue.
At some point in time in the early morning hours of February 22nd of 22, does the phone connect then to a different Wi-Fi router?
Yes, starting at approximately 6 a.m. on February 22nd, 2022, all the way through
Yeah, in Minnesota, especially in this
10
area,
a.m.
most of our
oh no, I'm sorry. Yes,
most
well,
of our
10 a.m.
power lines are
approximately.
below ground. So like wind and storms don't normally
It
knock
was
out
the,
power. When
My
I lived in the
Spectrum
south,
Wi-Fi, which then again
you have
I
a lot of
confirmed
above
that
ground
was
power
the
lines.
Wi-Fi router at the
especially in
Stony Brook
Houston,
Lane
close to the ocean, high water
Now,
table.
did those,
So those would get
in
knocked
order
down all the
to have
time.
the phone connect to the particular Wi-Fi device, does that mean that the user necessarily has to be utilizing the device to do something specific?
I don't believe so, no.
There are certain programs that simply run in the background that are searching for, trying to connect to the Wi-Fi.
Yes.
And that doesn't necessarily give you a specific time frame, but does give you general timeframes for where Ms. Schabusiness might have been at, Ms. Schabusiness's device might have been at certain points in time.
Yeah, that would say that one is accurate. It's not specific, but it does give you general timelines, yes.
I think you mentioned earlier you were also looking for photographs in the timeline right around the time of the homicide. Is that correct?
That is correct.
Were you able to note any photographs that were relevant to your investigation in this timeline?
Yeah, I noticed that on February 22nd, 2022, approximately 12:56, 12:57 a.m., several photos had been taken of Shad Therian.
And those photos were present on Ms. Schabusiness's device, is that correct?
That is correct.
And they have very specific date and timestamps?
Yes.
Brady, welcome to Paralegal. Thank you for joining the channel. Play the fucking interview. Let's just watch it. It'll be awesome. People are always the most honest right after they murder and eat someone.
Showing you what's been our business. You identify 108 for me?
Your Honor, I'll object to 108, 109. They're similar, but some of the photos on one of the exhibits are more like thumbnail, and then the other one is the larger one. But we already have pictures of the alleged victim, so I would argue duplicity.
Okay, let me see the photos. So your argument is duplicity?
Yes.
Oh,
Taking a look at 108, 109, they're different. Certainly there's thumbnails on 108, which are smaller. Those photos, actually each one of them are different slightly. And there's some other data on 108. So I'm satisfied that I'm going to overrule the objection and you can proceed.
And what is Exhibit 108 again, Detective?
108 is another extraction report documenting 5 photos that I had found in Taylor Schabusiness's cell phone.
And what's depicted in those photographs?
All photographs are of the head of Shad Therian.
You say you had, these are in-life photos of him, is that correct?
I'm sorry?
These are photos of him while he is still alive, correct?
That is correct.
oh my God.
And 109 depicts what?
109 is a full photo of one of those particular photographs described.
And again, what is the date and time of the photographs in Exhibit 108?
Did she draw like a decapitating line or something?
February 22nd, 2022, one at 12:56 a.m., another at 12:56.
It's not weird to have photos of someone's like face. Okay, that's not weird. It's weird if there's like
another at
lines or like cut here or whatever.
And the 5th at 12:57 and 18 seconds a.m.
Have you, as part of your investigation in this case, had an opportunity to review photographs of the two residences, the Eastman residence and the residence on Stony Brook.
Yes.
Based on your review of those photographs and then the review of Exhibit 109, are you able to ascertain where that photograph was taken?
The photographs just described, the background is the same as the bedroom on Eastman Avenue.
Is that also consistent with the timeline that you noted from the Wi-Fi usage?
Correct.
That the phone would have been utilizing that device around that time?
Yes.
I would ask for permission to publish 109, Your Honor.
Okay, you can publish 109.
Is the screen now depicting Exhibit 109?
Yes, it is.
Oh, look at that.
Thank you.
Damn, that's evidence. Why is that evidence? Someone tell me what about that makes any fact more likely to be true.
Detective, I now want to
They're
return
not.
to the interview and specific conversations about what Ms. Schabusiness told you on February 23rd of 2022. First of all, can you start by describing, what her general demeanor was when you met with her on the 23rd?
Well, characteristic as a calm demeanor, no outbursts, no mood swings. She was quite frank in being able to answer questions and ask questions.
What was your ability to communicate with her?
Very good. She
Yeah.
was able to answer my questions and with no issues.
You indicated that you had previous work as a narcotics investigator. Have you had an opportunity in the past to meet with and interview suspects who are under the influence of drugs?
Yes.
Did you note anything in Ms. Schabusiness's behavior, demeanor, or appearance that would have suggested that she was under the influence of narcotics at the time you were meeting with her on the 23rd?
I did not.
Hey guys, look, it's my head in a picture.
Can you
You're all
describe,
murderers now.
going into that interview, how much information you had about the specific acts themselves?
At the particular time, I had very little information. What I knew was that Shad's head had been found in a bucket in the basement, and also
Remember
just
the
information
framing
that
of
I
the
had from
question.
talking to
It was a
his
picture
mother
of his
about,
head.
who was he last seen with, and
It actually was his head and
known
shoulders
whereabouts the crime
and neck.
occurred.
In terms of the specifics of what happened to Shad and where the
But
rest of his body was,
It's
is that
framed to
information
imply
that you
that
knew
picture
prior
meant
to
she was
beginning
going
the
to
interview with Ms.
head on.
Schabusiness?
No,
because the
The
government
information
is
about
fucking
Shad and what
retarded.
happened to him and where his body was, where did that information come from?
it's your business.
And to begin your interview, how did you begin asking her about the specific events?
I basically stated to her that with the information that I had, and the information that I had at that point in time was that Shad's head had been found in a bucket in the basement, and that she had one point had been with Shad. So I just asked her if she could tell me what happened.
And was she able to describe to you what happened?
Yes.
What did she say with respect to how Shad was killed?
How Shad was killed?
Correct.
She said that Shad had produced a chain, like a dog collar. He put it around his neck. Initially, it sounded like it might have been some sort of foreplay, but it got to the point that she started to strangle Mr. Therian and just continued to do so, according to her, for several minutes until he passed away.
Did she, as it relates to the strangulation, did she make any statements about her observations of Shad as she was choking him with that chain?
Yes, she stated that his head turned purple. He started to, I believe, blood coming out of his mouth.
What's a little
His
mouth blood?
tongue was protruded, I believe.
Whose is it?
Did you ask her whether she chose to stop at that juncture?
I did.
And what was her response?
She stated that she wanted to continue to see what happened.
And
And,
did you ask her whether or not Chad had struggled at all when she was choking him?
She said that he did.
And what was her response to that?
My understanding is that Chad had been laying on the bed, prone, face down, and she was on top of him.
why was that?
And so she was able to
Go on.
choke and control his body, so to speak, that even though he was struggling, she was able to still maintain control.
What else was she doing at the time?
Did you ask her about how she
What else
felt
was she
about
doing at
what
the
she had
time?
done?
Yes.
And what were her responses?
Objection relevance, yes, to elements, Your Honor.
I think they're certainly relevant as to her intent.
Overruled.
Her response was that she liked it.
Had she also at some point expressed some remorse or that she didn't necessarily want this to happen?
Initially, that was some of her comments, was that, it hadn't intended, but once she started to strangle Chad, that she found that she did enjoy it, and so she kept on strangling him.
Had she expressed anything to you about her use of drugs at the time of the offense or immediately prior to the time of the offense?
She said that approximately 2 days prior to the offense, that she and Chad had been smoking methamphetamine.
2 days prior to the offense or 2 days prior to the interview?
I'm sorry, 2 days prior to the interview.
Did she mention anything to you specifically about drugs or paraphernalia that might be found in the residence?
Yes, she stated that there should be a pipe and some methamphetamine in the basement on a dresser or an entertainment center of some sort.
Did she express any knowledge about the location of the chain or chains that were used to strangle Chad?
Yes, she stated that there was 2 chains. One would be the same location area as where the methamphetamine was used, and another would be in another table in the basement.
And now I think I asked this earlier, but you're in communication with the investigators who are on scene during the course of this interview. Is that correct?
Correct.
And the information that Ms. Schabusiness is providing you about where things are located and what they might see in the basement, is that being confirmed by investigators on scene?
It is.
And the information that she's providing you, is that accurate with what they're observing?
Yes.
After the strangulation
They're
itself,
kicking the
what did
shit
Ms.
out of her insanity
Schabusiness
defense, by
tell
the
you
way.
that she did with Chad?
Well, initially, we were aware of Chad's head being in a bucket, but we were not aware of where the rest of his body had been located. So there were several questions pertaining to where his body was located. And Ms. Schabusiness' response to that it was still in the basement. Then she later went on to explain that she in fact had dismembered Chad's body and placed the various body parts into several bags and or a tote down in the basement.
Was she able to describe in detail the things that she did to dismember Chad?
Yes.
And again, are you matching that back up with information from investigators at the scene?
Correct.
Was she able to actually describe the types of bags or types of containers where she's placing body parts?
Yes.
And again, is that consistent with what investigators are later finding on the scene?
Yes.
Did she talk to you about how she dismembered or what she used to dismember Chad's body?
Yes, she stated that she used knives that she obtained from the kitchen of the residence.
Was she able to describe to you where those knives would be located in the basement?
Yes, she described that the knives would be in the same package or the bags that the body parts were also located.
And again, is that consistent with what investigators were finding on scene?
Yes.
In addition to the dismemberment, did Ms. Schabusiness discuss with you anything else that she did with Chad's body after she had killed him?
Yes, she did.
And what was that?
She described how she had sexual contact with the body in terms of playing with his penis. Also, she described that she had a dildo
All right,
that
tell me
she
more.
placed into Shad's mouth and to his anus, and that she also had cuddled the body.
Oh, well, that
Did
was
she
nice.
discuss performing oral sex on Shad?
That's correct.
You got to cuddle for a little bit. I mean, it's just polite at that point.
Did she indicate about how long she had cuddled or played with Shad's body?
She indicated that, it was, I don't exactly recall how long of a period of time, but there was a period of time, I believe shortly before or after the start of dismemberment.
Did she talk to you at all
How
about
long? That wasn't a how long.
trying to clean up the scene or what she was doing with the blood during the course of the dismemberment?
Yes, I've been made aware that there was not a significant portion of blood found in the basement that would have been consistent with dismemberment. So I asked her about that, and her response was that she mainly used like the bucket and or the blue tote to capture a lot of the blood, and eventually to dispose of some of that into the shower in the basement. She also did talk about the dismemberment and the removal of body parts, and in fact that there should still be a portion of Shad's lower limbs like legs in the van that she had been operating. So she did describe how she did remove at least a couple of his body parts during the course of dismemberment. And when I say move, I mean out of the residence itself.
And did she specifically give you a reason for why she ultimately left the residence on that day?
She told me that she had heard lots of walking around upstairs, and she also heard that she thought she had heard some shots being fired in the area. In this call, there's some concern, and she just decided that she had needed to leave at that point.
Did she discuss with you what her intention was with respect to Shad's head?
One of the first things that she did say was that she did like the head, and that it was her intent to take the head as well as the genitalia that was in the bucket with her. That's why she specifically placed those
Two
items
favorite
in
parts of the
bucket.
body. Yeah.
But
I
she
mean,
did mention
obviously.
that she had left the bucket by the stairs. And I don't know if she intentionally wanted to do that, but there was talk that it was her intent to take the head and the genitalia with her also.
I mean, it seems like a waste to leave him there.
At some point in time, do you discuss with Ms. Schabusiness a specific timeline for the events leading up to that evening?
Yes.
And what does she tell you about the timeline of her whereabouts leading up to this event?
2 days before the 21st, that Monday, is when she was at the apartment on Eastman Avenue with her friend AJ. They decided to go pick up Shad, which they did do. They were returned back to the apartment. At one point, they also did visit Shad's father, Michael Therian, and then also again returned to the apartment at Eastman Avenue, where they stayed there for a while. At one point, AJ left, and then Shad and Taylor then returned to Shad's mother's residence on Stony Brook Lane.
And the information that she's providing you with respect to the timeline, is that information that also was consistent with the other aspects of your investigation?
Correct.
Had she mentioned to you while you're discussing the timeline use of narcotics or controlled substances?
While they were in the apartment on Eastman Avenue, they did use her and Shad smoked methamphetamine, And she also indicated that Shad and AJ smoked marijuana.
Had she talked to you about what vehicles she was using to travel around to these locations?
Yes, the entire time she was using her roommate, Mr. Dahm's gold Chrysler minivan.
Did you ask her whether Mr. Thomas had given her permission to use the vehicle?
I don't know if I asked her specifically that question, no. But it was under impression that she was using it. At the time of the interview, I was not sure. I later found out that Mr. Thomas claimed that she has used it in the past, but not necessarily was supposed to use it that night.
Did she tell you any information about whether Mr. Thomas was involved in this crime at all?
He was just at the apartment the entire time, sitting in a chair basically. And according to her, he wasn't even aware of what they were doing because he was behind him or in the bedroom.
When you were speaking with Ms. Schabusiness, did you ask her about whether or not anyone else had come down into the basement at any point in time?
Yes.
And what did she say?
That's when she stated that she believed that Shad's mother had come down with a cat.
And did she discuss actually having any interaction with Shad's mother at that time?
She said that she did not, and I asked Taylor if she thought that the mother had seen her, and she stated that she did not believe. So asked her what she did, and Taylor just stated basically that she kept quiet and was off in the like the finished part of the basement.
The mom came down during all this? It's amazing. Oh, what are you?
So I want to draw your attention then to the second interview with Ms. Schabusiness that occurred on February 28th. Is that right?
Correct.
And that was also a recorded interview?
Yes, it was.
And you advised her of her Miranda rights prior to that interview?
I did.
And she waived those rights and agreed to answer questions?
Yes, she did.
Did you make observations of her demeanor generally on that day?
I would classify it as being the same, calm, was able to answer questions appropriately.
64-bit goodness, you
signs
bastard.
of any disruptions or mood swings.
And was she able to understand your questions and answer them appropriately?
She
Yes.
actually calls for speculation, Your Honor. Overruled. Leading? Argument for leading? Argument for leading, alternative argument, Your Honor.
Overruled. Go ahead, ask another question, Mr. Levay.
Thank you.
I'll
And
sing
what
it.
was
Don't
generally
worry,
the
I'll sing
purpose
it.
of conducting that second interview with Ms. Schabusiness?
We use Blink
Conduct
voice
some
too.
follow-up questions concerning that we had that came up during the course of the investigation concerning like her disposition of the body, what were intentions of what they're doing with the body, and her cleaning up after herself.
And what did she say with respect to the purpose of dismemberment and then the cleanup?
According to Ms. Business, the purpose was that she realized she needed to remove the body from the residence so that she wouldn't be caught. And she, Shad was more that she could carry just in terms of being a whole body. So the dismemberment and putting them into bags was to facilitate with her being able to remove the body from the residence.
And did you
Clearly,
discuss with
she's a
her the
victim of big
attempts to
GMO
clean up the residence as
marijuana
well?
caused by government
Yes, and Detective
intervention in a
Scanlon
food.
had been integral
Taylor
part
Business
of
is a
the
victim
search
of
of
big
the
pharma.
residence itself. So he asked her several questions about cleaning up because he had observed some, markings or on the cement down area that had been underneath the bed, as well as there was a squeegee in the shower down in the basement, in some items such as Clorox, wipes. And so he asked her about that, and she stated that, yes, she did use the cleaning materials such as the Clorox wipes and the spray to clean up several of the areas of
It's
in
only
the
polite
basement,
to
as
clean
well
up after the
as
mess.
using squeegee to clean up the shower area, and subsequently placed these wipes in the same bags that the body parts was found, which again is consistent with what Detective Scanlon had found.
And Detective, I think I asked you these questions already, but if you had an opportunity subsequent to the interviews to review the recorded interview from both the 23rd and the 28th of February,
Correct.
and you do believe that the recordings were accurate and consistent with your recollection of the interviews?
They are.
Your Honor, at this point, I intend to show significant portions of the first interview and a
Yes.
smaller portion of the second interview, but it's about an hour and
Yes.
10 minutes in length for the first interview and about 4 minutes for the second. So I think now would be a good time to take a break.
Okay, ladies and gentlemen, we started a little bit late, but.
Who runs the
nonetheless,
courtroom,
we're now
Judge?
watching
You are the
video, so
prosecutor.
I think what we'll do is take a break until
You
10:20.
would take a
It's now
break,
about
you Billy
10
bitch.
after 10. And with that, all rise for the jury.
Yeah, once the court is
Anything to bring up before we break, Mr. Saunders?
No.
Mr. Fraley?
No.
I'm assuming there's been, you referenced it earlier, a stipulation as to what pieces of this video you're going to show.
State's understanding, the specific times were provided, a copy of the excise video was provided
Judge,
to the defense.
peace is the appropriate word here.
Your Honor,
I mean,
that's
it's very
correct. We
insensitive.
Talked about this issue, so.
Okay, very good. We'll take a break until 10:20.
Thank you.
So what's going on, chat? Hope you're enjoying the trial of Taylor Schabusiness. For those of you who maybe don't know, we're on day 3 of this trial. She is accused, if you're just joining, if you're joining late, she is accused of, and she did it. She is accused of strangling via chain her boyfriend, her backdoor lover, Shad Therian, during some sort of sexual encounter. They've not been very specific about it. What we know is that she was on top of him as he's laying face down in a prone position, so she could yank on the chain as used to cut off circulation to his neck. Now, allegedly, there is a dildo involved that was penetrative of Shad Therian's anus at some point. They've only ever specifically mentioned a post-mortem penetration of the corpse, but I have a theory. Like Martin Luther King did. I have a dream. One day in February, white dildos and white booties met while the blood and essence of life still pumped through that body. I think she was pegging him. I think that's what was going on. I think it was an asphyxiation during anal stimulation. I think that's what had happened. I don't know this, but that's my guess. That's my guess, honestly. Some people are into weird stuff. Some people are into weird stuff. But like, now I know some people are just into restraint and asphyxiation without like the intercourse aspect of it. Maybe that's the case. I don't know what people get down to specifically. I have general ideas about what's on the menu for people, but actually, what they want, I don't know. I don't know what they're doing. But I just think that that was probably what was going on. That's just my idea. That's just what I think was happening. But I don't know. Okay, we can get rid of this. Go. Fuck off. That's my theory on what was happening. And they've never specifically stated that though. So during this alleged sexual encounter, she chokes him. She likes it. She sees his face turning purple, a little bit of blood coming out of the mouth, a little bit of tongue coming out. And really, if you're not going that hard, why are you even trying? And then he expires. He just dies, which, I mean, you want to talk about a boring partner. I just quit. You just quit. I mean, very inconsiderate. Was he even thinking about her at that point? I don't think so. So he dies. And then she allegedly plays with the corpse for a little while. Like maybe a little like, maybe she just didn't know how to give mouth to mouth. So she like puts the penis of the corpse in her mouth for a little bit, apparently. Maybe she's just trying to like, you know, breathe life back into him. I'm not sure. She allegedly inserts the dildo into various orifices of the corpse, cuddles it for a while, and then begins the process of dismembering it using kitchen knives that she's retrieving from the kitchen, eventually settling on the most effective one that she could find was a bread knife. Now, the bread knife was probably becoming less effective over time as bread knives have a nice serrated edge, but it's not a serrated edge that is meant for sawing through hard things. It's meant for the serrations on bread knives are very specific. I don't know what you guys know. A serrated knife is actually a tearing motion, right? That's the purpose of serration, is to actually tear through meat. They don't need to be sharpened as often because the object is to tear through typically a cross section of muscle. You go cross grain and the serrations catch on the grains and they just start pulling the meat apart. Whereas a sharp knife is serrated, but in a weird way, but microscopic serrations, very, very small. And all of those tear at a much cleaner and smaller angle. But you need to maintain that edge because those little serrations get bent out of place because they're so tiny, or they can get broken off and you have to reapply the edge to the knife. Now, serrations in general, same thing with like on a saw blade or whatever, are made kind of specific to the purpose that they're doing. Serrations on a saw blade are thicker and more durable because they're going through either wood or metal or whatever. But the distance between the teeth on a serrated edge, there's like a math formula I don't remember, but is directly related to sort of the diameter of the object that you're cutting, or the surface area that the teeth will be coming into contact with. If it's a very small thing that is also very hard, like a metal pipe, right? You're going to have a small surface area at the top that you're making contact with. And it's also a very strong material. You need to have smaller, very frequent serrations made of very strong material to actually grab and start pulling through the metal. If it's wood, wood is much softer than your metal saw blade, much easier. And also the diameter of wood can be larger and the serrations can be more appropriately spaced out. Plus you got the hollowness versus solid things. Anyway, this is all too much info. Bread knives have serrations that are made to grab into bread, a very malleable, easily tearable, substance. When they hit bone, not made to cut through bone. The knife comes to a point. They can be pretty sharp. They can be pretty brittle because you're not chopping with them and you're not cutting through hard things with a bread knife. So as she gets to the bone, starts sawing, that wears down. And so by the time she's done, there's not much left of the serration from what we can gather. But she does chop off the head. She chops off parts of the legs. She chops off the penis and the balls. And then she goes ahead and proceeds to take the legs in a box in her van. She was going to take the head penis, the head cock and balls in the bucket, but she left those probably because she was on meth and wasn't really thinking about it. So this is what is going on in this case. Very, very, very disturbing case. Oh, and you would think this would be a super bloody scene. It's only kind of partially bloody because she was pretty careful to collect the blood as she decapitated the body and try to clean up most of it by putting it in the shower. Because, it's your boyfriend's mom's house. You don't want to like leave a mess or whatever. Kind of rude. You're probably not going to be invited back if you do that. So she does that as well. So it was kind of, it took a little bit for this to be discovered. And she was, she's apprehended at her own place later, or I think her own apartment, where the van she was driving around was located. The legs were found in the box of the van. Everything else found at the scene of the crime. So that's the criminal accusation of Taylor Schabusiness. She's got, first degree murder, first degree intentional homicide. She's got, I think, 2 counts of dismemberment and mutilation of a body, and then 1 count of sexual assault. Now, in Wisconsin, you can be charged with sexual assault of a dead person. But I think that's kind of weird. But that is allowable under the statute. Well, the statute says the sexual assault, it doesn't matter if they're living or dead. But I think there's a problem with this sexual assault accusation just in general. It seems like the sexual contact was consensual. And so the argument, I guess, is over whether or not consent ceases when one is deceased. And I'm not sure that it does automatically cease when one is dead. Why would it? You were enjoying it while you were alive. You're enjoying it while you're dead, I would think. I don't know. I'm not an expert. We need a Ouija board. Did you ever want her to stop? Now, look, if you walk up to a dead corpse and you start going to town on it and you didn't get permission while it was alive, that's a problem, right? That corpse didn't give any express or even implied consent. But if if they're like, hey, we doing this? And yeah, baby, let's go. And then you're going, and then one of you has a heart attack and dies. Is that, it's like, what, were you supposed to stop? I don't know. I don't know about that. That seems very oppressive to me. Of course I want you to call 911, but I want you to get yours first. That's all I'm saying. That's all I'm saying. I just think, jokes aside, I think the statutes should be more specific. I think it should be a necrophilia statute versus a sexual assault statute. Because, look, they ain't in there. They ain't in there. And the problem with a sexual assault is not the physical act of sex or a penetrative activity. The problem with sexual assault is the trauma associated with not actually consenting to the activity. That's the issue. A corpse can't be injured and doesn't have feelings. So sexual assault to me is not an appropriate charge for an inanimate thing. That's weird. Can you sexually assault a mannequin? It might be gross if you try fucking a mannequin, but the mannequin doesn't care. It's just an object, right? If we're going by this logic, condoms get sexually assaulted all the time. Oh, what? They dressed for it because they're wearing the packaging that says that's what they're used for? Did you ask? No.
I think the parties would ask the court read
wait.
a version of JI 158. I have it here.
Yes.
Counsel agrees. It just addresses some of the obvious edits that would be seen by the jury. Just so there's no adverse inference to either party.
So just write a statute that says, by the way, if you fuck a dead body, we're putting you in prison. That's weird. That's weird, bro. Very strange.
Thank you.
There's nothing else?
No.
We'll bring the jury in.
All right, here we go. 64-bit goodness says, she left me in the bucket by the stairs. Surprises let me know she cares. What was the next line? Da, 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 da. I will not go. Turn the lights off. Carry me home. Na 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 na. Say it ain't so. Damn it. That's what the next line was. Thank you, 64-bit goodness. That genuinely made me laugh when I saw it come across. Sean McDonald says, I now know why Wisconsin is a serial Minecrafter mecca. People there talk so slow. It drives you to the point where you would either want to Minecraft yourself or everyone around you.
The state, the defense, and the court have agreed on relevant portions of law enforcement's interview of Mr. Business that will be played at trial. Recordings are proper evidence, and you may consider them just as any other evidence.
Saw my arms off. Carry me home.
Judge, the state is about to play what has been
Keep my
marked as
head
Exhibit
still.
110.
My ass you'll fill,
On
and I
Exhibit
won't go
110,
on.
There are a number of
I never
files.
ever will.
The files are both the individual clips from the videos, but then also one continuous video. The state intends to play the continuous video. I think there's about a 2-second break of a black screen in between the respective clips that are going to be played. For the record, the actual name of the file is February 23 interview hyphen trial, and then there will be another clip played for the second interview, and that file name is February 28th interview hyphen trial. So those are the specific files from Exhibit 110 that will be played for the jury at this point.
So someone in the Rumble chat says, fuck! Says, what the hell is happening?
I hate this fucking outfit. Never in my life.
Oh, Jesus, hold on, I gotta
I'd
turn it
rather
down.
be fucking dangerous than not.
Holy shit, that's
Clean the
horrid.
fuck up. What are you doing?
Thanks.
So if you don't understand anything, please let me know. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to consult with a lawyer before questioning, to have a lawyer present with you during questioning. And if you cannot afford to hire a lawyer, one will find to represent you at public expense before or during any questioning if you do wish. And if you decide to answer questions now without a lawyer present, you have the right to stop the questioning and remain
Why
silent
are the
anytime you wish,
microphones
including
like
during
this
questioning.
in the
Do you
interrogation
understand
room?
each of these rights?
Yeah.
Yes. Realizing that you have these rights, are you now willing to answer questions or make a statement?
Yes.
All right. All right.
Oh,
Well,
Ah.
a few hours ago, police were dispatched to an address on Stony Brook that the parents house Shad area. Do you know Shad?
put some fucking carpet up on the
shit.
walls.
He's my ex.
Your ex-boyfriend?
Yeah.
Well, they found a kind of disturbing stuff at the house there.
Oh, really?
Yeah,
Yeah.
a lot of blood. Basically Shad's head.
Fucked up.
Yeah, it's pretty fucked up.
Mm.
And then, so we know you were there at one point
Yeah.
with Shad.
Yeah, look at
what
their
else am I
VLC audio
about?
is maxed.
Now that band, is that your band?
No, that's my neighbor's.
Your neighbor's band?
Oh, the guy I was staying at?
Okay, so this, where did you go? Which place where did the police get you? Was that on Eastman? Is that correct?
Yeah.
Is that where you live?
Yeah.
Okay.
I'm staying there right now.
Okay, is that your apartment?
No,
No. Whose apartment is it?
that man.
And who is that man?
God don't.
I wanted to hear her digesting parts of him.
So, that's his band?
Yes.
Okay. And so, did you leave from Shad's house and go to Scott's house sometime today? Well, they found part of Shad at his house, his mom's house. Found his head. Where's the rest of his body?
It's there, it's at his house.
Is it in the house?
It's at his house.
In the house.
Can you tell me what happened?
It's a good question, because I blacked out during that time. But, I
Oh, stop moving.
need time to, think.
No problem. Take your time, have some water.
Mm,
Do you think the body is still there?
I don't see why not, unless it's just up and move, which it could have, you know.
Where do you think the body would be?
I was right there by the bed.
Lying back, you think?
Yeah, I was cuddling it by the bed.
You were what?
I was cuddling it by the bed.
You were cuddling the body with it? Oh, okay. Was it just you and Shad down in the basement?
Yeah.
Was anybody else down there at any point in time? When do you think you?
The crackling is
Yes.
her plastic suit that she's moving in.
I was it like 2 days ago.
Did you stay there the whole time?
Mhm.
You start to remember now what happened with Shad? A little bit, what do you remember so far?
No, it's not my mic. That's the, look at their VLC thing in the bottom right corner. They got the volume slider maxed all the way in the red. That's where the distortion and the white noise is coming from.
There's this chain thing, right? And then, yeah, like I was playing around with it.
Okay.
And like we were smoking the bitch, right?
Right.
And then, I'm terrible at explaining things.
You're like, guilty, you bitch. Stop
Let's
moving.
see here. And then here comes the chain, right? And then he put it around his neck. Well, we were like playing around and shit. And then, I don't know, I was tugging on it. And, I don't know.
You say you're smoking a bitch, what would that be?
Ice.
Ice? Have you taken any other drugs tonight?
No, this is still from 2 days ago. I know my eyes are fucking crazy.
Were you smoking the ice?
Yeah.
And how, on a pipe or someplace else?
The one that's on the counter or on the table. I left the baggie there.
Did?
I did.
Where?
Green baggie, and it should be right on.
But where exactly, in Eastman or Story?
At the left, that Shad's.
At Shad's. And you say, where was this place? Where would it be? In the basement or on the first floor or second floor?
Basement.
The basement. And it was ice in a, and it was a plastic, basically a bingo bag, a little small plastic bag.
Crushed up.
Crushed up. And just you and Jack.
Yeah.
And so there was a chain. You know what kind of chain?
It's the one that's on the same place as where the bitch and,
And where would that be again, please?
I think it's on a dresser.
On a dresser?
Is it, is it on a dresser? I don't know.
I don't know either. I haven't been there. I mean, as best as you can remember. So you think that there could be a chain?
Yep.
And the ice on a dresser.
Brian, I gotta wait to read the super chats because the audio.
It's just weird. I got like a weird flashback from it.
Oh, what happened?
Yeah, it's short.
Yes, I read all of them.
What did you see?
It's just, I don't even know anymore. Like, it was weird. I was riding him like a donkey, okay? And then, like, I think so. I think that's what was happening. I was pulling, and then I don't know.
Were you two being intimate, having sex?
It was getting there.
It was getting there, okay. So will this be considered
getting there.
foreplay?
Yeah.
I'm in a perpetual state of getting there.
And then, I don't know, and then, I just didn't stop. I don't know why. I didn't stop.
You guys done something like this in the past?
Not like that.
Do you use manual strangulation during sex at all?
No.
Is Shad like that?
A manual strangulation, yes.
He likes strangulation?
I don't know.
You know what I'm
Yes, he
talking
does,
about?
yes, he does. Yeah, yeah,
And you do too, or just him?
both of us.
So what would you, so when's the last time you guys had sex besides potentially scoring?
Mainly me, but like, we didn't even get it, like, I'm sorry, but we didn't even get it.
Okay, so you didn't, all right, but when's the last time you did do
I
it?
mean, I played with him though after, but, I have no idea, like, August.
And what would you guys like to do? Is there a certain role playing that you did with Chad? Or was
Now
it
you have my
just
attention.
some sort of strangulation? How would you guys do your, basically have sex?
It's like, I just want you just go, yeah, and we, go at it.
But does anybody like strangle the other person?
I like doing that a lot.
All right, so you like being strangled, like having your airway, or do you like doing it to somebody else?
I like doing it to somebody else.
Does Shad like to be strangled during sex?
I think so.
Have you done it before
Yeah,
with him?
yeah, he does. He likes it.
Have you
This
used what we
detective
call
went home and
props in the
dreamed about
past?
Schabusiness.
What,
This is my lady. This is, I can't.
Oh,
Oh,
the
this is,
dildo?
that or rope or chain or underwear or anything?
Yeah. I shoved a dildo in his ass and mouth.
In the past or just recently?
When he was there, when he was on the bed. Yeah.
So obviously you said you smoked some ice. Do you take any prescription medications?
No.
You have any mental health issues we should be aware of?
I don't know yet. I think.
Have you been diagnosed with anything officially? Because I know that Shad has some mental health issues, according to his mother. Since high school?
Yeah.
Where do you guys go to school together? Freeport? Okay. Did you graduate the same class or?
Yes.
yes.
You didn't graduate.
He didn't graduate?
So then you guys were boyfriend, girlfriend at one point? For how long?
2 years.
2 years?
2 years.
2 years?
2 years.
And this is right after high school or
No, during high school.
during high school? And what year did you graduate?
16.
2016?
Yeah.
So you and Chad date after high school?
We seen each other.
Okay.
We definitely seen each other.
Seeing each other, but were you officially couple, so to speak, or was it just, did you still have sex with him?
I did it once.
Just once,
Yeah.
after high school?
Yeah.
So when did you start seeing him again? Recently?
He's my buddy. He's my homie. So
Okay.
like, you know.
All right, so you've always been friends?
Yeah.
Okay.
Yeah.
So how did you get over to Shad's?
The minivan.
I mean, when do you think you went there? Do you remember?
2 days ago.
2 days ago? Okay. Did you stay there all the time, or did you ever pick him up and go someplace, or then come back?
We
Or
stayed there.
how did you get in? Was Shed there when you got there, or Shed let you in? Or you just walk in on your own?
He was there, we went in, got some shit, we came back, and then, methamphetamine. You know,
I see.
and then, yeah, ice, and then we came back.
Okay, so you showed up at his place. Then you and him left, and
Yeah,
you went and got some meth.
yeah, so then, we went, and, I picked him up, went and got some ice, and then after that, we went to, back to Scott's, we smoked,
Okay,
yeah, and then, I did his hair, but,
you did Shed's hair
yeah, I made him, a little bit.
at Scott's?
Yeah, and then after that, I, trimmed his face, you know,
Mhm.
feeling good, we left, we went back to his mom.
Okay.
I was looking for some crack, I never got no
Yeah, okay. So you went back it was just you and Shed to go back to his mom's? Or did Steve come?
Can they get someone who's
Steve,
not a fucking
Scott.
retard to just go ahead and mic
I'm
up
gonna
this
do that
room?
occasionally, and I apologize if I do get names sometimes. but-
Alright, yeah.
Did Scott, they come with you?
Scott stayed at home the whole time, at Eastman, that's his residence.
Alright, so you and Shed.
Problem is,
He
went
they
was
don't
back
want
not
to-
involved at all.
they don't want the person being interviewed to know
So
they're
you
being
and Shed went
recorded
back to,
because the government
Shed's
is
mom's
so
house.
fucking gay.
How'd you get in? Did you see, was anybody home?
The doors were locked. We went.
What time do you think this was? Was anybody home? Did you encounter anybody? I understand his mom lives there.
Tara,
Tara?
her mom, is that the mom's name?
Yes.
Damn, the head.
And then,
Yeah, I can't believe I left the head there.
where'd you do the body?
The body's there. Yeah. It's,
So we're gonna take the head somewhere?
I like that.
You liked it?
Well, you're gonna have fun trying to look for all the organs, but, yeah, they're all dismembered. Yeah,
So you dismembered the body too?
yeah.
And what did you do with the body parts?
They're in the house.
Somewhere?
They're like,
Basement, upstairs, downstairs?
absolutely in the basement. I was gonna bring them with them. And then, I know I forgot the head. I wanted the head.
Did you bring anything with you?
Yeah, it's in the van.
What?
It's in the van. It's, what is it? I don't know, a foot maybe.
The what?
I think it's a foot.
A foot
leg,
in the van?
a leg maybe. I don't know. I'm like, I'm gonna bring it all, and then I'm like, man, this is messy, so then I just left it. I got lazy.
Okay.
I got lazy, and that's what I did, so I'm like,
Okay. So there's gonna be maybe a foot or a leg in the van. And then,
yeah.
what'd you do with the head?
I forgot that was in the van, so, yeah.
What'd you do with the head?
The head I put in that bucket, that black bucket
Black bucket?
with the blanket on top.
Okay.
I should have it with me.
And then where'd you leave it?
Leave the head? The head's still in the bucket, it's right by the stairs.
By the stairs? Okay. How did you dismember his body then?
Knives,
With what?
knives.
Knives? Just more than one knife? Where'd you get those from?
Kitchen. Just couldn't find mine, and I wasn't sharp enough.
You weren't sharp?
No, it was alright. Bread knife works good.
Bread knife?
A bread knife works good, yeah.
Really?
I had to use what I used, so like, yeah. I got lazy last night, so
Where would these knives be now?
they're in with all the organs and all the body parts.
And where was that?
in the black bag. It's in the black bag
Basement?
it's in the basement. They're all in the basement. I never left the basement. I just went up the stairs.
So all the body parts and knives will be in a back bag. What kind of bag?
Black zipper bag next to a pink and black Under Armour backpack. That Shaq gave me. So I left it there.
Is it a big bag?
Me,
What kind of stuff would you normally put in this bag?
put anything in the bag.
Well, I mean, is it a trash bag or is it a garbage bag or is it, you know what I mean? Kind of bag?
Backpack.
No, the bag that has the body parts.
I have the backpack.
That's a backpack?
People are wondering about
Is
why
it a
she's
big
talking
one?
so much.
Yeah, the other one's like a little duffel.
I'll tell you in a little
black
bit.
duffel.
Okay. So you, at one point, did you bring these bags with you? Or were they already there?
I was gonna, but I got lazy and.
Right, you're gonna bring them with you when you left. But were the bags there when you used them, or did you bring them when you was Shad? Or did you just find them there?
They were there, I found them there, and I emptied them out and put them in there, and I was gonna bring it, and I got paranoid, and I got lazy, and I never get paranoid, but this time was just like, I think it was the dope.
So, did you want Shad to be dead?
No, it was out of random, like, I wasn't expecting that, and it kind of threw me off guard, and it was in an open place, you know, like, you went in the basement, right?
Mm-hmm.
It's pretty open.
Well, I haven't done it, but is it?
Yeah, so like it was weird. It was really weird. And you open the door to the outside, and you go down the stairs, and it's right there. Like you can see everything. Like right as you go down the stairs. Yeah.
And so, where did you get the chain?
I don't know. He pulled it out of his pocket.
He pulled it out.
He had two of them, one for me, one for him.
And can you describe them to me?
Chain
Chain link?
and silver.
Silver? Okay. And what size? Was it like a dog chain or a large lock type of chain? You know
They're
what I'm
like
saying?
this big. And then, and then it has O-ring.
Mhm.
And
So silver chains.
yes,
And he had two. And what'd you guys do with them?
we put them around her neck.
You did. Okay. And then what were you doing while they were on their necks?
I was strangling.
You were strangling them.
I was having fun with them and then,
Was their clothes on or off?
he had his shorts on.
He had shorts on. How about you?
I don't know, I didn't really care. But,
Did he ever put the chain around you? Did the chain ever around your neck?
I put it on
Do you have any marks or anything?
He didn't get the chance to strangle him.
Yeah, just he didn't get a chance to strangle you? Was that, he was going to though? Or was that part of the,
And I thought that was the thing, and then like, I don't know, I just went a little crazy.
okay. So when did you realize that Shad was not alive anymore?
Chad was unalived.
You know, his face turned purple.
Hmm.
He was coughing up blood, and he was pissed.
He was pissing himself. His face was all purple.
I still didn't stop, I don't know what's going on, I don't know what's blood, and then
So his blood was coming out of his
I kept
mouth
on
too?
feeling his heartbeat. Hearing his heartbeat.
I'm sorry?
Hearing his heartbeat start.
Okay. Did you hear it stop?
No, maybe, no.
Okay.
No,
So
I'm gonna trying to do that.
Did you figure he was dead then?
Yeah,
And what did you do?
played with him a little bit.
Did you try to call his mom or dad or anybody else in the house? You tried calling an ambulance? Why not?
Happened before. So, yeah.
So do you want him? You want him to die or you did? I'm trying to understand.
I didn't want him to die, actually.
But he did.
He's my buddy, but like it happened.
Happen again, but then did you feel a need to try to help him? Stop choking him or get an ambulance? You didn't feel a need to do that?
I don't know why, I just, it happened so fast.
So then after you realized he was no longer, he was dead, his face was purple, he said his mouth, blood's going out of his mouth. What'd you do?
Clean him up a little bit.
Sure.
And then, I just played with him like that.
You said play with him, what do you need?
Play with his dick.
Okay.
Yeah, like I put him up over the bed, and then, suck with it.
And you had him on the bed? What kind of bed? Was it an actual bed or just a mattress or what? So then you had sex with him?
Yes. And I had a dildo.
Okay.
I played with him too.
What'd you do with the
And
dildo?
I just cuddled him and hugged him.
What'd you do with the dildo?
I put it in his mouth, put it in his ass.
Okay.
Put it back. Put it back.
Where was this at? Where'd you put it back?
Oh, please stop moving. I can't do closed captions. It's not on their stream. I have them enabled, but their stream doesn't.
It's like on the wall next to the body. Right. And then,
Is it in a bag or on a shelf or?
it's in a wooden, box.
Wooden box. Okay. And what color was the dildo? You just. So
Pink.
you had sex with him. You said dildo on him. You said you cuddled for a while. Yeah, much.
Yeah.
You cuddled him. Where were you on the bed with him?
Yeah.
So you cuddled his body, and then what did you decide to do?
Oh, because like before, like I felt for his heartbeat, but then I still felt his heartbeat, right?
You did?
I did.
You felt it?
Yeah, so I kept on pulling more and more and more, and I went back and almost like he wouldn't die. And then he was like rebuilding in the muscle, and I don't even know, it was crazy. And then, I don't know.
Just before you had sex with him? Right.
That's what I was tripping.
While you had sex with him?
We never had sex, but when we were getting there, I was just choking him.
I understand that. You said that you played with his penis after he was dead.
Oh,
Was it erect?
yeah. It was half.
It was erect.
Did you,
It was erect.
what did you do with his penis?
There's hope for us after we're dead, boys. Yes. Woo!
Did you ever place it in your vagina or any of your body parts?
No, I just.
You didn't use it as a dildo or anything? Okay. So you're saying then you're like choking on and stuff, and was he struggling at all?
Yes.
I'm so fucking happy.
He was good.
You try not to
Says
fight,
Holy
yeah.
Spirit undefeated.
Sometimes people have a flight or fight, you know what I mean, the reaction that something happens, so they try to grab them, you
Yeah,
know.
he did. And then,
He didn't, or
no, he did.
did you get hurt at all? I see, you know, you had that cut on your thumb, how do you think you got that?
Oh, that was dismemberment.
That was just not.
That was a lot, yeah, I got lazy in that process right now.
Did you, use any other devices besides knives? Just, okay. Those scratches on your arms and stuff, were they from him?
Oh, no. I was,
And how did you get them?
so this one, I did by myself.
Oh,
This one, I probably did by myself. This one, probably did by myself.
so they
That
weren't
one?
him trying to grab you or anything? Did he try to grab you at all with his hands? That, so the blood on your hands, would that be Shadow's blood?
Oh, probably, yeah. I'm telling you, I got super lazy tonight.
How come?
I really don't know. I blame it being on drugs and the come down that I'm coming down off of.
How many times do you think you've done this
I never
before?
do drugs, like, I barely do drugs. I do drugs, but then like, once in like a few, like, weeks, not even like that, like months go by and then I'll do drugs.
I see. And where did you dismember this? In the basement, right?
Because everything for Dahmer and, yeah.
You do anything particular with the head or the body? What did you do with the blood? What happened to all the blood?
It's still in there, still in the tote. I mean, with the, you know,
The bill.
there's a shower in the basement, you go in the next side over and I just dumped it out into the drain, there's probably still blood there.
Where did you go? The bucket?
Well, I drained his head. Well, like, after I covered his blood, I put it in the bucket, but then there's still blood in this bucket because it's coming out of the head. Should have took the brains out, but I didn't do that. And then I,
So you cleaned his head in the shower and then dumped the bucket?
I should have cleaned his head in the shower, I should have polished it up, but, didn't.
Okay.
I like that.
And what did you use to smell that, heading?
The knives.
The knives?
Yeah.
What, well, you said one was a butter knife, what kind of knives were they then? Big knives or knives? Butcher knives?
They were the kitchen knives, everybody just.
How did your block?
There was two like little knives there. And then, they were like probably 4 inches. And then, the other ones, they were probably like 6-inch knives.
And where were they in the
One was
kitchen?
a steak knife, one was a bread knife. I
When you say
wanted
bread
bigger
knife, is
knives.
that
I
like
wanted
a serrated edge on it, or is it a flat edge on the bread knife? You know what I mean by serrated? And where were these knives in the kitchen?
Here and, shit. They were right next to the oven.
Were they in, like a knife holder thing, or in a drawer, or where?
They were in, like, you know what I'm talking about when the,
Yeah, some holder that put the
Yeah.
knives
that's the one right there, like, it was in the,
by the oven.
idea. I really like that.
What can we do?
That's how messed up my head was. Like, I was really messed up. Like, I don't know what was going on. I was just going crazy.
I don't know what's going on. I was just going crazy.
I don't know what was going on at all because this, I think it was the open area. I wasn't in a room by myself. There was no door. It's an open area. It was an open area. I didn't like it. It was different. At all.
Or was there anybody else there?
Maybe upstairs.
Upstairs? And how come why did you leave? Was anything calling you to leave the house?
I kept on hearing footsteps.
Okay.
Gunshots. So
What else, I'm sorry?
gunshots.
Gunshots? Why did you think you heard those?
I have no idea.
Do you have a gun with you?
No, I did not.
Did you hear a gun in the house?
No, I think it was outside.
Okay.
Yeah, and then
You afraid someone was coming
it was
there?
weird. I'm never paranoid, but then out of nowhere, like I got
Yeah, paranoid.
first like for a couple of seconds, and then we'll go away, and then like feeling will come back. It was weird. It was really. It was a weird night. Like,
Yeah, I would
I
imagine.
don't even know. Like, this one was weird. I didn't like the openness.
Yeah.
I didn't.
Too much room.
Yeah.
Okay. Well, I'm sure I'm gonna have some questions for you. I'll take a break. Maybe drink some water.
Pixelated Apollo, she is allegedly on
Tell them what happened, you
trazodone
know.
and meth in this interview.
You don't have to chat.
Yeah, he's got body parts in his hand, so he's gotta get that out.
Yeah.
I forgot about that. I've been off of it right now. I blame the fucking drugs. Honestly, so.
Just a minute. Are you supposed to take any prescription medications?
Nope.
Okay. All right. I want to look into a couple other things and we'll be with you and if you need anything, knock on the door. Okay?
For anyone worried about the
How you
time
doing?
shifts, they agreed.
Good, doing okay?
They agreed to the times that they're showing us, the defense and the prosecution. This is
That's great. I need
stipulated.
stitches.
You're gonna need some
I'm
stitches.
gonna need stitches.
The thing is, I don't know how soon you get there for us.
Usually you're good, they were saying, I think it's stitches, you got 24 hours. Do you think you cut yourself over 24 hours ago?
Oh, yeah, I just did it like, 4 hours ago.
You did it 4 hours ago?
Yeah.
Alright.
Well, that's actually one of the things that we want to kind of do is what we call timeline, just to kind of get an idea of what you were doing since you first had contact with Chad. How did you call him up? Did he call you up, or did you just show up at his house, or how did you decide to go
I
over to his
said,
place?
hey. I said, hey, come over here. And then I went and got him.
You called him, or he called you, or
Yeah.
how? Do you have a phone?
No, it was actually from my friend AJ, our friend AJ.
Okay.
Yeah.
Where were you?
That's Scott.
Okay, was AJ there too?
Yeah.
So you're at Scott's, and your friend AJ was there?
Yeah.
What's AJ's, any other, his last name or first
Big
name?
Gannon.
Huh?
He's Gannon.
We'll look
Cannon?
at
Big
the
Gannon, yeah.
we'll look at the Hunter plea deal stuff on lunch.
Gannon.
Would Scott know who he is?
Yeah.
Was Scott there?
He's referenced as Black AJ.
Is he a black guy?
He's a black guy.
Okay.
He's got juice bros.
Was, Scott there then, when you and AJ were at the apartment on Eastman?
Yes.
Okay.
He walked over there.
So you called Chad using AJ's phone?
AJ
Okay.
talked to Shad.
AJ talked to Chad.
Yeah. And he's just like, hey man, come on, word to Scott. And then Chad was like, I might have got a ride, but can you come get me? And, so then, I
Did you
went,
text them?
yeah. So then he's like, wait, never mind, I'm all right. So then we went and got him.
Okay. And then who went?
I took him in.
Did you go by yourself or somebody else?
I grabbed him. I took AJ and I put him in the seat. And then,
So you and AJ went to Shed?
yeah.
What time do you think this was? So you and AJ were at Scott's. And AJ contacted Shad by text message probably, saying come over, something like that. Were you and AJ using drugs at that time?
No, we were smoking the yield, Mary Jane. But
Just smoking marijuana? Okay. So then who went and picked up Shad?
we grabbed, I took AJ in the front seat and then we went over to Chad.
Okay. And so how did you get there?
Via van.
Did Scott know you were taking the van?
I said, hey Scott, I'm taking the van, I'm picking up Chad. And then he was just like, no. And then I'm like, okay. And I took it. Yeah.
Okay. So he didn't want you to take it, but you took it
So I
anyway?
took it anyway.
Okay. And where did you go?
To Chad's house.
His dad's house? Mom's house? Where?
Mom's house.
Did you go inside the house at all?
I knocked on the door, I said, hey Chad, come here. And then like, you came here? And then like, we went here.
All right, so then Shad got into the van and AJ was in the van and then where'd you go?
And then we went to, so me and AJ and Chad, we went to his dad's house, right?
Whose house?
We went to his dad's house.
Shad's dad?
Chad's dad, we went from his mom's to his dad's.
Okay.
Yeah, and then, I don't know. And then, from there, we went and picked up some dope.
So was anybody at Shad's dad's house? Was Shad's dad there?
Yeah, Chad's dad was there.
Okay. Did you talk to him or have contact with him?
Go Michael B, yeah.
Okay. How long were you think you were at Shad's dad's house?
Like 10 minutes.
Okay. And where'd you go to store dope?
I don't know. Like, that's the thing. Like, I don't even know where it was. Like, I'm just like, put in the Addy. And he's like, oh, and then he went and got it. And then,
So who made arrangements to get that?
I have no idea. Maybe Chad?
Shad, maybe?
Yeah.
So, do you remember, was it a business, a house, or a car? He met somebody in a car? What did it happen?
No, he was just like, hey, you got any pretty girls inside? I'm like, hell no, I'm gonna knock his ass out. But he says that, right? And then, like, for me to go in and get the dope, I'm gonna knock in the dope. I'm like, Chad, go get the dope. So Chad went and got the dope, and then he came back with the dope.
Okay, and where was this, do you think?
This was, I don't know, I have no idea. I just.
Was it a house or apartment or?
You said put the Addy in, did somebody use their cell phone to find the house address?
Could have been.
Do you know who might have looked it up?
I have no idea.
AJ or Shad?
I have no idea.
But Shad's the one that went in to get the dope. How much did he buy?
Oh, that was all me. I gave him $100.
Okay, so you bought $100 worth of meth?
That's what I did.
All right, and it's the three of you still in the van?
Yeah. Yeah, when he got back in.
And where'd you guys go?
We went back to Scott.
All right, one back to Scott's. Who's all there then?
I just dropped a fire super
Scott,
chat on Jeff's
AJ.
stream.
Shad, and me.
And what you guys do?
We smoked. We
Smoke
smoked
what?
the reefer.
Marijuana?
We smoked the reefer. I didn't smoke the reefer. You know, they smoked the reefer.
Who had that, the reefer? Someone bring it with them, or is that already there?
It was, the reefer was there. The reefer was there. And then after that, me and Shad, we were talking on the bitch. And then after that,
So you and Shad smoked some meth at Scott's?
got to smoke somebody.
Where were you guys located?
That would be Eastman. That's
Right, were you in an
Scott's.
apartment, but were you in a bedroom, in a living room, in the kitchen?
Living room. Bedroom.
Was Scott using any of it?
He was chilling on the chair, rocking back and forth.
Did you see you guys smoking meth or marijuana?
No, that's all behind him. He can't see. He can't see it, no.
Why not?
Because that's behind him.
Okay.
He's facing this way, we're this way.
Okay. So then the three of you smoking marijuana, and you and Shad smoked meth. And so then what happened then? Who went where?
I started cutting Shad's hair.
That's right, you said you
Yeah,
gave him a haircut.
Give him the haircut and everything, and then right after that, AJ was just like, you don't want to go. So then, I already see it,
Did you left on his own? Okay.
and then he shot it on foot. And me and Shad, we took it out. I shot him up, and I took him out. I had one shot too.
And where did you get that stuff from?
That's the same place.
I know, but, well, so you bought it with the meth, you bought the other stuff too? Where did you shoot them up with?
Same shit, the trazodone,
Yeah.
I crushed it up.
And where did you get the trazodone from?
The table,
The table, where's the table located?
it was right by Scott's,
Was it Scott's trazodone?
yeah, he is,
Are you sure it's trazodone?
it says it on the bottle.
So you took some pills from where? You said on a
From
table?
the counter.
On a counter?
Yep.
And it said trazodone on the label?
Yep,
And was it Scott's pills? Was Scott's name on there too?
yeah,
And you crushed them up, and then what did you do with them?
I put it in the syringe, I pulled it back, and then I shot him.
Okay. And you said you took a shot too?
Yeah, I did.
Okay.
Where did you get the injection? Where did you inject them at?
I got it from a friend.
No, but I mean, when you shot,
Where did I shoot him up?
yeah,
Shit, probably in the arm.
in the army then?
Yeah, there.
You said you got the hypo from a friend? Mm-hmm. Have you used drugs, they call it intravenously, some needles before?
Yeah.
Alright, so were you guys in the bedroom, in a living room, or someplace else where, bedroom? Okay. And then what do you guys do?
And then, we just took off, cause, we just headed over to his mom's house, got cozy on the bed, we drove into the driveway, right? Opened the door, we went down the stairs, we chilled on the bed, and right after we chilled on the bed, he put the collar on.
So you and Shad left, Scott's van. Did Scott know you were leaving?
I said, hey, I don't know, actually. I don't know.
Do you remember what time that was, or was it day, dark out, light out? Night, you know what I mean? What time of day was it, you think?
Like 12 maybe, I'm just gonna guess. I really have no idea. I don't know.
AM?
I don't have the phone.
Was it dark out?
Yeah.
Okay. So you went to Shad's parents' house, Shad's mom's house.
Mhm.
Did you meet anybody as you were arriving?
No. He didn't.
All right, and then you went into the basement.
Yep. Open the door and then into the basement, down the stairs, and then onto the bed where you put on the cover.
Was it right away you started doing that?
I don't know. This is what I remember.
How long do you think you were in the basement?
Until I left. I really don't know.
Was it during the day at all?
I really don't know.
Did you sleep at all?
I mean, I was playing with him all night, so
Because you were playing with him all night?
yeah.
What about during the day?
He kind of went into the day. I still was playing with him. But like, are you talking about the choking session? 'Cause,
Well, from the time you got to Shad's mom's, how long do you think you were there before you left?
like until he like died or like
No, until you actually left.
until
And
I
went
left?
back east. Yeah, so by the time you first got there to the time you actually left,
I don't know. I don't do times. Like I really don't do it.
was it overnight?
Yeah.
So I'm asking because it was the time it's the boyfriend see.
Did you at some point the boyfriend have to let you in,
Shut
into the house?
Who don't lock the door
Did he unlock the door
and open it?
and open it for you guys?
He did.
Okay, so when you guys got there after shooting up the first time and
Yeah.
coming back from Eastman, he did open the door for you guys?
Yeah.
Okay.
So then, from then till the time you left, how long do you think it was? A whole day? An hour? You know what I mean?
It was shit. I don't even know. Like he was
So you got there and Chad's mom's boyfriend let you in,
Mhm.
and you went to the basement. Did you start getting together right away, or did you sleep for a while, or what do you think you remember you did?
We went there. 5 minutes in, I was already choking him.
All right, so it happened pretty quick.
Yeah.
And you talk about you're playing with him.
Oh yeah, I was playing with his dick and with his corpse.
Was it light out at some point? Was the sun
I
up?
mean, when I looked out the little window, I seen it.
You could see
I
light?
could see the
So
light.
you were playing with him when it was light out?
Yep.
All right, so basically within, you said within 5 minutes of it getting there, you guys started, he pulled off the chains, I guess you were saying? And he put it around his neck.
Yeah,
Did you put one on, you never put one around yours, did you put one
I
on?
did.
You
I
did.
did. It was tiny. I finally got it around and I put it on my neck and I took it. After he was on, but like,
So you started choking him, and when you were choking him, what did he do? What were you guys doing, I guess, is to try to explain it as best as you can.
he was coughing up the blood right and I was just waiting for him to die and then, like I was looking at his purple face.
Well, did he
During
expect to have sex with you?
Cause I felt like it was fucked up. I'm like, damn, I'm already this far. So then I was just like,
I understand, but why would he put the chain around his neck?
because he's a kinky mother, yeah.
So was he expecting to have sex with you then? Kinky sex?
I would assume so.
But you said that he just started choking.
This goes directly against the sexual assault.
How long did it take for him to die?
Like, 3 to 5 minutes maybe. But, I don't know. I have no idea.
You said that when you were choking, when you started coughing up blood,
Oh, yeah. Like, damn.
and you just decided that.
I just like, I like to see what happens.
So you just
I'm
kept
curious.
going harder and,
I didn't
You
go
wanna see
harder.
what happened when he died?
I just watched it, yeah. Well, this one was different. This one was common.
blood.
So when he put the chain around his neck, he thought that you guys were going to have kinky sex, right? You think that's what Chad was thinking, maybe?
Yeah.
What were you thinking?
I was gonna do the same thing. You know, I was going in, and I did, and I went in. But then he was like, choke me, but he didn't really say it, so I'm like, put it on his neck. I already know I'm gonna choke him, and I did.
I'm going in.
All right, so
I was
before
going
that,
in,
did you
so I
guys,
did.
was there any foreplay?
We launched onto the bed. We went from the stairs to the bed, and then, yeah.
Were clothes on or off?
Yeah, and now, yeah, now the,
But before you chain went around his neck, were you and Chad like kissing or any foreplay or anything?
no, we were chilling at home.
You just chilling. So all of a sudden, the chain went around his neck?
Yeah.
How come? I'm just trying to get it.
He likes it. I was
So,
gonna walk him like a dog.
you know, and he wanted that?
I have no idea what I was gonna do it anyway.
Okay. And you're claiming it was his idea? With the chain?
Obviously mine. No, it was his idea. It was all him.
Right, so you're on the bed, the chain goes around his neck and you start choking him. And you just realized that he was gonna die or what?
I'm just like, shit. I think I went a little too far, cause like I was blacking out while I was doing it, right? And then like, and then like, I look at him, I'm like, shit, he's already purple. I'm like, fuck, I'm like, I don't know if he's fucking, is he good? Is he good? But then like when I woke up, like, you know, during the blackout moment, I'm like, shit. Like he was coughing up blood. I'm like, I don't know. I just kept on going. Like, damn. Sorry.
You made the comment, you said that when you were choking, you was coughing up blood, you kind of were like, I'm going this far, I'm just gonna keep going. Did you realize that by continuing that may kill him?
Like, yeah, because I felt bad that he's like, because I'm like, damn, he's gonna be losing after this. I'm like, might as well just kill him.
Okay. So you realize that by continuing that you may actually kill him?
He was, I swear to God, he was telling me, he's just like, just do it. So I'm like, wow. And I did it.
Okay.
Like, I
Okay,
swear,
you should- this is
I
interesting.
accidentally fucked up and then I thought, oh my God. And yeah, that's exactly what happened. All those
And
movies.
you also said that you enjoyed it, right? And I enjoyed it.
Oh, yeah.
What'd you enjoy about that?
I think that goes against intent.
Was it kind of thrilling, a rush, exciting? What was the feeling that you got out of it?
That's all it is.
I'm just trying to understand what you were feeling. You're saying that you had enjoy it. You know, did it make you happy? Was it just kind of exciting? Like opening Christmas presents
Like,
or?
I don't know. Like, this is the thing that I have, like, I've always had, you know, like, you ever love something so much that you kill it? Like, it happens to me. That's the feeling that I have. I love something so much that I kill it. Like, oh, I love it so much, and then I kill it.
I will love
That's
him
what
and
happens
squeeze
to
him
me.
and hug him.
So,
All right, so he dies, he's dead. And then you just kept playing with his body? Okay. And when did you decide to, how long did you play with his body? Is that when you thought it was booked outside and it might have been light out too?
I don't know, it's still dark.
Still dark?
Yeah. Oh, I gotta be like, 2, 3 hours. 2, 3 hours.
Is that also when you Used a dildo?
Yeah.
Did you have sex with his body at all? At any point, or any type of sexual contact? You know, obviously the dildo and stuff,
Put
but.
the dick in his ass.
Hmm?
I grinded on him, I put the dick in his ass.
You grinding on,
Yeah, I listened.
did you ever put his penis in your vagina? Or you just grind on him?
She didn't even give him a veg? Lame.
Did you see before that you?
And at least after death.
Roll on him?
Yeah.
Okay, and that was after he was dead?
Yeah. And then, yeah, and then he got half, he was like half hard while I was still sucking while he was dead. Yeah.
Okay. Okay.
And was that part of playing with him, or
That is part of playing with him.
That was part of playing with him.
did you?
Actually, I was just, I was severing his head while I was doing that too with him.
You were sucking.
Yeah.
So it wasn't only a couple hours before you severed his head? Or did you fall asleep at any point in time, or? So how long do you think you were in that basement? Because you didn't leave until like 3 or 4 this morning, right? But what about during the day? What did you do during the day?
I don't know, like I was kind of like dozing off, like nodding out.
He was dead already? Was his head still on?
No, I took that off. That was the first thing I took off.
Okay.
I wanted the head.
What about the rest of his body?
I didn't even take it. And then the rest of his body, it's like I was fucking I don't even know what it is. It's in a big blue container, you know? And
Just a
it's big.
container?
It's like a big Tupperware, it's not Tupperware, but it's a Tupperware container, like a.
A big storage tank?
Yeah, one of those, and then,
So that's where the body parts are in? Or I thought just they were in a black bag?
they're scattered around.
Okay, so both probably. But when did you start, cutting up his body?
Like almost right away, I was sucking and cutting at the same time.
Then what about the rest of his body parts? Did that take all day to do?
I was getting pissed off at the dismemberment process, actually.
Did it take a while?
It took a while.
Yeah, because like I was nodding out, so
Okay, so you're kind of sleeping, kind of nodding in and out. Have you taken any other drugs?
I should have took drugs, that would have helped. But
I
didn't.
should have took drugs. Would have helped.
Do you remember it being daylight at all?
Yeah, when I looked at the window and I seen the daylight.
And was his body together still then, or?
Why it was never together. It's just like, I had fun with him for that 2 hours and then boom.
So, but it took a while to cut the rest of the body up? Okay.
All messed up too.
So, I'm just trying to, so I understand two rules. So you said you were cutting and then you got a knot off, kind of wake up and start cutting again?
Yeah.
So it took you a little while to cut the body apart. There were times where you went on napped or whatever. It wasn't, you didn't work nonstop to dismember his body, right?
I mean, I probably did while in my sleep. I do things in my
You
sleep.
do things in your sleep.
But yeah, but like, that's probably it right there.
Did anybody ever come downstairs at all?
Tara came, she came downstairs and then, with the kitty cat, and then she set the kitty cat down. And, flipped over the kitty cat and then the kitty cat was walking around. And I threw the kitty cat, and then, yeah.
Did you talk to her?
I'm like, hey Tara. I don't know, it's just weird. Cause like it was an open space, like there's no closed door, and I'm like,
Did
it was weird.
she saw anything?
I have no idea. I don't even have to ask her. Because she's like, it's a big ass.
So you think she came down at one point and dropped the kitty cat off downstairs in the basement? Right.
How long was she in the basement, just shortly to drop the cat, or?
Yeah, she just came down there, dropped the cat off, to go use the kitty litter,
Okay.
the box, and then she went right back upstairs. Yeah, and then,
All right, so then throughout this process, you would cut off a body part with one of the knives, and you would put it in the bag or the tote or something like that.
yeah, I was still tweaking out, so like, I don't want to get on that, and then I'm like, wow, it's getting dull. So I grabbed another one, and then I was cutting it, and it was getting dull. Now, and I was tweaking, so like, I'm like, oh shoot. I should've done that. I didn't mean for all this to happen, and I'm like, I fucked up, I know I fucked up, and I'm like, shit. Yeah, I'm sorry. That's what happened.
Well, you know, it's feelings, got a mom and a sister and a dad and family and more of being sorry, you know. You killed them.
You gotta tell the sister sorry. Didn't mean for that to happen.
You didn't mean to kill them.
I
But you didn't try to help them?
No, I didn't, no. It works both ways, like, I have no idea, like, it.
You was gonna
Gotta
die,
be put into change.
right? You was gonna die, so.
I mean, I didn't, but at the same time, I woke up like, fuck, that's bad. I didn't know what to do, cause like, you was like, ah, like, fuck, I didn't know. You know what I mean? Cause like, I don't know.
But you liked it?
I liked it. I'm like, fuck, like, it was, like, I didn't know what to do, but like, oh, I liked it though.
She didn't know what to do.
Well, you
Did like
said you
it.
didn't wanna call police or ambulance or anything, so.
Actually, I thought about it. And then, I was getting angry at myself,
Mhm.
very angry at myself because I didn't have the proper tools.
Yeah.
Sucks not having that.
Was it sexual to you when you were choking? Yeah.
Oh, yeah, very.
Was it exciting when you were sucking on his penis after he was dead?
It was very exciting. Everything was, we should check on my panties. Boom.
Have we been watching this interview for an hour? Damn.
Hey, can you see us? I gotta ask you a question. I just wanna kind of clarify some things quick. Type the growl, I'll be here shortly. Probably, I believe he's gonna stop. It won't take long. So, after
He's
the
laughing.
incident where you choked him out,
What else
can
are
you
you gonna do?
describe how you placed him before, because you said you cut his head off first, correct?
Yeah.
Can you describe where was he
This
laying on the bed?
later interview.
I pulled him,
Okay,
like, say this is the bed.
okay, so this is the top of the bed?
Yeah.
Okay.
And, I pulled him, and then, his head was hanging off.
So you're probably laying face up? So
Yeah.
his back was on the
The
bed,
back was on the
his
bed.
head's partially off the bed?
Yeah.
Okay,
And then,
As one does.
the tub was like right there.
like the pail that you had the
Yeah.
head in before? Okay. So basically his head's here and the bucket's right here?
Yeah, and then, from there, I severed his,
You cut his head off?
yeah.
After you cut his head off, I know you said you dumped the pail at one point into the shower.
In the shower, yeah.
Did you leave the body there for a while to drain into the pail or what? How?
It's all in the tub, in the blue tub. You found the blue tub, right?
I don't know if they're slowly going through the scene, so there's a lot of his blood. Did you pull the tub under there then?
Oh, no, I moved the tub like real fast.
Oh, so you cut the head and then pulled the tub under there?
No, when I was dismembering the
Yeah.
body,
Yep.
there was, I mean, I'm going like this with a knife, so there's blood fucking going everywhere, sorry.
Okay.
Yeah, and then,
But initially, when you cut his head off, there was a pail underneath, correct? Okay, so the head went into the
To
pail,
Schabusiness.
the blood went
Thank
into
you
the
for
pail.
today.
The blood bucket fill all the way up with blood?
No.
No? Okay.
No.
Then, did you move them again when you started with the pail? Because you're talking about that blue Tupperware thing.
So I think there's a black pail and then there's a blue Tupperware thing, right? And then his head was hanging off. And then I cut the head off and then I moved it over and I brought it back and then I put it in the pail.
Okay, so initially the head went into the blue Tupperware thing?
I do
Kind of
not think
Yeah.
she's guilty of murder
Yeah.
one.
There's a lot of blood in that one right now.
In the blue Tupperware thing.
Yeah.
At any point did you, like, before you, because you said you removed the head first,
Mhm.
did you start removing limbs right away, or did you kind of wait a little while? And
That's the weird thing, like, cause when it started happening, like I started like nodding out.
Okay,
And then I was going crazy on the limbs, like even while I was sleeping, and then it looked messed up, and I didn't like it.
okay. But you believe the blue tub, that big tub, like, probably, I'm thinking it's the way you're describing it's only like Tupperware tubs about like this size, that 3 cubic foot one, and that's where most of the blood is,
We can talk about that in a little
along with a
bit.
bunch of his organs.
The organs are everywhere too.
His organs are everywhere.
Yeah.
Did you like hide organs in the house?
Oh, they're in plastic bags. They're in plastic bags.
In the tub?
In backpacks.
In the
In the
back?
backpacks and then in the.
Did you remove all organs, like his intestines and everything, or where are the intestines? Do you remember?
Remember the mutilation of a corpse is not an element in murder one.
They're gonna be in a plastic bag.
They're all
You could
plastic
say it goes to
So that
intent,
blue tub is almost just all blood?
but it seems more like she
It should be
mutilated
like,
the corpse
like
incidentally after to
this
me.
much.
Alright. Okay, we're just trying to clarify a couple of things. I'm just trying to make sense of something.
Yeah.
Okay?
Okay.
Alright, I appreciate it. Thank you.
All right. Thank you.
So someone asked why the detective seems so excited.
How you doing?
They're,
Good on yourself.
Alright.
I think they
Can we
think
talk
they're
for a
gonna
minute again?
nail down intent and stuff like that.
So,
Blue Fire, we'll talk about it
out
when
at the house right now,
interview's
there's,
over.
you know what a medical examiner is? They're the ones that kind of like take care of people that died and see how they died. And so, you know, they have a bunch of questions for us that we really can't answer. And the biggest questions that they have is exactly how did you dismember Shad?
Nice.
Did you, you know, cut arms, or, I mean, or was it just internal organs, or?
So you started on the head, right?
Yeah, and then I don't know where I went from there. I just went crazy.
Did you cut it, or did you remove his arms? Okay, can you show me where you were cutting the arms?
They're also trying to nail down that she did this,
Right there.
not that she knew it happened and is
Was this
talking
part of the
about
arm
it.
left on?
They may know the details. They may have the body parts at this
You gotta
point.
go in that blue
They may
bag.
know
Okay,
the state of the body. They're gonna
Yeah.
Did you know
they're
that you cut
asking
it off at
questions
the elbows?
about things that
Can
didn't
you cut
happen.
both arms off at the elbows?
I would hope so. Because like, I was saying that dismemberment process I did was like really messed up because like I was nodding out. And then I was like sawing it off.
Did his
Did you
legs,
use just a knife?
Just the knife, so like,
did you remove any part of his, did you dismember his legs at all? What was you on the legs?
I think there's one leg that's actually intact.
Okay.
And then, maybe, where is it? I have no idea.
And where was his body located when you did this dismembering? Was it in one spot, or?
Yeah. It was all in the same spot,
And where's that again?
blue tub.
So the body was in the blue tub as you were cutting it up? Okay, then did you empty the tub at points, or, you know what I mean?
Was there a bed down there, or just a mattress, or?
There was a mattress that was laid down, there should be blood on the sheets. Like a lot of blood, but, I tried to get it out. But, I can't fucking think right now, I'm sorry.
That's
I'm
okay.
going fucking nuts.
Yeah, you know, because, like I said, just, yeah. And they'll probably figure it out eventually, but, they just had some questions about, like where blood might have went, or most of it went. I mean, you said a
That was
bucket, or, yeah, that was drained, or like that. But it was, when you took off his head, was he lying on a mattress? Or was he someplace else?
I had his head hanging off,
The mattress?
and then I was fine.
But was a bucket underneath his head?
Yeah.
So it was high enough?
I don't know, it just dropped in there.
What's that?
It just dropped in there after I got the bone.
But it was high enough that it could stand up underneath his body, you know what I mean? So let's say the body visited the bed, the bucket was able to fit underneath there. Was that bed was high enough for a bucket to fit there? Or would it have to be on its side or something, the bucket?
No, the bucket was just fine where it's at, on the edge of the bed,
On the floor or on the bed itself?
on the floor. So there's a box spring and then there's a mattress.
You know, what do you think should happen if somebody does something like this to somebody else?
I don't know, they obviously get prison time, I don't know. Whole lot, like, I don't know, this was out of random.
Think it was the right thing to do?
No, I did it anyway.
Yeah, and I just want to clarify, when he had the chain around his neck, were you behind him
Yeah,
and kind of, what, just one end or two ends or the chain or?
there
And, just one, but you hold it, how to, you know, what I mean, because if you wrap a chain around someone's head, you just hold one end of the chain, the other end is gonna go loose.
no, so if you seen, there was a ring, and there's two rings, and then like you can pull the chain from under the ring and then pull it back.
All right, so then a loop at the end of the chain that could go around, kind of like a dog choke collar.
Yeah, exactly.
Okay, do you think it was a dog choke collar?
Could have been, very much
Could've been.
so.
Was it that size?
It was that size, for a large dog.
All right, and so then you would have been, was he laying on the bed? Or kneeling or something else?
He would have been, on his stomach.
Something like that?
Yeah.
Is that what you're talking about?
Yeah.
Choker chain? Okay. And there were two of those, correct? You said there was one, you moved one for, that was on him, yours was a
Yeah.
little smaller?
Yeah.
Does this guy look familiar to you at all?
Mr. Gannon?
That Adrian?
Yeah,
Okay.
that's the one.
So he was lying face down on the bed? Or was he just on his hands and knees?
He was
Or,
lying face down on the bed.
okay, you're on top of him. On his back,
Yeah, I was on his back.
pulling the chain back. Okay. Hopefully that, hope that, you know,
Did you guys find all the parts here?
still
Yeah. there's-
going through the process of looking. So, did you remove any other, you said you had the heart and the liver, how about the lungs? Did you remove all that from the chest cavity? Or did you leave them in there, or
It could be in there.
do you remember, or
They're all in plastic bags.
separate bags, or one big bag?
They're all in separate bags of Walmart bags. And they'll find.
Long should they go? Okay. Are you doing all right? You need anything, or hungry or anything, or
One thing.
what?
Just one thing.
Well, you're right, I mean, you don't need any food or you got water, obviously, so if you need anything or you go to the restroom, knock on the door, and then, you realize that you know, you're probably going to jail after this when we're done, so.
I didn't know that.
I'm just, you know, telling them what it is, and then I'll make screw around with anybody, so.
All right. Yeah,
No, you've been forthcoming with us, so we're gonna be forthcoming with you,
thank you.
and we appreciate it.
I mean, like Dave said, if somebody kills somebody and dismembers them, do you not think that that person probably should go to jail?
Oh, fuck yeah. Yeah, this shit was fucked up, so, like, I don't even know, like, I'm like, goddamn. Yeah.
So, you know,
Yeah.
we see where we're coming from and what we gotta do. And nothing personal.
Sucks.
All right,
You need something, instead of knocking the door.
Thank you.
Detective Graff, the video that we all just watched, is that video accurate and consistent with what you recall from your in-person meeting with Taylor Schabusiness on February 23rd of 2022?
Yes.
Just want to address one thing. At the beginning of the video, she's wearing a yellow outfit. Toward the end, she's wearing a blue outfit. Can you explain that for the jury?
When she went to the hospital to have her thumb checked, the hospital changed her into the blue scrubs.
And then you indicated there was also the recorded interview from the 28th. I intend to play a much shorter portion of the interview from the 28th.
you know, so you took the ring fingers, is that why you got scratched that? And you kept mentioning that you liked it.
I was gonna take it and then I just left it. I was staring at it, I was looking at it, right as I was looking, right as I was gonna go up the stairs, and I just like, I left it there. Like I was gonna come back, I was gonna come back, and I left it there, and I don't know.
Only
I
4
was
minutes.
told.
This is like
Yeah.
5 days later.
But you're gonna eventually take all the parts, you think, with you?
Yeah, I don't know. I really don't know.
Did something spooky?
Oh, I kept on hearing like footsteps up and down the stairs, down the stairs, down the stairs.
Can I ask you a question? Would we be then? Do you remember wiping up the concrete floor by the bed? Remember wiping it up?
Yeah, before I speech, they were right there.
Okay. And then you put those in the bags, remember that? What do you do with those stalks, please? What do you?
I think, I had no idea.
Okay, would you use those to wipe up with that?
Yes,
Did you move to that,
yes, it is.
to cover that up?
Yes.
Okay. And you remember, cleaning like the, you know, how the stand-up showers and that, there's part of the basement? There's that shower. Do you clean that area up too?
Absolutely, that's my ability.
Like with water or whatever?
And that speech.
So you use the speed, that's right, there is speed. And so, that, you look, you saw. Cool. You're feeling, were you anxious, angry, excited?
Well, when I woke up and I seen that this happened and there was like, the environment around me, and I was like, it feels like I'm on a hidden camera TV show right now. And I was like, what the, yeah, I was going crazy. So, I was really pissed off and freaking out a little bit.
Yourself?
Yeah, very much so. One, the victim was like my friend, right? And two, it's it was an open area.
You said,
Very open area. I didn't like that one bit. The dismemberment process was awful.
yeah. Can you go into a little bit more on that? Yes, actually, before you jump into that? Sure. Were you cleaning up so that you would get thought?
Well, yeah, to the best of my ability, I almost like called on myself like 4 times, but I'm like, there's no fucking way. There's people upstairs.
Sure.
There's people upstairs. I'm like, how am I gonna get away with this at all?
Is that one of your thoughts when you're
Yeah.
chopping them up?
Yeah, I was just like, there's no way I'm gonna get away with this, and now I'm fucking screwed.
And that's part of the reason you put them in different bags or cleaning up, is that correct?
I was cleaning up, but then, like, when I said I was tripping out, the body looked like it was rebuilding itself because I already cut off his arm, and his arm came back on. I'm looking at this, I'm like, there's no way. There's no way, you know? And then, and I'm like, am I that high?
Would you cut it off again?
Yeah,
So,
and it took forever. Oh,
yeah, I know Sean, but one of his arms had where you cut it. We never cut all
yeah. It's weird because I cut it all the way off. And then, that's, I'm just saying that, like, I don't know.
of it. Was it easily moved now because he was a bigger guy than you?
Because I'm looking at this, I'm like, how do I get Shad out of here? Can't just leave Shad here and be like, hey mom, Shad's dead. So, yeah.
And Detective Graff, the portion of the video that we just watched from the February 28th, 2022 interview, does that accurately reflect a portion of your interview with Ms. Schabusiness on that date, February 28th?
Yes, it does.
And Detective Graff, after
And
that
I would move
interview,
for then formally move for the admission of
Would you?
Exhibit 110.
I mean, would you though?
Yes, I would.
Laura, can I confer with Mr. Lissay for 1 minute?
I just keep expecting that detective to drop down to one knee and propose to her right there in court. Let's see. Chinnator says, Nick, I was dying last night at the freeze frame of your face when you lost power. And when you came back to tell us you lost power and boomered it. Yeah. Yeah. Romo Drummer
That'll be
sent several
received.
super chats. Says, I think they are trying to make it loud enough for the people in the court to hear. They don't realize it's also being streamed. It's raping our ears.
The February 28th, 22 interview, whether
Maybe
Ms.
they'll
Schabusiness
dismember us after
mentioned
that.
having any contact with Stephen Hendricks during this incident.
I recall that.
The guy in the background does look like Richard Spencer.
Recall correctly, I think at first she didn't mention that, but then later on she did.
And the contact relative to the eyeglasses?
Oh, yes. She did mention that at one point she did go up into the kitchen and had contact with Mr. Hendricks and borrowed some glasses. Yes.
I have no further questions for Detective Graff. I don't know if the court wishes to take a break before cross-examination.
We will. Ladies and gentlemen.
Who's in charge of this goddamn courtroom?
I'm going to ask you to be back here in the jury room. We'll take an hour and 15 minutes. So try to be back shortly after 1:05 or so. So then we'll get underway promptly. Right? And all rise for the jury. Anything to bring up before we recess for lunch, Mr. Saunders? No. Mr. Fraley?
No.
Can I ask Mr. Saunders, or Mr. Lozay, either one, do you have a sense of how many more witnesses do you have? Or is this the last witness?
This is,
Yes, it's our last witness.
Then probably what I'm going to do is distribute a draft of proposed jury instructions so that you can start taking a look at that. My judicial assistant is out, but I'll try to have those on your desks by the time you return. Okay? Very good. Then we are in recess until 1 o'clock.
Your Honor, there is one other issue. The defense then would have Scott Tomes as a witness, but apparently he's unavailable. And I have him under subpoena. You know, the timing of his unavailability is suspect for me, but I've conferred with the prosecutors and they've advised that he is simply not available. So what we talked about was talking about potentially some agreed facts that could be presented to the jury. It's an unusual situation for me to be in, but you know, as a lawyer, when you issue a subpoena, people are expected to appear. So I'm caught in a difficult spot.
Well, you can address it to me when you come back at 1 o'clock, okay?
Okay, thank you.
Very good, we're in recess.
Thank you.
All right. We're on that lunch break. Oh, I'm sublimely happy for today so far. The rest of the trial today could go to utter shit and I would still be sublimely happy. Very fantastic. Very, very fantastic. To get that interview in at the end. It was really hard to hear. So I tried to balance the audio. I have a volume booster on Chrome because the court audio is always so low. And so I have this thing boosted like 400%. And I had to drop it to 250 for the court or for the interview audio. And I probably should have dropped it below that, but it wouldn't have helped the distortion at all. So I kind of I didn't want to keep fucking around with it. The distortion was because I think two factors. Three. One, it's in a bare room, drywall or cement walled interrogation room. The camera is located somewhere obscure because it's not obviously visible, or the microphone might be on the camera, might be under a table. It's not obviously visible. They don't want people thinking about being recorded because the government is awful. Repeat after me. The government is duplicitous in the actual use of the word, lying, manipulative fuckers. Always. They are always like this. They are terrible. They want to pay homage to the fact that you have rights rather than actually respect the fact that you have rights. So they don't want you to realize that you're being recorded. They want you to loosen up and just talk. They want you to self-incriminate. They can't force you to. They just can set everything in the situation up to make you self-incriminate, including lying to you about what they know, lying to you about what their intentions are, lying to you about what kind of thing will help you out versus harm you. Oh, yeah, it'll be much easier. You'll be just fine. You just work with it. You just tell us what's going on. This will go way better for you. They can lie to you about everything. I know that most of the people being interrogated in these things have done something bad. I get it, but fuck off with that excuse. Do not simp for your government. You are the boss of your government, not the other way around. The fact that they even have a police force is something we should barely tolerate. All right. So, sorry, I got off track. They hide the microphone because they don't want you to think about it. Okay. So that's the first thing. Bare walls, no acoustic dampening, no sound absorption at all. Because why would you do that? I mean, if you have padded walls, you can't slam people into it and have any sort of good effect. So you want to use those bare walls, hopefully brick or concrete, in case you need to rough up your suspect. Reminder that they do this all the time also. Not every cop, not every interrogation, but enough of them that it should fucking concern you why they don't just pad the walls. Just pad the walls. Better audio. Less chance of actually causing serious injury. Anyway. Next problem you have. The actual video playback that they're using VLC, which is a great open source video player, VLC, they have it cranked all the way to the maximum, which means they're not at 100% volume. They're at something like 150% to 200% volume, and that's going to add distortion to the video playback. And then finally, I don't think the VLC was being purely fed into the court audio stream. I'm pretty sure it's being picked up by a microphone listening to the speaker system in the court. So those factors are what's contributing to the absolute dog shit tier audio quality that we were getting during that interview. So, oh yes, people have asked me about my shirt. Here, let me show you without showing you that I'm not wearing pants. It's an incognito corgi shirt. I got it at Anime Matsuri last year. So. They had a couple corgi themed shirts. I got 2 for me and 2 for Lady Rackets because they're funny. I would never want a corgi because I don't really care for owning dogs. Like, I grudgingly like my pug because it's kind of cute. And it's stupid, right? Like, that's the thing with pugs. They're never looking at you. They're always like looking around you, and they're dumb. They just sit there and their heads are like solid domes. So they run into shit and they don't care. But I would never want a dog at all. I'll tolerate them. It's fine. But corgis are fucking funny because they got those little midget legs, but they like have the attitude of like a tough dog, like a big dog. Anyway, so yeah, I like them in concept. I like them in concept. Let's see. Let me get these super chats. And then there's a couple left here. And then we'll start talking about some of the elements of this case that I think are really interesting. This is part of watching trials for me, is that there needs to be something particularly salacious or interesting about it. So, Kyle Rittenhouse, very politically charged, right? Obviously. Johnny Depp, Amber Heard, huge celebrity dispute, defamation of a celebrity. Is it even possible these days? Is it possible through these very obscured and protected and laundered statements? These are very interesting things. Plus the idea of physical abuse in a relationship actually being from the female side, showing that that's a real thing that happens. It's a danger for men out there. And then plus the absolute incessant gaslighting of our current society in the male-female dynamic. It was impossible to think about this. Even though we know that Amber Heard chopped off part of Johnny Depp's finger by throwing a bottle at it. We know that happened. It was unfathomable that she could have been the abuser in the relationship for so many people, because they're so ingrained in this idea that women have no ability to abuse men. So the fact that she was not only an abuser physically, but she was an emotional gaslighting abuser, and that those gaslighting statements continued to the point where she convinced the entire world that he was abusive towards her and that she was a proper representative as a victim of domestic violence. Like, she went so far in her abusive, manipulative gaslighting of this man that she became a representative of domestic violence victims publicly to the fucking government. Like, imagine that is how far your abuse goes, that you will beat and scream and degrade and deride one of the most famous and objectively successful people on the planet to the point where he is a simpering loser in your presence. And then on top of that, to put the icing on the cake, to put the cum on the creamsicle, you will then go on to represent yourself to the entire world as a victim of domestic abuse just to further fuck him while he's down. Amazing. That is shockingly amazing. The fucking testicles on that woman to do that. And everybody's just like, oh yeah, Johnny Depp must be the most awful person in the world. And then when you get into it, you're like, actually, you know what? I think Depp is kind of a broken savant. You know, he's got some damage going on, dealing with depression. He seems to be representative of this idea of the the tortured genius, right? All the success, but none of the satisfaction. Like he's got all the money in the world. He's resorting to drugs. He can't seem to get past these dark thoughts and experiences. Attracted to a woman and suck with her who will abuse him, despite having like literal gems in his past, like Kate Moss and stuff like that. He's with this monster. I mean, it's a telltale of stereotypes. A beautiful case, right? You got What the Business, Daryl Brooks, hilarious. You got the guy who shot the attorney, clear murder, but arguing self-defense and then trying to make it into a race thing. All of this stuff is built in. Schabusiness has tons of great elements. You've got this very salacious and violent act, inconceivably dark, going on. You've got the like serial killer element, dismembered bodies in different parts in different places, drugs being a thing, sex kinks being a thing. And now you've got weird questions about potential overcharging, even of this person who is despicable in the act that she committed. But we go, wait a minute. Or I go, maybe you don't. I go, is this murder one though? Like, is this murder one? And I don't think so. I don't think this is murder one. So let's pull up the Wisconsin murder statutes and we'll take a peek. I think that's what we got to do, right? Like discern what's going on here. Wisconsin murder statutes. Let's take a peek here. So she's charged with first-degree intentional homicide. Let's here we go. Here we go. First-degree intentional homicide in Wisconsin. Except as provided in subdivision 2. Whoever caused the death of another human being with intent to kill that person or another is guilty of a Class A felony. Okay, so this is, do you intend to kill that person? Or do you intend to kill someone else and end up killing this person? So the way you can kind of figure this out, you point a gun at someone and you pull the trigger, you intend to kill them. That is an intent to kill. You go, I'm going to make the decision to kill this person. Now you point the gun at like a hand or a leg, you're not necessarily intending to kill, but typically speaking, center mass, head, we're manifesting an intent to shoot at this person. Now, maybe you reflexively pull a gun, like someone startles you and you shoot them. We're talking about a very clear, you point a gun at someone, you have time, you pull the trigger. Does it mean you woke up that morning wanting to kill someone? No. You act with the intent to cause death. That is the key. All right. And that can manifest in a lot of ways. Now, let's say you point the gun at someone. You're going to kill them. That's your choice. You pull the trigger. They're a ninja and they dodge and you shoot the person behind them. Same thing. You have intended to do the killing. The killing just happened to get someone else. Okay. So that's what you've got in this scenario. And by the way, someone asked me earlier, if I just sang a line from Backdoor Lover from the Josie and the Pussycats movie. Yeah, of course I did. Backdoor lover, coming from the back with the lights down low. I mean, it seemed appropriate. I just wanted to clear that up. So then in B, except as provided in subdivision 2, whoever caused the death of an unborn child with intent to kill that unborn child kills the woman who is pregnant with that unborn child or kills another is guilty of a Class A felony. So again, And this is not applying to abortions here. What we're talking about is someone who, goes up and punches a woman in the stomach with the intent to kill the child, or stabs the woman in the stomach, or feeds her abortifacient drugs surreptitiously, something like that. Something to cause the death of this child, not like consensually with the mother here, but this is a killing. Or if they kill a pregnant mother and, they're, cause the death that way too. So there you go. All right. Now, mitigating. Drew Dastardly, you better stop. Mitigating circumstances says the following are affirmative defenses to prosecution under the section, which mitigate the offense to second-degree intentional homicide. Okay. So now we've got the elements of the crime. First degree is that you intend to cause the death. And that's critical here because I don't think Schabusiness intended to cause death. I think she realized incidentally that death was occurring and did occur. But I think that interview seems to be pretty clear that she wasn't intending to kill him while choking him, right? She admitted to stepping on the gas while choking him to see what happens. But did you hear her? She said, I swear he looked up and said, keep going. I swear he looked up and said, keep going. So it did. The detective also asked, did you know he would die? And she didn't answer yes. To me, I think there's plenty of argument that she did not intend to kill him, but that she did. Now, we're going to get to this. We're going to get to this, though. This does not mean, by the way, she's not guilty. This just means, to me, I don't think she's guilty of murder 1. All right, so here we go. Mitigating circumstances. Adequate provocation. Death was caused under the influence of adequate provocation as defined in section 939.44. I'm guessing this is going to be like a fight type thing. So means adequate means sufficient to cause complete lack of self-control in an ordinarily constituted person. Provocation means something which the defendant reasonably believes the intended victim has done, which caused the defendant to lack self-control completely at the time of causing death. So we're talking, this is, you see something going on that would drive you into a blind rage type thing. So you intend to cause the death, but you wouldn't have intended to cause the death under normal circumstances. So you walk in, you think you see someone assaulting your wife, right? So you kill the person in a blind rage. But they weren't assaulting your wife. It was an affair. And you're not fully, like, it wasn't obvious that they're assaulted. Like, your brain rationalizes the affair or something. Okay. You could see, like, this type of thing going on. Or an unreasonable response to a misperception. Where it's not a perfect defense, right? Like, if you legitimately believe, and it seems reasonable to a reasonable person that someone is assaulting your wife, you could use reasonable force up to and including deadly force under the circumstances to do so. But if it's not reasonable, that's just your subjective perception. You can have an imperfect defense. Maybe you're under the influences of drugs or alcohol, something, because it does say an ordinarily constituted person. All right, so unnecessary defensive force. Death was caused because the actor believed he or she or another was in imminent danger of death or great bodily harm. The force used was necessary to defend the endangered person if either belief was unreasonable. So again, self-defense and deadly force requires a reasonable belief. The objective standard, a reasonable person believes that someone is in danger of imminent death or severe bodily injury. You can have and you also have to have the subjective belief. You have to have both. If you only have the subjective belief because your perception of reality is skewed in some way, then you don't have a perfect self-defense. So now it gets mitigated down. Prevention of felony. Death was caused because the actor believed that the force used was necessary in the exercise of the privilege to prevent or terminate the commission of a felony, if that belief was unreasonable. Same thing. Coercion. Death was caused in the exercise of a privilege under section 939.451. So let's see what this says. When the actor's conduct occurs under circumstances of coercion or necessity so as to be privileged under these other sections. Okay, we're not gonna go through that. All this shit, but they have a belief that they're privileged to kill, but they're not. Okay. So this is affirmative defenses. Now, when the existence of an affirmative defense under sub 2 has been placed in issue by the trial evidence, the state must prove beyond a reasonable doubt that the facts constituting the defense did not exist in order to sustain a finding of guilt under subdivision 1. Okay, so this is murder 1. All right. Let me get murder 2. Second degree intentional homicide. Whoever caused the death of another human being with intent to kill that person or another is guilty of a Class B felony if the state fails to prove that the mitigating circumstances did not exist. The state concedes it is unable to prove mitigating circumstances specified did not exist. And prosecutions under sub 1, it is sufficient to allege and prove. Okay, wait. So this is not what we want. This is only the mitigating circumstance. I think we actually need, second degree or first degree reckless homicide, maybe. Recklessly cause the death of another human being under circumstances which show utter disregard for human life is guilty of a Class B felony. Whoever recklessly caused the death, blah, 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 of another human being under the following circumstances: by manufacture, distribution, or delivery of a controlled substance. So this is if you are, let's see, this is if you're a drug dealer. This is if you're a drug dealer and you sell someone drugs and they die from it. That's reckless homicide in Wisconsin. I personally disagree that this should be a murder crime at all. Look, I'm not a drug dealer. I'm not a fan of drug dealers. Drug dealers tend to involve pretty shady characters that get into a lot of shit. That being said, you sell someone drugs and they make the choice to take too many drugs, right? Did you do too many drugs? I did too many, right? Like, that's not on the drug dealer. The drug dealer isn't at fault. Now, maybe the drug dealer dosed it, like cut it with fentanyl or something. I don't know. To me, that's a buyer beware, right? That's on the person ingesting the drugs, not the person dealing the drugs. You're choosing your shit. That's my opinion. Now, yeah, I think you can manifest intent. See, and this goes towards intentional homicide. You give someone a hot dose, right? You're like, this motherfucker hasn't paid me. Oh, yeah, I'll lend you. You can get me next time. You give them a hot dose. They go and they die. That's different. That's you intending to kill them. That's you causing the death of another person. Incidentally selling drugs and someone takes too much, my opinion, should not be a specified crime. Get them on the drug dealing. Sure. Distribution, that's their fault. That's a felony. They can be punished for that. I just don't agree that it's murder to me. Just my thing. That's my thing. By administering or assisting in administering a controlled substance. Okay, so here is, this is where I think she could fall. So I guess it's still technically murder 1. It's just reckless. She's charged with intentional homicide. Reckless homicide. Did you know that choking him could kill him? I mean, I guess. Reckless disregard. To me, this is all the hallmarks of a reckless murder, right? He's sitting there, his face is going kind of purple, his tongue's out, he's coughing up a little blood, but he says, choke me harder, big mama. So I keep going. All right, cool. I mean, do you think that could kill him? I mean, I guess you could kill him. I didn't want him to die, didn't mean for him to die. To me, that's reckless homicide. Now, people are like, why do you believe her? Okay. To the people who just watched that interview and say, why do you believe her when she says she didn't want him to die? You tell me what part of that interview that you watched that indicates that she's lying about anything. She told them everything. She didn't seem to hold back. It doesn't seem like a devious plan here. She walks in there. She said, well, I didn't mean for him to die, but then he did die. And then I was like, what the hell am I going to do? There's people upstairs. How am I going to get out of here? I'm going to chop up the body. Okay. Remember, dismemberment after the fact isn't proof of intent to kill. The state bears the burden to prove that the dismemberment is an actual precursor to the killing. The state has to prove that the dismemberment applies beforehand. They can't just say, well, she dismembered him, so she must have wanted to kill him to dismember him. The state has to show why. Now, is it possible that dismemberment is the intent of the murder? She wants to take a trophy. She wants to do this. She thinks it'd be interesting. She wants to do amateur anatomy. Sure. The state has to prove beyond a reasonable doubt that that is connected prior. You don't get to post facto assume intent because something weird happens after. Do they have evidence that she wanted to chop up his body? Now, they're trying to do that with the Jeffrey Dahmer searches. They're trying to do that. I mean, that's their purpose here. I don't think that they've adequately shown that the Dahmer searches are relevant. I think, personally, they would need to connect those Dahmer searches in a specific way. The judge disagrees with me. That's fine. The jury may decide that those Dahmer searches manifested the adequate intent to get to the dismemberment after the murder. I think that's an injustice. I do not go that far. I'm not the jury. My opinion doesn't matter in this case. Okay? So to be very clear, my personal opinions on what is proper and just and constitutional are often different than what a court does. I think more in the lines of a defense attorney. Clearly, her defense attorney thought the same thing. He objected to those things being included for the purpose that it was prejudicial, not probative. We're saying the same thing. Judge disagrees. Okay, cool, fine. Personally, I believe that they would have to show a link between Dahmer and the intent to commit a crime, not just incidentally say Dahmer is the intent. I think that's way too far with Jeffrey Dahmer. Were it a more obscure serial killer, or a pattern of serial killers that had the exact same thing, I think you could start to build it out. And there's an argument that this matches some of Dahmer's MO. I got that. I understand. I'm just saying my personal opinion on this. I think it's more prejudicial than probative, absent something else linking it to the crime specifically. That's my opinion. So here, though, they have to prove intent to kill, not that she killed him and is now like, what do I do with this body? Let me pose some scenarios. If she kills him and goes, oh, fuck, I'm scared. I don't know what to do. How do I get rid of this body? Chops him up. Is that intent before the killing? I don't think so. If she kills him and says, oh shit, he died. Well, now I have this body though. What do I do with it? I mean, how often are you going to have a fresh deady on your hands to bang, right? Or cuddle or chop up or play with? I don't think that proves intent either. The state would have to prove that she intended the kill to get to the dismemberment for the dismemberment to justify that killing, which seems circular. And yeah, kind of. But it's only circular absent the actual proof, right? That's the trick. The state's logic that the dismemberment necessitated intent to the kill, that is actually circular. There is some other element that needs to get there. And maybe that element is entirely in her head, and maybe it's true, but we can't prove it beyond a reasonable doubt absent evidence that it exists. You have to only infer or presuppose the answer. This is why I have a problem with murder one, intentional homicide. Reckless homicide seems perfectly acceptable here to me. And all it means is she doesn't get life without parole. It means she gets life with the possibility of parole. Minimum 20 years in prison, possibly more. Are Jeff and I ever going to stream together? Is he going to vibe on his own? On this trial, no, he promises chat that he's doing, bell-to-bell coverage on it. So on this trial, it's possible I might join him. He won't join me over here because there wouldn't be a circumstance for me to invite him. He'll be streaming. I mean, if something happened and for some reason he got a strike or something, he'd be welcome here, of course. But under foreseeable circumstances, no. Now, if I'm not able to stream like a full day and only have an hour or something, I'd pop on Jeff's show in a heartbeat. Okay, so that's just my opinion on this thing. I do not believe we have a first-degree intentional homicide here from what I've seen from the state. And again, I have no reason to disbelieve Taylor Schabusiness in that interview room. She talks about killing him. She talks about chopping up the body. She talks about sexually vandalizing his corpse. She talks about doing a bunch of drugs. She talks about all of the things that you would allegedly not say if you had any motive to lie. And if we're going to assume that she's lying about just this one thing, we have to impute upon her an unreasonable level of forethought into this testimony that she gives while allegedly high in a post-kill haze, while she's also apparently retarded based on how she talks, answers questions, and acts generally. I just don't see it. And if you do, that's perfectly fine. I'm just telling you why I don't think it's appropriate. Obviously, everybody gets to come to their own conclusions. The jury will come to their own conclusions. It's not for me to control decisions in any way. I'll just say what I think. And that's me. Did she do this? Obviously, she did it. She admits to it. She's guilty. I just don't think intentional homicide is the right charge. Now, can she get convicted of a lesser offense than intentional homicide? Yes. I don't know if first-degree reckless homicide is lesser included. Not sure how Wisconsin does this, but I would have to assume that that's a possibility. So, that's my personal perspective on this. For people asking about the death penalty, Wisconsin abolished the death penalty a long time ago. She will not get the death penalty. It's not an option. It's not on the table. But yeah, that's my opinion. Okay, so one more thing on this that I want people to consider. Reading the law very specifically causes the death of another human being under circumstances which show utter disregard for human life is guilty of a Class B felony. To me, this again goes right towards the drug use, the incidental, thought, the dark takeover of someone under mitigating circumstances of their own capacity. But there's circumstances that they voluntarily put them in. if you know anything at all, the most basic stuff about BDSM community, right? Guidelines. Consensual. Obviously, you're toying with things that are associated with pain, control, or humiliation a lot of times. So the consent part is critical. Otherwise, you're just assaulting people. The other part of it tends to be safety and lucidity, right? Some of these things are inherently dangerous. Asphyxiation concerns, blood constriction concerns with stuff like ropes and restraints. They use ropes that tend to, not all of them, they use ropes that tend to be softer, more pliable. It's about the restraint, not about an inability entirely to escape. And they also recommend having things like shears or whatever on hand in case things get out of control, in case knots are unable to be untied, stuff like that. Because various constriction in the wrong spot, like if you constrict the leg too much in the wrong spot, you could cut off the femoral artery's ability to move blood. You got a problem. Which you wouldn't expect, right? No rope around the neck. It's just around the leg. Well, suddenly you're choked off and you die. Bad thing. So lucidity, substance-free environment typically is preferable in these situations. Recommended even because you're dealing with causing the right amount of pain or the right amount of restraint or whatever that is. To elicit pleasure, not to actually cause damage. So you've got circumstances here that show utter disregard for human life. You're on multiple mind-altering substances. You've got an asphyxiating chain, and you're applying it in a way that goes beyond what most people would consider reasonable, even within a hardcore BDSM community. When someone's face is purple and they're coughing up blood, I don't think you need to wait for the safe word at that point. Like, I think it's like, well, all right, you're good though, right? That's the idea. Anyway, so I think this falls under first-degree reckless homicide. I think the intentional one is due to the salaciousness of the acts, the gore, the sensationalism of it, and I just think it's overcharged. So that's my thing. And for everyone who says you can't talk when you can't breathe, I beseech thee to invoke a prayer to Saint Floyd and ask if you can talk when you can't breathe. But she cut him up though. We covered that earlier, but she cut him up. Again, that's a separate crime that she is charged with. Nick, I'm with you on this one, but this woman did some phone box worthy activities, which actually, and that's part of this defense. The defense that she's going for is not guilty by reason of insanity, that she should be committed to civil, to a civil confinement for therapeutic psychiatric care. Presumably, at that point, she could be released when found to be treated, if ever. She'd be involuntarily committed for that thing. If she's not guilty by reason of insanity, she's not out automatically. She would have to be treated and deemed safe to return to society, no longer a danger. She'd probably have to go to drug rehab. She would have to show like a continued commitment to that rehabilitation. Also, mental health care until she were deemed no longer subject to the ailments which led up to this. I don't think they win on not guilty by reason of insanity, but I do think the insanity brings us to first degree reckless homicide. Cause I think the argument is obviously she's a temporary insanity. And what they're going for based on the arguments I've seen from the defense is this idea that a combination of prolonged extended meth use leads to brain damage that is undiagnosed. Very big weakness in the defense case. Undiagnosed brain damage, along with being on multiple mind-altering substances, the trazodone and the methamphetamine at the time of the killing, put her in a state of mind in which she could not manifest the requisite criminal intent to do this. Again, I don't think that defense flies as a not guilty verdict, but I do think it merits dropping to first degree reckless homicide versus intentional homicide, or maybe even second degree. Let's check out what second degree reckless homicide is real quick, because that might be a specific thing here. So this is just whoever recklessly causes the death of another human being is guilty of a Class D felony. So as opposed to, wait, where'd we go for the first degree reckless? Under circumstances which show utter disregard for human life. I think this is first degree reckless though. The choke chain, her seeing the face turn purple, coughing up blood, that's reckless with utter disregard for human life. Reckless homicide. So recklessness is this, generally speaking. Recklessness is creating a situation which could put people into death or serious bodily harm, and then acting in such a manner that actually occurs. That's recklessness. All right. So you have to create and be aware of the situation you're creating. So again, I know the drug thing is dealt with from the drug dealer aspect. Well, I mean, it's distributes or administers, but ignore the drug thing as a special crime, because it would be a really good illustrative crime of recklessness to give someone drugs and then to give them more drugs and more drugs and more drugs, knowing that eventually, like, the dosing would get too high and they could die from it, from an overdose. So you're creating this circumstance where things are getting increasingly dangerous. You know you're increasing the danger, and then they ultimately die from it. That would be a great example. If there wasn't another statute for it, that would be a great example of creating this scenario that allows death to occur. Utter disregard for human life is when you do something in that way, but specifically disregarding human life. So pointing a gun and shooting it in a direction is reckless. Pointing a gun and shooting it in a direction where there's a crowd is reckless with utter disregard for human life. Okay, so if I take my gun and I shoot into the woods, I can't see anybody. I don't know. I'm like, aha, blam. I just shoot into the woods and it tags a hunter. Well, that's reckless homicide. Now, if I know a group of hunters is this direction and I point my gun and I shoot to scare them, that's reckless with utter disregard for human life, right? I know this bullet has I should reasonably know that this bullet has a potential to hit these people that I'm shooting towards. So that's kind of the two circumstances, a way to kind of rationalize the idea or difference between these things, because it's not always obvious what that means, but trying to analogize and help you guys discern what the, what that difference is. I hope that is helpful for you in doing that. Okay. So some news unrelated to Schabusiness while we have a break. Apparently the Hunter Biden plea deal has been canceled. Now, if you have not been following the Hunter Biden plea deal story, he has he's pleading guilty to a couple things. One was this lying on his firearm purchase form about being a controlled substance user. The others were pleading guilty to this tax evasion, intentional tax evasion. And so what he would get as a part of this deal was deferment of any prison time, and sort of a payment plan on the taxes. But the prison time would be off the table. That has been undone now. That is no longer an option. Now, I don't know the exact reason that the story is unfolding, but late yesterday, the story broke that the day before or the day of the plea hearing, I was going to talk about this last night. Someone from Hunter Biden's law firm that he hired called up the court pretending to be from a different law firm that had filed amicus briefs in the case. So that's not acceptable. And when they pretended to be this other law firm, they were trying to withdraw the amicus briefs that had been filed. Now, an amicus brief is a friend of the court brief. So it's someone who is not a party to the case, but has some tangible interest in the outcome, not for or against a particular party, but incidental to it. So you to visualize this, if there's like a big First Amendment case involving a YouTuber, right? In theory, I could file an amicus brief because the outcome of that case could potentially impact how I do business. I would want to protect speech, be against like a frivolous lawsuit about it, et cetera, et cetera, et cetera. And so I could file a brief to the court on why I think the court should determine, one way or another on issues in the case. I don't know the details of the amicus briefs that they were attempting to retract. I don't know anything about that, but that is highly unethical behavior. That's making a misrepresentation of the court. It violates your duty of candor. And it seems to have for the purpose of impacting ongoing litigation. Very, very bad stuff. My guess as to why the plea deal is now invalidated is because of that. All right, I'm going to end this poll here. So on Taylor Schabusiness question on the TQ, 27% of you would smash. 72% of you would not. So there you go. Lisa says she was only a clerk, right? Allegedly. And the judge gave the other party the opportunity to show cause as to why this happened. Did the clerk act on their own? Was it rogue? Were they ordered by an attorney? What did they do? I don't know how that has turned out. I don't know if they have answered the judge. I don't know what has happened, but whatever the case, here's the thing with a law firm. The lawyer's professional rules apply to your employees as well. So your employees that are reasonably attached to the firm itself. If you are an attorney and you hire a paralegal, you cannot just say my paralegal did that, it's not my fault. You have a supervisory obligation to make sure that that paralegal is following the same professional standards that you are held to. You don't get to just shield yourself with the clerk. A clerk of the law firm is held to a lawyer's standards when acting on behalf of the law firm. Now, could there be evidence that that clerk was otherwise coerced? Maybe some other party kidnapped the clerk's child and made him do it. Is that the law firm's fault? No. Maybe the clerk had a love affair with Hunter Biden and he asked the clerk to do it. Is that the law firm's fault? No, but is it Hunter Biden's fault? Yeah. Maybe, turns out the clerk was bribed by the party they were posing as, and that's why they did it. Okay, you got all different kinds of things here, but generally speaking, a clerk is responsible, or the clerk is not responsible, but the lawyers supervising the clerk are responsible to make sure that clerk is acting in a way that they are holding to the same standards. And you can see why this is obvious, right? Because if every law firm could just say, well, it was just a stupid clerk, they're new, they didn't know it'd be silly to pose as opposing counsel. I mean, none of us would have ever ordered the clerk to do that. That's crazy, Judge. I mean, why would any of us, we're esteemed members of the bar, why would any of us be a lying scumbag who coerced a lower employee who doesn't have to follow the same ethical standards as us to do this thing? I mean, that'd be crazy. So obviously, lawyers in the past have thought through this. how can we do this thing without doing this thing? Right? Like this is this is why this would happen, right? So again, the judge gave them the opportunity to show cause. I don't know that they did. I assume as the story develops throughout the day, we'll get some the court will justify its removal of the plea deal. So that's very interesting. Also, breaking news, apparently Kevin Spacey has been found not guilty on his on all charges of sexual misconduct. Kevin Spacey keeps on winning. His alleged victims keep on dying. But apparently he's not guilty. Does that mean he did it? Didn't do it? I don't know, but maybe now I can watch American Beauty again. Can I just watch American Beauty again without being accused of like endorsing Kevin Spacey raping and murdering people? Can I just do that? Can it just do that? Do any of you want to accuse Kevin Spacey? I don't think so. You get Schabusiness. You'll get Schabusiness. A sneeze? Lights, come on. It's gonna go. Ah, damn it, went away. Oh, God. It's happening to me. Okay, so let's get back to the super chats here. I hope that kind of covers my thoughts on the case currently. Yeah, and I try and answer questions as they come up too. But Sigrun Eterna, Aeterna, Sigrun Eterna has dropped a chat. Thank you very much for that. And they said, this trial might ruin my friendships. This trial is getting me asked questions about sex, death, and death during sex, and the logistics of both living and dead people that make normal people very uncomfortable. Let me modify that. Makes fragile people very uncomfortable. You are allowed usual suspects, but not American Beauty. That's just bigoted. That's just bigoted. Dark Saber X, welcome to paralegal status. Thank you so much for joining. Rayona 1868 says she might be a killer, but at least she doesn't narc on her dealer. Loyalty to the end. This girl is a queen. Girl's a queen. Ryan Acorn. Oh, by the way, the Kevin Spacey map allegations, I believe, were actually withdrawn by Anthony Rapp, who is the 14-year-old that he is alleged to have molested, played Mark in Rent, along with some other things. He looks like a gay version of Wash from Serenity. If anybody needs to kind of remember what Anthony Rapp looks like. Yeah, I believe he withdrew the allegations. I mean, granted, other people who accused him all died first, but he maybe did withdraw it. So, you know, what's a little death? What's a little death? Yeah, gay Alan Tudyk. Yeah. Oh, here. Here, let me see. I can prove this. Anthony Rapp. Here you go. Perfect. Open image and new tab. Yeah, gay Alan Tudyk, right? There it is. Okay. Okay. Weirdest fucking job. Rayona 1868 says she might be a killer, but at least she doesn't narc on her dealer. Oh, I just read that one. Ryan Acorn, she said she loved him so much that she wanted to kill him while she was choking him. Isn't that the requisite intent, no matter how brief or preceding the crime, to be murder? You can make that argument. I don't take that statement as a serious manifestation of intent, given the other things that she said. Again, my interpretation of that, and take this however you will, is more along the lines of the guy, Lenny of Mice and Men. I will love him and hug him and squeeze him. I was bouncing the most, George, and when I bounced him too hard. Right? Like that's what I get out of this is she's trying to describe that like you just want to crush the thing you want to squeeze it, you love it so much. Not that you actually want it to die. All right? There's a difference. There's a difference. But that's my personal opinion on that. You know, however the facts lay out to you. But see, so if you choose to take that one statement as intent, you have to decide to disbelieve the other statements about her not wanting to kill him. And you have to choose why you disbelieve or believe, one or the other. That's what juries are for. So people often misunderstand the role of a jury. A jury's job is a fact finder, okay? Or a judge in a bench trial's job is a fact finder. So they are presented with two stories. Now we know both of these stories are wrong because both of the stories are biased. One is biased towards party A, the other is biased towards party B. And the truth lies somewhere between the story from party A and party B. And they determine where that truth is by finding out which facts are the most likely actual facts. And we do this through an adversarial system where each party is permitted to argue that their version of the factual events is more correct than the other. And then the fact finder chooses which parts of the story based on what's brought in, what other people see and say about it, what other contemporaneous evidence exists, video, audio, what they believe about the credibility of the parties, the witnesses, all of that gets factored in, and they choose which facts make up the actual timeline of the story. Are they always right? No. Obviously, they can't be. They're making best guesses on individual things leading up to a total picture. So we have competing facts here. I didn't want to kill him. Have you ever loved something so much that you just wanted to squeeze it until it dies? Which one do you believe? Which one will the jury believe? I think, to be very clear, I think she's going to be found guilty of intentional homicide, murder one. I think she's going to be found guilty. I just think the proper charge in this, because juries, this is a very violent crime. She definitely did a lot of it. Juries are inclined to vote guilty on this. It's a recipe for the conviction of the charges presented. I just think the proper charge under the facts I've seen is reckless homicide in the first degree and under Wisconsin law. And I think that should be the outcome. But I think what will be the outcome is intentional first degree homicide. All right. So next, we've got Summer Butterfly. Thank you for joining paralegal status. Leanhart says, so did she say the reason as to why she cut him up, or did she just want a souvenir? It was really fuzzy, the audio. I think she said once she realized he was dead, there are other people in the house. She kind of didn't know how she was going to get out of there. So she cut him up to take him out. But she got lazy and she only took the first box out of the house. I think that's what she said. If she said something different, I very likely missed it. Because she said she was going to go back for the bucket and the cock and ball with the head and the cock and balls in there. But she got lazy. Now, what does she mean lazy? Well, she did just carry a box with his legs up some stairs and outside of the house in the snow. And if you've ever walked outside in the snow in Wisconsin or Minnesota, like, you know that it sucks and you don't want to walk back through. That's weird. She also might've been just happy to get out of the house, like without getting found out and fled. So who knows? That's what I heard. It might have been there could have been something else that I didn't hear. The volume and the audio from that interview is really bad. And there could be some other evidence too. Now, she may take the stand, and I think in this case, when you're going with the insanity defense, I think she should. I think she should take the stand here. She's already sunk herself with the like on the crime itself with the police interview. I don't think taking the stand is going to further worsen her chances in this case of being found guilty. Like, she admits to choking him, she admits to chopping him up, she admits to snuggling and blowjobbing the dead body, all of that stuff. This isn't a mystery. Her excuse is not, I didn't do the things. Her excuse is, I was insane when I did the things. So I think it's going to be on her to show the jury why she was insane, or to try. I don't think she'll succeed. All right. Kitchen Knife Rescue says, hey, Nick, professional knife sharpener here. One of the most common reasons I have to remove bad nicks, chips, and gouges is because someone accidentally hit bone. So I assume that those blades are absolutely trash. Oh, yeah. Well, the tip of one of the knives was busted off. The blades are dull. The blades are probably dull anyway, because as you know, as a professional knife sharpener, most people are absolute dog shit at caring for the edges of their knives. Because, like, well, it looks sharp still. And I guess it crushes the tomato, so that means it's chopping it. But I would guess that those knives didn't look like particularly great knives to begin with, good quality. So they're probably garbage in the first place. But yeah, the from what I understand, the serrations on the bread knife were really, really badly damaged. Nick's Hex says, okay, great. You can watch American Beauty again. I'm happy for you. But when can I listen to Lost Prophets again? Wait, why can't you listen to Lost Prophets? Now, the only song I remember of theirs is Shinobi versus Dragon Ninja, which is a pretty cool song. Am I not aware of the Lost Prophets drama? Are they pedos or something? God damn it. Look that up right now. Lost Prophets. Lost Prophets. Rock band. Okay. They were a Welsh rock band. Well, that was one reason I shouldn't have liked them. In December of 2012, Watkins was charged with multiple sexual offenses against minors, infants, and animals. Lost Prophets canceled all tour dates and disbanded in October 2013 before the end of Watkins' trial. He pled guilty to several charges. In December 2013, he was sentenced to 29 years of imprisonment plus 6 years of extended supervision on license. In June 2014, the remaining members joined American singer Jeff Rickley to form a new band, No Devotion. 29 years? Why not every year forever? What? Can we solve this problem, America? Just put him away for the rest of time. We can have a jail where pedophiles die and just their bodies stay there. And the next one gets to join the corpse. Maybe it'll still be erect and they can have fun. I don't know what they're going to do. Oh, yeah, Welsh. So there's probably in Wales, I guess. Let's see if we can find the crime section. Where's the... Oh, do they not have it? Convenient... Oh, they do have a table of contents. Arrest and band breakup, I guess, is the... There's no audio from the court yet. The transcript is horrifying. God, maybe we'll have to do a live stream about this at some point. Immediately after he was sentenced, the BBC banned the entire Lost Prophets discography from playing on their stations. Holy shit. This guy's crime was so bad, we're not even going to let the music play. Let the music play. Pedos get away. Wow. Wait, look up the password to his computer? Come on. Ian Watkins' computer. Oh, it autofills. No. God damn it. What? Come on. His password was I fuck kids. So there you go. There you go. That's they make industrial equipment for this problem. They make industrial equipment to solve these issues. Whales, get on board. Well, thank you, Nyx Hex, for ruining my enjoyment of Shinobi versus Dragon Ninja. Wow. I'm going to hit the bathroom real quick. I just realized I probably should have done that while Court was out, but if they actually start up, you guys will see it. So I'll be right back. Allah Akbar. Allah. Allah.
Bring the jury in. An issue has arisen which I need to take up with the attorneys. And I'm gonna summarize it briefly. It's relating to the jury. And then we can talk a little bit about it. So my understanding of how the issue has developed is this. This morning, one of the jurors approached the bailiff. The bailiff is in question is supposed to be in the room right now. I don't see her, but she'll be here shortly. Well, I need her to be brought in here. I indicated I needed her in here right away. So the juror approached the bailiff and indicated that he got a text from his buddy out of state who said, "I saw you on television. You're looking pretty dapper," or something to that effect, which raised concerns on the part of the juror that the jury was getting videoed, which of course violates my order. So then the bailiff approached my judicial assistant who's here, and I've indicated to the bailiffs in the future they need to bring these issues to me, not to my judicial assistant. My judicial assistant, hearing this issue, went to the videographers from Law and Crime who were in the back and indicated this is being reported. They apparently indicated that we'd need to know when it was in order to look to see if it happened. My judicial assistant then went back, spoke to the juror to try to nail that down. Again, I've indicated to my judicial assistant that I want all those things to go through the bailiffs to me, but this is how it occurred. And I don't think on the part of anybody involved that there was any malice involved in how this unfolded. The juror then apparently was able to give some detail as to when this occurred. I think it was around or later in the afternoon yesterday, but I don't know that for sure. Some of the details I don't have. And that'll be part of what we'll talk about here in a minute. Then my understanding is that the video has been completely scanned, and there has been no occasion when the jury has been shown across the the live stream or any other place. And that's the state of affairs. This has been developing this morning. And so it would appear, assuming that to be the case, in other words, that the jury never was shown, information is flowing into the jury. And I don't know if information is flowing out from the jury, but clearly I gave the jury instructions as to dealing with information that's coming in. That's the current state of affairs. And so the real question, I think I'm going to turn it over to each side and see if they have a thought about what to do. I have some thoughts about what to do, but I'm going to turn it over to the state first. Is there anything you'd like to address me on with regard to taking this issue up?
Judge, there's a, thank you. Judge, a couple of concerns I think come to mind. First, I'd be interested in knowing, I understand that there's the live stream, but I understand there may also be other sources of media that are here or potentially other individuals who may have done some filming or photography within the courtroom, which I think would violate the court's order, but I don't know that that's not happened. I think it would be helpful to voir dire that particular juror to understand better who informed him of this information. Is that person potentially have other people who could be, other people know that he has jury duty and they might be in the courtroom and then texting him? So for example, there are a number of just citizen members in the gallery. Maybe someone in the gallery also knows this juror and then sent a message to a friend of theirs or something like that. So voir diring, I think, the individual juror to know what was shared, how it was shared, by whom it was shared, might give us a better idea of how the information is coming in and going out from the jury.
Sure. Before I turn to Mr. Freilich, there's a few, your comments have raised a few other pieces of information. First of all, my understanding is in the conversation that occurred between my judicial assistant and the juror, there were other jurors nearby and they heard that that might be happening. And so I think there may need to be some kind of a statement made to the jury as a whole. To some of your other points, we also considered the fact that it could have been a member of the public who was using their cell phone. I've asked security to look at the security cameras to see if they can track down if that's the case. I don't have any feedback from that search yet. But what I can tell you is my understanding is that the juror indicated the feed came across YouTube. Anything can come across YouTube. But the feed is, my order is very specific. There are 3 cameras in this courtroom and there's to be no other cameras. So unless YouTube picked up on a video that was illicitly obtained and then posted it, I doubt that that's the source of the concern. The concern, of course, then is potentially false information is coming into the jury. In any event, the state is suggesting that I voir dire or we voir dire that juror. I'm going to turn to you, Mr. Freilich.
Thank you, Your Honor. All of this raises a question, I believe, of whether my client, Taylor Schabusiness, can get a fair and impartial jury with the jurors that we have. It's concerning. I know that my client has some concerns about this. I'd ask the court to consider a motion for mistrial.
Well, what I can tell you is I anticipated this kind of an argument. In other words, I know I denied a motion for change of venue or to bring in an outside jury. I'm absolutely convinced that there's nothing about this event that couldn't occur in any other jury situation, including had I brought in a jury from the opposite side of the state and sequestered them the entire time. So that is, everyone has cell phones that they have. Everyone gets text messages. And I expect the jurors are going to follow my instruction, which is if someone tries to talk to you about this case, despite your telling them not to, you should report that to me. So the implication in there is you're not prohibited from receiving a text message from a friend about this trial. What you are prohibited from doing is discussing the case, and that your first step is tell them to stop doing that. And if they continue to do that, they're to report that to me. So I'm not going to grant your motion for mistrial because quite honestly, the issue is the same. We need a fair and impartial jury. All these jurors during voir dire have indicated we can do that. This is I'm not even sure if there's been an infraction, because quite frankly, if this juror tells us, I got that text message and I said, don't talk to me anymore about this case, and then he reported it to the bailiff, that'd be precisely what I would want him to do. The problem is it spun a little bit, and it was, frankly, it was investigated. So we actually have more information than we did before. But I'm going to deny the motion for mistrial because I frankly don't see the basis for it at this point. But I think I'm going to avail myself of the opportunity to bring the juror in. Either of you want to, either side want to hear from either the bailiff or my judicial assistant about the steps they took or the things they heard. Mr. Saunders?
I think what I'd be interested in knowing is to the extent that the judicial assistant or the bailiff is aware that other jurors partook in this process or were aware of this process, that's the information I'd be concerned about from either the bailiff or the judicial assistant.
Let me just indicate, again, I've spoken to both of them. My judicial assistant here is here. I'm going to recite what, because she's not near a microphone, but I'm going to ask her to indicate whether I'm reciting accurately. My understanding is when the juror shared this with her, there were jurors sitting there nearby who said, "Are we on TV?" And they were assured that they're not. Is that accurate, Ms. Pigeon? Okay. She indicates, because she's not near a microphone, she told them not to worry, they would not be on any video, which I think frankly was an accurate recitation, because from my understanding is they haven't been on, that my order has been followed precisely by the media, which is what I'd expect them to do. Anything else, Mr. Lezay, from either of the two, the bailiff or my JA?
No, Your Honor.
Mr. Freilich?
No, Your Honor, thank you.
Okay. I'm going to excuse my JA. She can go back and take up her tasks. But I am going to ask if you could invite that juror in to just bring him in. I mean, actually, before we do that, I would expect we would just bring the juror right in here. Is there a request that we do it some other place? I don't know why this would be an inappropriate venue as long as they're not video. Mr. Saunders?
No, that's fine.
Mr. Freilich?
Your Honor, at least for me, I find this kind of to be a little unusual. And I'm concerned that if the juror has to answer some questions in front of a large crowd, it may be more uncomfortable, whereas if we're in a more private space with the lawyers in the court, the judge, it might be a little easier.
Well, I've indicated to the jurors, and they've taken an oath to follow the law, to uphold their oath as a juror. I don't think I've noticed anybody on that jury who seems disinterested or unconcerned or upset in any way about what they're doing. They all seem very intent and very interested in serving in their role. So I'm satisfied that if I brought him in here, they'd answer that is, this individual would answer questions appropriately. And then once, so I'm going to bring the juror in here. After the juror is done, then we'll need to talk briefly about whether or not, and I'm inclined to indicate to all the jurors the circumstance, but we can also determine once we've questioned this juror, the extent of the issue involved. So we're going to bring the juror in now, right here. All rise for the juror. No. So the reason you're in here is because we are responding to a concern that you had raised earlier this morning with the bailiff, I think, regarding potentially having been videoed while you're serving on the jury. And I'm really interested in knowing what you heard because we're trying to get to the bottom of the issue.
Sure. And it was a conversation I wasn't concerned, but so yesterday afternoon.
Sorry, I thought people weren't home. I went upstairs and all my children and my wife are here. It's delightful. So I was talking to them for a minute. Also getting some food.
Trial, and I thought that was unusual. And I'd seen the text when I went back into the room and our phones are. And so I didn't think very much of it. And so then this morning when it was brought up, I had asked him where he had seen it. He had said YouTube.
Juror watching YouTube.
And said that it was streamed.
And when did he indicate? Maybe you said that. What time?
He texted me yesterday at 3 o'clock sharp.
Okay.
Oh, not a juror watching YouTube, but juror was shown.
Questions from the state?
Shown on stream.
Just curious whether he texted you a screenshot or a link, or was it just a text?
Mr. Freilich, any questions?
Did you save the text?
It's on my phone.
So it's on your phone?
Yes,
Did you respond back?
I did.
Okay.
Thank you. Thank you.
Yeah. All right. Anything else that you feel you want to tell me about that event or issue?
No, other than you're free to look at my phone. I'm happy to show it to you. I'm happy to inquire further with him.
Just not in my hidden folders.
As well as a coworker, whatever would please the court.
Okay. I am going to just indicate to you that perhaps, going forward, if you receive any messages from coworkers or friends, that you advise them you can't speak about this case at all until it's concluded.
Sure.
Okay?
Certainly. And my response was, thank you. That's what I said. I can show you.
Okay.
That's just polite.
Okay. I think I'm going to excuse you then. Thank you. All rise. Be seated.
Well,
What
that
was that?
could have been more exciting than it ended up being.
Your Honor, I guess I don't have any concerns about how this impacts the integrity of the jury in any way. It seems like a very limited conversation. I think it is probably a good idea for the court to reiterate to the jury that you have given instructions that they aren't being filmed, just to potentially alleviate any concerns that they might have, and that you're confident that those orders are going to be followed.
Are you confident?
Freilich?
Your Honor, I inquire, how is it possible that a juror in a case like this or any case is seen on TV? And that's concerning to me. I believe that, this juror, even by responding back, which he shouldn't have done, causes an issue for the defense, at least for the integrity of the jury. My client and I are concerned about, this jury, can it be fair and impartial? So I, again, based on what's been discussed here, make a motion for mistrial.
This is not a
I'm
mistrial.
going to deny your motion for mistrial.
Yep.
A couple of things. First of all, I agree that the juror shouldn't have replied. First of all, the juror also indicated that he's not really concerned about it. And I think, one of the main reasons that we enter orders.
These
that
are
jurors
open
not to
courts.
be
If you're
videoed
there,
is so
you
that
can see the
there's,
juror.
For juror security. So.
Like jurors are not
this
private.
individual Apparently wasn't concerned with that.
They don't want them
information.
broadcast to the world, but they're not private.
Secondly, I'm not even certain that it happened. It's hard to drill into why he would get a video from, or a message from a friend in Indiana about being on this case.
Because it's cool.
And, if he wasn't, I can't explain it, but I'm satisfied that that the cameras over which I have control in this courtroom, that being the media cameras, aren't filming the jury. It's possible, I suppose, that someone in the audience used their phone to make that video. I don't have the results of.
Or it was just an accident.
The efforts by security to try to track that down. Hopefully I will get something, but I'm not satisfied that this juror has indicated in any way that this is going to make it more difficult for him to serve on this jury. He indicated he wasn't concerned. So I'm going to deny the motion for mistrial. I intend to just indicate, I intend frankly to do two things. I'm going to again read the jurors the instruction that I've been giving them regarding communication. I think it's important to reiterate that for them. I'm also going to advise them that I've made a specific order that they're not to be videoed.
I thought I had heard that on like the first day that a juror was, the jury was briefly shown or something at some point.
That they haven't been videoed. As part of that, I think I'm going to need to relate to them that a concern has been raised. Only because beyond that, they'll wonder, why are you telling us all this? But that's what I intend to relate to them. Mr. Lizzie, any objection to that? Mr. Freilich?
No, Your Honor, but I have a concern.
Okay.
So.
They
would
showed
the
a witness.
court,
Yeah, I heard that too.
Consider striking that particular juror because we have alternates. The other thing I'm worried about is there going to be discussion about, well, why did the court want to talk to you, to this male juror? have
I
some
do think
concerns
striking
about
the
that as
juror
well.
might be
So will
appropriate
the
here,
court,
honestly.
consider maybe striking this juror, and we've got several alternates.
But a mistrial's no go.
Well, first of all, regarding a conversation the jury might have about why did the court want to talk to you, that's why I indicated I would tell them that a concern has been raised. And they'll get it, oh, it was the guy you brought out here. So, and I don't
I think
the
that's
jury will
perfectly
in any
reasonable
way
to
look
strike
on
this
him
juror,
disfavorably
honestly.
Because he was simply reporting to the court.
My bad, sorry.
The nature of the what you're with that juror.
My bad.
I don't either. I frankly think this juror has
Accidentally hit the back
perhaps
button on my
screwed a little
mouse.
close to my
It's
rule.
my fault.
Instead of responding thank you or asking when it occurred, he should have said something along the lines of thank you, but please don't talk to me on this until this trial is over. On the other hand, friends might feel that's a bit terse to reply.
That's my
but
fault.
I'm going to reinforce that. I think the point is that the reply that he made was so innocuous that I'm not satisfied he violated my order to the point where he would have to be excused. Again, I think the notion that nobody on this jury is going to get any text messages from anybody while this trial is pending is something I simply can't control. So I can't find that in any way would cause me to strike him. And again, he's indicated he wasn't concerned with being shown as a juror, so he hasn't formulated any sort of bias or prejudice as a result of that event. He's just simply reporting what happened, which is what I expect a juror to do. So I'm going to deny the motion. Your
Nah, I
motion is
think you
noted, Mr.
strike this.
Freilich. I'm going to deny the motion to strike.
You've got
it.
4 alternate
That's
jurors.
what I intend
You're
to
coming
do.
to the end of the
Thank you.
trial.
Okay.
Deny the motion or strike the juror. He is
Anything
the
else,
only,
Mr.
he has a
Lezay?
particular
No, Your Honor.
compromise that the other jurors don't have. I think it's valid to strike him here. It's not a mistrial, though. And again, this is a critical thing that people need to remember about jurors. Not broadcasting the jurors to the nation is a courtesy. It's not a right. You as a juror do not have a right to privacy. In fact, if you go attend jury selection on a non-broadcast case, you'll see the jurors, you'll hear their names, and this is done in open court. Anyone can be there. Now, the judge may order that their names are not to be released during the pendency of the trial, of course. But again, that's not a right. That's not a right that jurors have. That's sort of a compromise between this idea that we have open courts, that's going to happen, and we don't want to intentionally exacerbate stress for a juror in
Welcome back, ladies and
particularly
gentlemen of the jury.
notable cases.
And I need to take up an issue with you before we get started. A concern has been raised by one of your number that perhaps at some point in time, perhaps yesterday, that the jury may have been videotaped and put out on a live stream. And a couple of things I want to advise you about that situation. First of all, I appreciate
we'll
the
do a
fact
poll.
that it was reported right to the bailiff, and that's what I need you to do. As a result of the report, the matter has been looked into by scouring the videos that have been taken of this trial. And at no point in the videos that I have authorized to be taken have you been videoed. Just to give you a little more detail about that. In this trial, I've allowed 3 cameras to be utilized. Those cameras are situated in such a location that you're not being videoed by them. When I need to, I look at the media room and I can stop the video feed at any particular time for a particular witness. Perhaps you've seen me do that and heard me do that. I've entered an order that no one in the audience is allowed to use a cell phone to take photos or videos. At this time, security is scouring the videos of this entire trial to see if anybody in the audience has been doing that. I can tell you that I can see everything from up here and I haven't noticed it. And in case you wonder,
I misspelled nothing. Wow,
it's
that's
also
awesome.
being monitored in various different locations. So we're being watched while we're being watched.
We're being watched. There's
People
layers
that
of
are-
pucks
that are
happening here.
videoing it are being watched by the people that are sitting in the security office downstairs. So I want to assure you that order was entered by me. I'm endeavoring to great lengths to make sure it's abided by. And as far as I know, right up until this very minute, my orders have been followed to a T. It doesn't mean I'll stop looking into it. And I would encourage any of you, if you have a concern about that, as we go forward, report it to the bailiff. There's one other thing I want to do because it's important. I'm going to again give you this instruction. You've heard it before and you'll hear it again. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use computer, cell phone, or other electronic device with communication capabilities to share any information about this case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or
It's
off
X
the
now,
computer.
bigot.
Do not permit anyone to communicate with you about this case. And if anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based upon the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decisions in this case. After this trial is completed, you are free to communicate with anyone in any manner. That's all I'm going to have to say about that for right now. I believe the case is still with the state. Actually, we're at cross-examination, however. Detective, I think you were on the witness stand. I'll have you come back. And I will just remind you, Detective, you're still under oath.
For people who are asking what I'm eating, I warmed up 2 hamburger patties that we had from a grill out the other
Also
day.
remind everyone to please
So it's quick.
use their
And
microphone. As you can see, we've
I have a penchant for a nice dipping sauce, which is just anything spicy plus soy sauce. In particular today, it's Cabron habanero
Probably the worst offender. So go ahead.
hot sauce.
Thank you, Your Honor.
Mixed with
Detective
soy
Groff,
sauce.
good afternoon.
Good afternoon.
So on February 23rd of 2022, were you called down to the police department?
Yes,
What time did you get there?
I probably arrived about 4:45 in the morning, I think.
Okay, is that kind of a normal shift for you, sir?
No,
What's a normal shift?
7 a.m. to 3:30 p.m.
And why were you contacted to get down there at 4:45 a.m.?
As far as my duties as a detective, we can get called after hours for major crimes. And in this case, I was called by a supervisor to ask if I would assist in a homicide investigation.
Were you called or did
And
he
were you
reach
in-
over
were
to
you
you
told
from the
that there was a
bed?
minivan that was found parked at the Eastman Avenue apartment complex?
Initially, my initial phone call, no.
At some point, then you were told that there was a minivan that was of interest, correct?
Yes,
And that was parked over at the Eastman Avenue apartments.
yes,
You interviewed several people, correct?
yes,
One being Tara Pakinich, correct?
correct.
And did you also talk to Stephen Hendricks?
No,
Okay.
No, I
Did
never
you
talked
talk
to that fucker.
to Taylor Schabusiness as well?
yes,
You talked to Miss Pakinich and Miss Schabusiness on the same day, fair?
yes,
Did you talk to Miss Pakinich first?
yes.
And was it such that they were down at the police department when you arrived?
No.
Okay. You got there first?
I don't recall if I got there first or if Miss Pakinich was there first, but Miss Business was not there when I first arrived.
Okay. So you took Tara Pakinich into a room, correct?
Yes,
And what did you talk about? The fact that she found something in a bucket in the basement of her house?
yes, of course.
And you followed up with further questions with regards to that?
Yes, I did some preliminary questions, yes.
And did she indicate to you that Taylor Schabusiness and her son were friends?
Yes,
That they went to school together?
yes,
They went to high school together at Bayport?
yes,
And did she indicate to you that how she came upon the bucket in the basement?
Judge, I'm not concerned any of this is particularly prejudicial, but it is all hearsay. Ms. Package testified and he can and did ask these questions to Ms. Package. The statement that the detective took from a witness who is not a party is hearsay information.
Well, it's really not offered for the truth of the matter, Your Honor. It's just to get some background information. But I can move on.
When you move on. So
Okay.
the question's withdrawn.
So after you finished talking to Tara Pakinich, then was Taylor Schabusiness brought in?
yes,
Okay. And initially you introduced yourself, correct?
yes,
And Detective Kemp was there. Is that fair?
that's correct.
Were you sort of the lead detective on this?
Well, initially I was one of many detectives who came in to do the initial investigation, but throughout the course of the investigation, it took a more of a lead role.
Okay. So in the interview room, you swabbed her hands, correct?
Yes,
Did you take any pictures?
I did not.
You offered her some water, correct?
At some point, yes,
And then you told her that a few hours ago, officers went to a residence on Stony Brook Lane and a bucket was found with a human head in it, correct?
correct.
And what was her response? Do you remember?
something to the effect of, oh, really, or something to that.
Did she say that it's pretty effed up?
Yes, that would be correct.
Pretty fucked up, correct? That's what she said?
Yes.
It's a little bit different from oh really.
And did she indicate to you that Shad was her ex-boyfriend?
Eventually, yes.
Okay. And then did you confirm that she lived on Eastman Avenue?
Yes.
Cut Shad up
Apartment 1
into
at
pieces.
2353
He was
Eastman
her
Avenue, correct?
ex-boyfriend.
And she indicated that she lived there with
Suffocation,
Scott
no
Torms.
breathing.
Correct.
And then you had further questions, correct?
Don't give a fuck if it comes while I'm chopping.
You asked her questions about things that may be in the basement. Is that fair?
Yes.
And did she give you comments like, well, that's a good question?
That sounds familiar. Yes.
Did she say that she blacked out at some point?
Yes.
And did she tell you that she needed time to think?
Yes.
And you said, that's not a problem. Take your time, correct?
That's correct.
When you were talking to her, was she smiling inappropriately?
I did not observe that. No.
Did you hear her laugh sometimes during the interview?
I believe so.
He's trying to elicit some insanity evidence here.
Her mood, did it kind of go up and down during your interview with her on March 23rd?
No.
Trying to support her bipolar alleged
There were
diagnosis
two
there.
detectives in the interview room with her, correct?
Correct.
And was there any sort of intimidation towards her at all?
Nothing.
During the time that you talked with her, did she say things that were sort of bizarre?
Well, some of the acts that she described that she did, were something that, was not common, but bizarre. I wouldn't say bizarre.
Unusual? How about that?
Sure.
Okay. And you told her that this was kind of an ongoing investigation and the detectives and the officers and the law enforcement personnel on the scene were trying to figure out what was going on. Is that fair?
Yes.
Because law enforcement really didn't know what was going on, correct?
Absolutely not.
It was, would you say it was a situation that was unfolding and developing?
Yes.
She did indicate to you that did she exhibit responses that were kind of short and snippy?
No.
Did she say that she did not know what was going on?
Well, she did make a comment that at one point she had blacked out. And again, I assured her that she could take her time and she had plenty of time to remember what she did.
Now, you've been on the force you've been an officer for 27 years, correct? You've got a lot of experience. Is that fair?
37 years.
37
yes.
years. Oh, sorry.
I'm sorry, 30 years, then yes.
30 years. Okay. So, and you've been a detective for 17, yes?
Yes,
You've worked with people that have used meth, correct?
I have.
Meth
Have
is a
you
very
used meth?
powerful drug, isn't it?
It can be, yes.
It can cause people to act and react in an unusual way. Is that fair?
Yes.
When you were talking to her, she had some problems answering questions, correct?
No.
She would mumble and trail off when you would ask her a question. Is that fair?
No.
She said a few times, damn, my head. Didn't she say that during the interview?
I don't know if she's referring to her head or
Did
Mr.
she
Therian's.
say it?
You didn't know what she was talking
Did
about.
she
correct?
say it?
On
Is the
that topic?
question.
I don't recall.
Don't be evasive, you
Did she
fucking
tell you
loser.
that she was coming
God!
off a high or a buzz?
No.
I mean, I think she did actually.
She did say that she was paranoid, correct?
She did mention the word paranoid in terms of why she had left the residence.
And she said it was really weird. She made that comment, correct?
I don't recall.
And she said, I think it was the dope. Didn't she say that to you?
She did make those comments, yes.
As far as the investigation was concerned, there were no human remains found at the Eastman Avenue apartment. Is that fair?
Correct. Not inside the apartment.
Correct. There was a minivan, well, strike that. At the apartment, Scott Tomes lived there, correct?
Yes,
And he also owned a gold colored Town and Country minivan, correct?
correct.
When you were talking to Ms. Schabusiness, she did say something about she heard gunshots, correct?
Correct.
Did you hear any gunshots
When?
when you were either at Stony Brook or at Eastman Avenue?
I was never at Eastman, but when I was at Stonebrook very briefly, it was much later in the day, and I did not hear any gunshots.
You reviewed a lot of different reports and talked to a lot of different detectives, including Detective Scanlon, Detective Kemp, Lieutenant Buckman, a lot of the other officers involved, correct?
Yes,
Did any of the officers provide any details or reports about any gunshots being fired at either Stony Brook or Eastman Avenue on or about February 23rd of 2022?
I don't recall who said, but I do recall that during the time that officers were called to the Stony Brook residence, that there was another call that officers were on that might have involved gunshots.
At some other location though, correct?
I'm sorry?
At some other location, not Stony Brook or Eastman Avenue, correct?
Correct.
During the interview that you had with Taylor Schabusiness, did it go on for about 6 hours?
That's an estimate on my part. I'm not sure.
That's fair. That's fair. So you started in the morning and then at some point you took a break because she had to go over to St. Vincent's Hospital.
Yes,
And then you came back and then resumed the interview, correct?
yes,
All at the Green Bay Police Department?
yes.
You had a chance to look at her hands, her thumbs, and her fingers, correct?
Yes.
She had some scratches and some deep cuts on her thumbs and fingers. Is that fair?
She had a cut on her thumb and some scratches, yes.
And she got medical treatment for that?
Yes.
Were there, when you asked Ms. Schabusiness some questions, sometimes she was non-responsive. Is that fair?
No,
She did not answer your question every time you asked one. Is that fair?
I would not say that is correct.
She
Really?
said some odd or weird things though, correct? During the interview? Specifically, well, the arm or something like that would rebuild into muscle.
But yes, she made
Well, I mean-
several comments of,
Yeah,
when she
I
was
mean,
training
well-
Mr. Theory in that, his muscle would rebuild, and made several comments about, that she forgot to leave, or she forgot to leave the head behind in the bucket in the basement. Those types of comments in terms of describing her actions and what she was doing. But in terms of those being bizarre, I did not find that to be
The
in
arm
any way, shape,
muscle
or form.
rebuilding
You
is
found
it
it to be odd
bizarre?
though, especially when she laughed about it, correct?
Well, I did not feel that way.
But she did laugh about it when you talked about it, correct?
I think there would, maybe at one point there was kind of a smirk or something, but it was in the context of just how she replied back to me.
And she did tell you that on some date before February 23rd of 2022, that her and Mr. Therian were smoking ice, correct?
Smoking, yes. Ice,
She-
or
she-
methamphetamine.
Yeah, she used the word bitch, correct?
Fucking hate
Initially.
how cops and
And then it
detectives get
changed from
evasive
ice
on
to
the stand.
methamphetamine. Yes.
Just tell the
Yes.
fucking truth instead of
Then she
trying
indicated
to
that
get a
meth pipe and
conviction.
Plastic bindle would be in the basement.
She said that.
Just tell the truth.
She told you that it was a weird night. Is that correct?
I'm sorry, can you repeat that?
Did she say that it was a weird night?
That's possible.
And then she did talk about drugs, and she talked about the fact that she's been off drugs and then she's on drugs. She said words to that effect. Is that right?
We did talk about her drug use in the days previous to the interview. I believe she did make comments of using drugs in the past. As term of her, how much, I don't recall that.
Okay. And fair to say that during the interview, oftentimes Ms. Schabusiness would say, I don't know. She didn't know the answer to your question.
I'm sure that she probably had some of those answers.
She would say, I have no idea, correct?
I guess I would have to know specifically what I was asking her.
And is it fair to say that some of the things that she said just didn't make sense?
No.
Really?
You sort of had a narrative and she kind of went along with it, correct?
I would not say that, no.
You wouldn't?
I did repeat several of things that she would say to clarify, but I would not say that I led her in any way.
When you were talking to her, oftentimes she'd have her hand over her mouth, correct?
It's possible.
And she would talk very softly, correct?
I was able to hear her.
That's
she
not
did
the
talk softly,
question.
correct?
Just
I know.
answer the question. Just answer the fucking question.
She said something about that she was tweaking out, or that she was tweaking. Do you know what she meant by that?
I do not recall those specific words. I would know what she would mean by tweaking out, though, yes. And I don't recall as to what time period she was talking about either.
Okay. Is it fair to say that the first part of your interview was about 3 hours and then you went to the hospital?
That's fair.
You came back, and then the second part, was that about 3 hours, or how long was it?
I'm not sure.
Not sure. Couple hours though?
Sure.
Okay. Took a while to ask questions and try to figure out what was going on. Fair?
Right. As I was interviewing her, there are investigators who were at the house. And so it was an ongoing and continuing investigation to determine what happened.
Right. During the interview that you had with her, she said, I didn't mean for all this to happen. I'm sorry. Is that fair?
I think that she did make a comment as to initially that she did not mean to kill Mr. Schabusiness. I'm sorry, Mr. Therian.
You've had cases involving asphyxiation, correct?
Yes.
And can you tell me what we mean by that? Is it choking?
Asphyxiation?
Yes.
Choking is another word. Is when someone's windpipe or has been blocked and breathing has been obstructed.
Is it a situation where people that maybe are into this kind of thing choke each other to get some euphoria or pleasure out of it?
I have heard of that practice.
Okay. With regards to this case, law enforcement did find 2 dog collars or 2 chains. Is that fair?
Yes.
During the interview, Miss Schabusiness said something about, I can't think right now. Remember that?
No.
She said, I'm fucking nuts. Remember that?
No.
Just conveniently doesn't remember the stuff that's inconvenient for the state.
Were you surprised by some of the things that she said to you?
Overall, in the context of what we were discussing and the information that had been provided to me?
Yes.
No.
And did she tell you that the body can rebuild itself?
She made that comment, yes.
Just say yes. just so fucking irritating. There's no
There
reason
was a
for this
second
guy to
interview on
lie or
February
evade.
28th of 2022 back at the Green Bay Police Department, correct?
Yes,
And Detective Scanlon was there for that.
he was.
Like,
Did
she's
he
still
kind of ask most of
guilty.
the questions for that interview?
I think it was 50-50 on both our parts.
And did Ms. Schabusiness indicate to you or to Detective Scanlon that she was freaking out?
I do not recall those exact words. It's possible.
Okay. Do you recall though that she talked about having a lot of issues with open areas? Remember that?
But she was talking specifically about the basement area that she was in.
She didn't like the open area though, correct?
No,
I'm correct on that?
I'm sorry.
I'm correct that she did not like the open area. Is that right?
She did not like the open area of the basement at Stony Brook
Okay.
in Green Bay.
Thanks. That clears that up for me. Her emotions came out during the interview. Is that correct?
It's possible.
Did she tell you that she got very angry at herself?
Once again, it was quite a lengthy interview. I do not recall every single comment that she made.
She did say during the interview that there were some times where she nodded out, correct?
Yes, I do recall that.
So just a little bit, I'll talk about the
And,
difference
she
between the
indicated
roles
to
of the
you
lawyer
that,
and cop,
Um,
because it was just brought up in chat. And
her
it's
and
really
Shad went
important.
in the basement, and within about 5 minutes, got to it, correct?
Got to it.
Yes.
She stated that Chad produced a couple chains. Yes.
Yeah. Within 5 minutes of being down there, correct?
Correct.
And she told you there was no kissing, correct?
I do not remember that at all.
And she told you there was no sex, correct?
She said that it was starting to lead that way, but there was no sex while
he was
Chad
alive.
There was no penis to vagina sexual intercourse going on, correct? Is that fair?
Penis to vagina, no.
I'm correct about that, right?
She never stated that that
Correct.
occurred.
Just say, yes, you're correct. They're trained to answer in obscure and annoying ways when they're answering just yes. It's so fucking irritating. Remember, these are the people we're employing to ensure our rights, not to convict us.
And did she indicate that her and she had theory and had took a toke off of some meth at the Eastman Avenue apartment in the bedroom?
Yes.
Okay, I have nothing further.
Just very briefly, you were asked about a couple of terms, nodding out and tweaking. Are those terms that you have encountered in your experience as a detective or as a narcotics investigator?
Defunct monster,
Yes.
stop being a
What do
government
those
cuck.
terms mean to you, starting with
Yeah, talk
nodding
about
out?
this.
Nodding out is a term typically heroin users would describe when they would become drowsy
As a result of the drug use?
as a result of the drug use.
And how about tweaking?
Tweaking it can refer to methamphetamine users. It's a stimulant, so it could cause them to be hyper or sudden body movements. And
Is he a drug
the
expert?
result of the use of methamphetamine.
Is he a physician?
No
What
further
training has
questions.
he had on the full effects of methamphetamine?
Okay, thank you. You can step down.
All right. So for the people saying, well, the lawyer's asking obscure questions or questions intended to draw out a particular set of facts. Yeah,
Does the state have
that's
any other witnesses?
the state has a lawyer to do that
No, Your
too.
Honor, at this time, the
They're
state rests.
allowed to do that. That's
Okay.
their job.
Ladies and
The
gentlemen,
cop's job
state
is
has now
to
rested their
tell
case.
the
We will take a
truth
brief
because the
recess,
cop
and,
is just a
we'll
witness
reconvene in about
who has an
10 minutes.
obligation
All
to
rise for
tell the truth to the court. The cop's job is not to find a conviction when they're in court. And let me point out one other very important thing. That's not the prosecutor's job either. The prosecutor's job is to seek justice, not secure a W for the government. Seek justice while ensuring the rights of the accused, because the accused is not guilty until a verdict is rendered. Period, period, period. Any government official violating that is fucking your ass without your consent. And we've got to stop apologizing
State has
for
rested
it.
Then, Mr. Freilich, the case would then turn to the defense. Do you intend to call witnesses, or do you want to address me on the stipulated facts?
Yes, before I do that, Your Honor, I'd like to make a motion for a directed verdict. Ask that the court consider,
Obviously going to lose this motion.
Use the microphone.
Oh, sorry. Ask that the court consider that as it relates to the first degree intentional homicide count, I would argue that there is insufficient evidence to support that particular charge. There's insufficient evidence to show that my client, Taylor Denise Schabusiness, had any intent to kill ST Shadtherian. What we have here is some testimony from a number of law enforcement officers. We also have some video footage from an interview between my client and Detective Groff and
Defunct
Detective
Monster,
Kempf.
it's not a false narrative.
It's clear that my client likely did consume and ingest methamphetamine with Mr. Therian prior to his death. My client provided commentary and answered questions from Detective Groff. I would submit that what she indicated that was that she had no intent to kill. The question is, did my client do it or not? That's another question. There are a lot of different issues here going on, but based on what she said to the detective, I'd ask that the court consider dismissal of the first degree intentional homicide charge on the grounds that there was no intent to kill.
No, because you still have
Also,
lesser included.
there are really
This
no
won't work.
eyewitnesses to whatever went on in the basement at 829 Stony Brook Lane in Green Bay. When Tara Pakinich and Stephen Hendricks went downstairs, they didn't find anybody down there. They found body parts, unfortunately, but they did not find my client.
She
there.
admitted
My
to
client
doing
was at
everything.
2353 Eastman Avenue. And that's where she was arrested. And there were no body parts over there. There were body parts in a van that was owned by Scott Tomes. That's not my client's minivan. That gold Town and Country Chrysler minivan belonged to Mr. Tomes. So there are a lot of issues here. As to the third degree sexual assault charge,
Because you got to
the
make
state's
the
gotta prove
motion,
that my
but
client had
obviously this is
sexual
pointless.
intercourse with Shadtherian. I believe based on this record, there's in the video, there's no evidence to show that my client had any kind of penis to vagina contact with Mr. Therian. We have testimony from
Anal penetration with a dildo is still a
the
violation of
DNA
the statute,
expert,
so this isn't a good one either.
that indicated it was uninformative as to the dildo. And I know that my client claimed that the dildo was used on Mr. Therian, but there's no DNA evidence on that. And
I mean, she
so I
said
would
it,
ask that the
but-
court consider dismissal of the third degree sexual assault charge as well for those reasons. Thank you. Finally, as to the mutilating a corpse, count two, again, there are no eyewitnesses to observe what really happened in the basement.
This is a
on,
pro forma argument. He
the
knows he's going to
question. So,
lose.
For all these reasons, I'd ask that the court consider.
It would
the
be
motion for
malpractice
directed
if he
verdict and
didn't
dismiss
raise
these
this,
charges.
Mr. Saunders.
even though he knows
Reasonable
he's going to
juror, given
lose.
the evidence in the light most favorable to the state could convict. The state's met its burden. His motion should be denied.
Yeah.
Okay, well, these motions are fairly common in cases like this, and the court does have to, in these circumstances, look at the evidence in the light most favorable to the non-moving party. This is by no way the court making a decision about what the ultimate verdict in the case will be. That's up to the jury, not up to me. But the court's task at this point is to take a look at the four corners of the record, the evidence, to see whether the state has satisfied their burden of proof, at least to this point, such that the matter can move forward and be given to a jury. Each of these counts has two elements. The homicide count has two elements. The mutilating a corpse count has two elements, and the third-degree sexual assault count also has two elements. And the court is satisfied when considering the entire record in this case that a reasonable jury could conclude that the state has met its burden and convict based upon the evidence that has been offered thus far. Again, I'm to look at the evidence in the light most favorable to the non-moving party. That isn't necessarily how a jury will look at it in their deliberations, but that's what I'm to do at this particular point. And in doing so, I'm satisfied that these motions for directed verdict should be denied, and that's what the court does at this time. So those motions are
Proper
denied.
decision, Judge.
And, so I'm
Yeah,
gonna
there's
turn it
no
back to
grounds
you,
for directed verdict
Mr.
here.
Freilich. My
Again,
understanding is as a
the defense
result of Mr.
counsel-
Combs not being here due to some health issues, that there's been a set of stipulated facts.
Yes, Your Honor, but before I do that, I know that my investigator had made attempts to contact Scott Tomes as part of the defense investigation in this case, and my investigator was not successful in making contact. But we did get a subpoena out, and the Brown County Sheriff's Department, I believe, subpoenaed Scott Tomes for court as a defense witness. The prosecutors did inform me promptly that he is not going to be available. Maybe he's got health problems or hospitalized, but they told me that he is not available. I've advised my client of this. I find that, and I'm not blaming the state, but I'm blaming him, that the timing of this seems suspect to me, that he's not available. I haven't seen any report, doctor's note, anything like that.
Yeah, make it prove it. Issue a
Before I
warrant.
answer the court's question, I'd ask that the court consider a motion for mistrial because this witness is not here, has been properly subpoenaed, and I really have
Scott
no
Tomes
recourse
is
to
the
call him and question
owner of
him,
the van,
about the issues in
and
this
also
case.
who
So
was
I'd ask that
present
you
when she was
consider that
arrested.
motion.
Well, before I turn to the state and ask for their response, Mr. Freilich, what can you tell me? What was your expectation of what he was going to testify to?
Well, I have some highlighted sections from his statement that the state and I.
You're not going to
agreed
get a
on
mistrial out of this, but
as
order
to,
him into the court or to offer
what
proof
his
for why he
testimony
can't be
would
there.
About, but when you call a witness, there may be other things that come up, but I'm working off a statement. I've highlighted the yellow parts that would be told to the jury if the court felt that was appropriate. But I felt the need, because I'm at this kind of crossroads with this kind of problem, that I would make this motion first.
Okay, sure. But I don't think you have my question, because the question is, you've asked for a mistrial based upon the unavailability of this witness. So the question is, what was he going to testify to so that I can assess the gravity of his not being here?
I understand. Okay. Thank you. I believe that he would testify that on that Monday night, I believe that would have been February 21st of 2022, that that Mr. Therian and Ms. Schabusiness came over, that he did not know Shad's last name, but he saw him before. and that he believed that they hooked up to get some meth or do meth. That would have been about 9 p.m. on Monday night. And that he had this gold Chrysler Town and Country minivan, and his keys were on a lanyard, which hangs on a hook by his front door. And that he indicated that Taylor Schabusiness has used his vehicle in the past, but with his permission, and that she's always asked to use it. And then he said she did not ask to use the vehicle last night, and that he did not give her permission to take the vehicle. And he said he did not call the police to report the vehicle missing. And then he indicated that he was drinking some whiskey and cranberry juice, and that he sometimes gets drunk, but not inebriated. He indicated around midnight,
cranberry juice.
Ms. Schabusiness returned home with his vehicle, and she went basically directly to her bedroom. That he had a suspicion she may be high on drugs, and that he believed the police arrived 15 or 20 minutes after Ms. Schabusiness got home. And then he talked about the living arrangements in the apartment, and that Ms. Schabusiness stays in the bedroom and he sleeps in his chair in the living room. So.
Okay, so.
He's guilty of the murder.
First thing I want to take up is Mr. Freilich's motion for a mistrial based upon the unavailability of Mr. Tomes.
It's not a mistrial, but can we get an offer of proof as to his unavailability?
Denied. Essentially, everything counsel stated, the state is willing and has prepared a stipulation to that effect. So I don't think that the drastic remedy of a mistrial is necessary. I do want to be quite clear. The state does not control Mr. Tomes. We in no way told him to disregard a defense subpoena.
Well, that was a weird thing to deny.
Call him.
Wasn't accused of it.
About the medical issue, and we passed that information along to defense counsel. So I don't want it to there be this record that we are influencing his unavailability in any way. Obviously, counsel can still attempt to have him here and still attempt to produce him. It's an issue the state deals with fairly regularly in trials. That isn't being done, so I don't think the defense failing to produce a defense witness.
You guys said he wouldn't be available, though.
Particularly when the state's willing to stipulate to everything the defense seeks to elicit, essentially.
Your Honor, I want to let the court know that Mr. Saunders promptly let me know of this situation as soon as he found out about it, so that was appreciated.
What?
Okay.
But didn't you say the state told you he wouldn't be available?
I mean, if you have a bad cold, that's a medical issue. If you are in the hospital for serious surgery, that's a medical issue too. Is he incapacitated? Is he just staying at home because he doesn't feel like getting out? Do we have a sense of that?
Why can the state make contact but not the defense?
The information we received is that he was in hospital and would be for several weeks. That was the information we received from a relative. Okay.
He's just going to be out for several weeks.
So
where?
In front of me then is a motion for a mistrial. A number of things. First of all, when I listened to the recitation of the information that Mr. Tomes was going to testify to, first of all, I'm satisfied that a lot of that information has already been testified to by other witnesses, particularly the individual, the mutual friend of Mr. Therian's and Ms. Schabusiness's, who was here yesterday, testified to some of the events that occurred at Mr. Tomes' apartment. Frankly, some of the other information that Mr. Tomes was going to be testifying to that was referenced by Mr. Freilich, I think was brought in through some other of the witnesses. The information about what Ms. Schabusiness did with Mr. Therian while they were at Mr. Tomes' apartment. There was reference to potentially utilizing controlled substances there, that perhaps Mr. Tomes was in either a different part of the house or had his gaze focused somewhere else while they utilized controlled substances behind his back, so he didn't see. That kind of information has come in other areas. Really, the only piece of information that I heard that doesn't sound like it came in any other fashion, except by indirect statements from Ms. Schabusiness in her interview with law enforcement, was the comment that, you know, when she used his van in the past, she asked permission, and that she didn't ask for permission that night to use his van. And there's a couple of things about that particular piece of information. I remember the information in the video where the detective was asking her questions, and she indicated in response to her question, I don't know if he knew that I was leaving or not. I don't know. I think she was uncertain whether Mr. Tomes actually knew that she was leaving. And the reality of it is, if she was utilizing his van and she was uncertain whether or not she even knew about it, whether or not he even knew about it, then that might confirm a statement whereby Mr. Tome says, yeah, she usually asked for permission, but that night she didn't. That would be very consistent with what she
Do you
reported
trust a
in her
juror to have
interview.
caught that?
Beyond that, I'm not really
Honestly?
sure the extent to which that piece of information is so relevant, that his presence is needed here, as opposed to stipulating to the facts that are outlined. For all those reasons, I'm satisfied that the fact that he hasn't responded
It's not a
and
mistrial. To be
arrived
very
here
clear,
today due to
it's not a
medical reasons,
mistrial.
I'm not going to grant
But let's offer a proof of the medical
mistrial
reasons
for that
from
reason.
somewhere.
I am then going to turn to the parties to determine if there's anything else that needs to be recited regarding that stipulated set of facts, or whether, Mr. Freilich, you've actually gone through and recited it there. Is that what you would intend to have recited?
Mr. Saunders has it, Your Honor. So I'm just going to take another look at it real quick.
It's just really frustrating because, again, so yeah, you could get a stipulated statement that admits to these facts that have been intermittently interspersed throughout the trial, but she's being denied the ability to highlight specific facts that they think are relevant for the case. Whether or not we think they're
What I did
relevant
was,
doesn't make much
I
sense.
highlighted
Like,
in
it doesn't
yellow
matter.
the relevant sections from the statement he gave to police, and then
But,
Mr. Saunders'
a
office,
relative
had it typed out.
that
So
the defense
it's in
isn't
proper
able to talk to identifies that their witness is
Gentlemen, how
gone
do you
for
want that,
weeks to a medical reason
submitted into the record?
with no proof, no ability to verify,
I can
no
mark it
location,
and then,
nothing.
Perhaps
Is
the
a
court can
little
just
bit
read it
weird,
at some point
right?
during the defense
You want,
case.
you want the court to
Shouldn't
read
that
it?
bother
please.
people?
Sure. Well, then we'll mark it as exhibit 111.
You get to make your defense, even if it's not great.
Thank you.
Just hate this shit. She did it. Obviously did it. Let her at least have her constitutional right to a fucking defense.
All right.
You have a right to call witnesses. You have a right
then
to
just for
confront
my own
witnesses.
edification, Mr. Freilich,
It's a constitutional right. It's in the fucking text.
I would intend to read this to the jury as soon as they're brought back
And she's
in.
not getting it.
Other than
For no
potentially
reason.
your client testifying, do you have any other witnesses that you? Because then we're going to move right into other witnesses. But if you said, well, that's the only one, and then the only issue is whether your client's going to testify, then how we'll proceed is I'll bring in the jury. I'll read in these stipulated.
There
facts,
is a
I'll
doubt about
excuse
the
jury
verdict.
again, and then I'll have the colloquy with your client about her testimony. So can you give me a sense? Do you have other witnesses?
Your Honor, I've looked at my list here. A lot of the witnesses I was going to call have already been called, so I think we're good. I will need some additional time to confer with my client on whether she wishes to testify or not, but
Okay.
that's where we're at.
All right. Well, then,
Just,
Mr. Saunders.
can I just quick, I know some of the defense, some of the law enforcement officers had defense subpoenas. Is it okay to cancel them then?
Yes, it is.
Thank you.
Okay, it sounds like all the other subpoenas that are out there are now canceled, okay?
Thank you.
Anything else before bringing in the jury, Mr. Saunders?
No.
Mr. Freilich?
No.
Okay, so I'll bring in the jury, folks. I'll read them this stipulated facts. I'm going to excuse them again. We'll break for a little more so you can speak with your client about testifying, and then we'll come back and I'll have that colloquy with her and go from there, okay?
Okay, thank you very much.
Might be wrapping up this case real soon, y'all. Here we go. Real quick. Gates of Above says the good old Omarion song, I got this left foot where my heart used to be. I don't know what song that is. Ninja Work 111. I'm going to read this and we'll address it later. Isn't arguing for the rights of people who are obviously guilty just theater? I don't get why you get so upset about it. Could we not have just thrown Daryl Brooks away without wasting time when he's on film doing it? No, we cannot do that. No. Someone roll up a newspaper and slap the fuck out of you, please, because you're not in the room with me.
Be seated.
On our next break, we'll discuss it.
Ladies and gentlemen of the jury, the state of Wisconsin, the attorney for the defendant, and the defendant have stipulated or agreed that if Scott Tomes had been called as a witness, he would have testified as follows. Scott Tomes was interviewed by a Green Bay Police Department detective on February 23rd, 2022, and stated that on Monday night, the defendant had a friend over named Shad. Mr. Tomes did not know Shad's last name, but had seen him before.
The statement
Mr.
is
Tomes
elicited
indicated
and
he
recorded by the
believed
cops.
Ms. Schabusiness hooked up with
Fucking
Shad
insane.
to get and do meth. He believed this was about 9 p.m. on Monday night. Mr. Tomes stated that he had his car keys on a lanyard which hangs on a hook next to the front door. Tomes stated his vehicle is a gold Chrysler Town & Country with Wisconsin tag 580ZJZ. Mr. Tomes stated Taylor has used his vehicle in the past, but with his permission, and that she always asked him to use it. She stated Ms. Schabusiness did not ask him to use his car last night and that he did not give her permission to take his vehicle. He did not report the vehicle missing. Mr. Tomes stated he was drinking last night and indicated he gets drunk but not inebriated. He indicated that around midnight, Taylor returned home with his vehicle. He stated she basically went directly into her bedroom. Mr. Tomes suspected Taylor was high on drugs. Mr. Tomes believed the police arrived 15 to 20 minutes after Taylor got home. Mr. Tomes was also asked about the living arrangements in his apartment and stated that Taylor stays in the bedroom and he sleeps in his chair in the living room. Mr. Tomes was later interviewed by a Green Bay Police Department detective on March 9, 2022. Mr. Tomes stated that A.J. Gannon and Taylor Schabusiness were at the Eastman Avenue apartment on Monday, February 21, 2022, before they left and came back with Shad Therian. Mr. Tomes stated that Gannon did leave on his own, leaving Taylor and Shad still at the residence. You will consider that testimony in the same manner as if it had been given under oath here in court. I have marked that as exhibit.
From a witness they'll never
111,
see,
that's
never
been offered,
meet,
Mr.
can't
Freilich.
assess
Yes,
if
it
he's
is,
telling
Your
the
Honor.
truth,
Exhibit 111 will be received.
no ability to
Could that
probe
be published
deeper,
to the jury?
and the entire testimony was elicited by one
Probably not
side of this.
necessary, yes. I'll-
Not
The
gonna
defense
publish it
has
to the
never
jury
spoken with this
because
guy,
that would involve you
ever.
Putting it up on the screen or passing it through there, and I'm not going to have them read it, but it is exhibit 111.
Thank you.
And then, ladies and gentlemen, I'm going to excuse you briefly again, so all rise for the jury.
I'm not saying they have to force him into the courtroom, but at least a doctor's note. A doctor's note. Anything.
Be seated.
L-Dog, did the defense agree to that? Yeah, because for whatever reason,
My understanding is you'd like to
he didn't
speak with your
demand they
client,
enforce the
for a
subpoena
little
with an
bit
arrest
about
warrant.
Her decision as to whether or not to testify, is that correct?
That's correct, whether she's going to testify or not testify.
My understanding is you can do that right back there.
That's
to
on the
side
defense,
door.
by the way.
So we'll be in recess then.
No, it's not an appellate
I'm gonna be
issue. The
checking in
defense
on
has
you, Mr.
agreed to
Freilich, by
it.
25 after, but if you need a little more time than that, you need to let us know, but I'm going to check in with you about that time, okay?
Okay, can you just give me till 2:30, Your Honor?
Sure.
Okay.
2:30.
All
All
right,
right,
thank
we're
you.
in recess.
So fucking frustrating. Why did the defense agree to it? I don't know. I don't know. He's putting up a frustratingly inadequate defense, but it's not ineffective assistance of counsel. It's just a different strategy than, I don't know, anyone should take, in my opinion. Why didn't the defense depose the guy? They've never been able to speak to him. They've never been able to make contact. The only people who have is the state of Wisconsin. Well, get the state of Wisconsin to produce the reason why he can't be there. That's what you should demand of the court. It's your fucking Sixth Amendment right to do this. It's so irritating. Okay. So again, no, this is not grounds for mistrial. It wasn't grounds for mistrial. It was grounds to demand the judge enforce the subpoena. The state saying, and maybe the defense dropped the ball early and should have requested it earlier, but well, he's sick. A relative told us. Why do you trust the state? Why do you trust the state? You believe your client is not guilty. Why are you trusting the state? Yeah, I know there is courtroom chatter going on. They're talking about whether or not she'll testify, but it's not Schabusiness and her lawyer. All right, so anyway, to address this super chat real quick from Ninja Work. First of all, thank you for the super chat. But second of all, you stupid motherfucker. Yes, it matters. It matters because Kyle Rittenhouse 100% shot and killed 2 people and shot and injured a third. 100%. It's on video. He definitely did it. I would say not only that, but he acted with deadly intent on all of them. Well, why do we care about his rights then, right? He did it 100%. Oh, because there's an affirmative defense. The affirmative defense is that he got to come in and say that he acted in self-defense. Now, just because we agree he acted in self-defense and we think it was the right move, did everybody? Did the media? Did your friends? What about your liberal friends? What about your black friends? Did they agree that he acted in self-defense? Kevin Hart, after the verdict, still thought Kyle Rittenhouse shot 3 black men that night. And it was on video. Guilty. Should Darrell Brooks have gotten his chance? Yeah. What if Darrell Brooks was being was drugged against his will? What if Darrell Brooks was being held under duress? Someone's got a gun to his daughter's head or something. I don't know. His best friend's head says, you drive this thing, you go drive through that thing. And he was trying to avoid people. He gets to assert his defense. It may be a lie. He gets to assert his defense. He gets to cross-examine the cops who said they saw him driving that car. He gets to cross-examine the victims' families. Is their story true? Is their story credible? Yes, of course we protect the rights of the guilty. You must protect the rights of the guilty the most. That's why they exist. The innocent don't need rights. I mean, they do. But the innocent need rights because the government will convict the innocent in the absence of those rights. Because the government always exceeds its power. Always, always, always. It is a rule, a fact, a law of nature and government that it will always exceed the authority granted to it and the restrictions placed upon it. Always, always, always. It happens every fucking day. Every day. And people still ask this question. Not only every day, it happens every day in every state, in every city, every day. And people are still like, well, I mean, do we really need to worry about these rights, though? I mean, it's obvious that they're guilty. Why is it obvious? The person telling you it's obvious is the state that is exceeding its authority every day. That it turns out to be obvious later does not justify the state lying in the previous part of it. That's so frustrating that this still goes on now. You have social media. You have guys like Andy No out there on the street showing you this. You have James Veritas, or James O'Keefe from Project Veritas on the street showing you every day overreaches by government, overreaches by corporations who are colluding with government. We have the FBI testifying that for the January 6th defendants, that they lied to the court and used data that they did not have a warrant for that was collected from FISA, the Foreign Intelligence Surveillance Act, unconstitutionally and only to be reviewed upon a sufficient warrant on the basis of the Foreign Intelligence Surveillance Act. You can't just get a warrant to review FISA data. You have to get a warrant to review FISA data based on communications relating to a foreign terrorism scheme. It's not so fucking simple as just, well, we have the data, we can just look through it. No, but that's what the FBI did. And they lied to court. They infringed all of their rights, and no one's doing anything about it. Why? Well, because they're obviously guilty. I mean, they went in the building, right? They tried to stop Congress. They tried to change the vote. They tried to change the election. Well, I mean, they obviously did it, right? Well, what about the Whitmer guys? What about the 4 guys of the 15? The 4 guys of the 15 prosecuted in Whitmer. They obviously did it. I mean, who cares that the other 11 were federal agents leading them into it, right? I mean, who cares? They obviously did it. Who cares that it was entrapment by the government who planned a scheme and 4 retards tried to go along with it? Actually, only 2 did, admitted to it, because they're literally sub-room temperature IQ and had no idea how to levy a defense against the government coercing them into a kidnapping plot that they had no intention of carrying out. But who cares? They did it, right? Why should we protect their rights? Why should we protect the rights of people who the government led into crime that they weren't going to do? Just to justify, let's be very clear, Whitmer's executive order, which was also unconstitutional under Michigan law, locking people down during COVID. Do not forget that the Whitmer kidnapping plot was a literal government false flag, verifiably so. Verifiable government false flag to justify COVID lockdowns by raising outrage over a right-wing terrorist plot to kidnap Governor Whitmer. But why should we? Why should we protect the rights of the guilty? Why should we? Why should we do that? I don't know. You're right. Let's just listen to the government. Let's just go ahead and trust them. They never lied to you. They never lie to justify locking you down, shutting down your business. They wouldn't lie about, the possible side effects of vaccines. They wouldn't lie about the categorization of COVID deaths. Oh, but I don't know if you guys caught that. They came out and they had to say it. Well, we probably overclassified COVID deaths to the tunes of hundreds of thousands, maybe even close to 1 million. And if that's what they're admitting, what's the real number? But why should we protect our rights, right? Obviously guilty. Obviously COVID was right. Obviously everything. Obvious. It's all obvious. It's all fucking obvious. Well, everything's obvious when only one side of the story gets told. And that story is in favor of the people who overreach all the time. And let's just not forget that you have a literal guaranteed right to the presumption of innocence until you're guilty, which means until the verdict comes down. Until the verdict comes down, you're not guilty. There is no such thing on this country's radar, in this country, however, as anyone who's obviously guilty. I don't care if you walk down the street, putting the gun to the backs of the heads of children and pulling the trigger, one after another, 1,000 at a time, on video, broadcast to the entire world. You are innocent until proven guilty. Only after sufficient due process with a jury. That's it. We guarantee that right because in the absence of that right, you are guilty of whatever they accuse you of, because that's the system we came from. The King's Court. The King's Court pronounced guilt. It didn't decide it. And as shitty as our system is, it's still, and this should terrify you, the best system in the world to be a criminal defendant. I would not choose a single other country, despite all of the problems and all the fuckery that we can witness in a trial where she obviously did it. And here's the thing, guys. Taylor Schabusiness is not going to walk from this crime. The defense for Taylor Schabusiness, I know they're defending not guilty by reason of insanity. She's not going to get that. Almost, I can't think of any way, based on the evidence that we've seen, the testimony, the video, that she gets that. But does she deserve life without parole because it was intentional? Or was she insane and under the influence of substances that she didn't manifest the intent? Because if that's the case, then she deserves her chance at parole. That's the Wisconsin law. That's the process that's guaranteed to her. And she gets to advocate for it, even though we know she killed this guy. And it's so weird to me that people keep up with this notion that well, it's just inconvenient. Well, I hope it's never inconvenient for you. Because I sure as fuck would never give the keys to my freedom to this government without my chance to fight back. And if you will, just go move to a different country where they do it every day. God, I hate people who apologize for and bow to this fucking system. Government should be suffered as a necessary infringement on our rights, not given license to run your life. All right. Well, now that that's out of the way. TMF Squid says, didn't she tell the cops she got lazy and forgot about the head? Let's be honest, that's normal for women to forget. Val the Gene says, based AF Nick Rant, keep advocating, man. The rights of the accused are sacred and should never be violated. 100%. 100%. It's imperative. It's essential to freedom. Bear in the Woods says, officer, I don't remember anything. I blacked out except for fucking my homie in his ass and choking him to death with a dog collar. Also, I could have set off with a bread knife. I was going to keep his head and dick, but I was too high on meth, bro. It's a great story, but she gets to tell it. Legal mindset. Hey, thanks, buddy. He says, Nick won the poll for best law 2 brands. Oh. How you doing, man? Court's audio's off. It's not me. We're unmuted, but the court's still muted. Marion Holtzman says, thank you, Nick. If I ever need a lawyer, you'll be it. Now get someone
Sure,
with
I've had
an
an extended time period. I appreciate it. To talk to my client, we've talked about this prior to trial, but we talked again about it today. I've advised her that she has an absolute right to testify if she wishes, and she also has a right to not testify if she so chooses. I've given her advice. I've conferred with her. We've talked about this particular issue.
To do it. Come on, girl, do it.
It's her decision not to testify and exercise her right to remain silent.
No, you coward. No. Oh.
Then I'll engage her in a colloquy about that in just a minute. But Mr. Freilich, then it would be my understanding that that you have no more witnesses, what you indicated before, and that when the jury comes back in, you'll be resting.
That's correct.
Okay. Okay.
Bro,
Then,
you
Mr.
just-
Business, I need to address you personally. So
Change your
Attorney
mind,
Coleman,
girl.
I just spoke with you about some of your constitutional rights that are coming up right now, and those rights are that you have an absolute right to testify, and you have an absolute right not to testify. Do you understand that?
Yes.
Okay. Mr. Freilich, the microphone. Not
sorry.
yours, hers.
Sorry about that.
So, Mr. Business, those rights belong to you. They don't belong to Mr. Freilich. They don't belong to the state. They don't belong to me. Those rights belong to you and you alone. Do you understand that?
Yes.
Okay. My understanding from listening to Mr. Freilich is that you've decided that you would like to exercise your right not to testify. Is that correct?
That is.
Okay.
No.
Now, I know you've spoken with your attorney. Do you feel you need any more time to talk to your attorney about that decision?
No, I do not.
Has anybody made any threats or promises to you to get you
She's
to,
going to prison
make
forever.
that decision here today?
No.
Okay. Any further inquiry you'd like
In
me to
my
make?
opinion, her only hope
Mr.
was to
Lezay or Mr.
testify.
Saunders? No. Mr. Freilich, any further inquiry you'd like me to make of your client regarding that decision?
Just inquire if there's been any pressure on her.
Okay. Ms. Schabusiness, has anybody placed any kind of pressure on you to make that decision?
No.
Okay. All right. Well, I'm satisfied based upon the conversation that I've had here with Ms. Schabusiness that number one, she understands her rights. She has both of the rights to testify and to not testify. The issue, of course, being you can't exercise both of those rights at the same time. You can only choose one. She's choosing the right not to testify here today. I'm satisfied that she's done that after consulting with her attorney. They took a little bit of extra time. I gave them better than 10 minutes to speak about that. That was the amount of time that Mr. Freilich wanted, and they were back here when I came into court. So they've had an opportunity to discuss that. Ms. Schabusiness has indicated to me she doesn't need any more time to speak with her attorney about that decision. I'm satisfied that her decision is freely, voluntarily, and intelligently made here today. Of course, when it comes time to address the jury instructions, Mr. Freilich will have to address, I think it's instruction 315. I think that's the instruction about that I could give to the jury potentially about, and I'm not sure if it's in your packet, but we'll certainly take it up. It's an instruction about instructing the jury that they're not to hold her decision not to testify against her, and that's another choice that she will have to make. If it's not in the packet, I'll get it for you, Mr. Freilich, but I'm sure you've done enough trials, you're aware of that instruction, and I'll make sure it's available to you, and we'll have that conversation later, okay?
Yes, Your Honor. Thank you.
Very good. I'm satisfied, therefore, that Ms. Schabusiness is choosing not to testify. Then what we do is we'll bring the jury back in. I'll ask Mr. Freilich if he has any other witnesses. Mr. Freilich, based upon
A lot of
the
times, I think
representations
it's
he's
the
made,
best
is going
move
indicate
to
that he's
not
going to rest.
testify.
And then we have a choice really to make as
Affirmative
to how far we wanna
defenses
go
can really
today,
throw a loop
with
into
the
it.
jury sitting here, either try to press forward or to release the jury and work on the jury instructions and start tomorrow with instructions and closing arguments. Does the state have a preference as to either of those, Mr. Saunders?
Our preference would be to proceed today.
Pretty
Any
sure we'll be
objection to that,
wrapping
Mr.
this
Freilich?
case
My
up tomorrow.
preference would be to go with the jury instructions today and proceed tomorrow with opening or with closing statements.
Okay. Well, I can tell you that I don't have to make that decision right at this minute. I'm going to bring the jury in. We're going to finish up the case and we'll go from there. And then I'll let you know what I've decided as far as that goes. All rise for the jury.
We'll talk about all this real soon. I saw some generous super chats from today's Tom's Lawyer, which I'll, of course, address. How long do I think deliberations will take? An hour if they're promised lunch. I think the only way she was going to convince a jury that she was not of her right mind at the time of the crime and it's mitigated down is to take the stand. And I think she just blew it.
Okay, be seated. Okay. Ladies and gentlemen, the case is still with the defense, so I'm going to turn to Mr. Freilich. Mr. Freilich, do you have any other witnesses you wish to call?
Your Honor, no other witnesses. Defense rests.
Ladies and gentlemen of the jury, the defense has rested, so the evidentiary portion of this portion of the trial is now concluded. Just to give you a little bit of a roadmap as to what occurs now, the attorneys and I need to work a little bit on finalizing the instructions that I need to give you regarding the law. Then the attorneys would do closing arguments, and then you would go into deliberations. What I'm going to do is I'm going to excuse you again, and I'm going to start working on these jury instructions with the attorneys. I'm not thinking it's going to take us too long, but probably longer than the other breaks you've had. But that's what's going on. Progress is being made. And I'm hoping that within a half hour, maybe slightly more than that, you'll have a better sense of the timing for the rest of today. If I run into problems, perhaps I would dismiss you for today, but at this point, I'm thinking that I'm going to have you wait and we'll get into instructions and closing arguments today. So that's a bit of a roadmap going forward, but with that, I'm going to excuse you again. All rise for the jury.
Okay. All right. Today's Tom's lawyer says, I'm not disagreeing with you on the system, but anger in this case is misplaced. Defense has the opportunity to produce statements to counter cop with. They could request witness or counter cop witness. They could request witness produced, etc. I said that is on the defense. Him agreeing to it is a problem. Absolutely. But I don't know
Whether to
why
move forward today, or
I don't know why the judge doesn't
break,
ask
send
the
jury
state.
home early, and then
Can we produce
come
any
back
proof?
tomorrow.
Just like,
I'm always keeping
well,
in
what
mind just
was
the
it?
timing that we gave them. Overall,
It's a
this trial
hospital.
would take about a week. I'm concerned.
I don't care if we
know
don't get to hear it.
the duration of the next phase
Can we
of
get
this trial.
any proof
I'm
of it?
concerned that if we come back and finish this piece tomorrow, I don't know how long deliberations will go on the first phase, and then we have the second phase. So I'm not inclined to stop at this point. I'm inclined to push forward.
So the second phase is where they're going to
Having said
argue
that,
not
then,
guilty by
I think
reason
my
of
judicial
insanity.
assistant should have put on your tables copies of the proposed.
Maybe
jury
she'll
instructions
testify
and verdict
then, I
forms.
guess.
Mr. Saunders, did you
I
get a copy
still
of those?
think
I did.
she
Mr.
should
Fraley?
testify to
Yes.
go against
Okay.
intent.
Then what I'd like to do is just go through with you those instructions. There are going to need to be some modifications, which my judicial assistant and I will work on when we break. But starting out with, I would propose giving jury instruction 100. I will note that I'm going to jump way to the end after starting at the beginning, that instruction 602 is instruction after evidence has been received on issue of guilt, where a plea of not guilty has been joined with a plea of not guilty by reason of mental disease or defect. It's suggested that this portion, or that this piece, this instruction, be inserted to instruction 100 or given following the instruction on the offense charged. My inclination is to put it right at the end of 100 because in my mind, that's where it makes most sense. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No.
Okay. Then I would intend on giving 103 evidence to find. Then I would intend on giving also 115, one defendant, 3 counts. There's a couple of modifications that need to be made here. First of all, on the version that you have, I've used the initials SRT for Mr. Therian. And I think we already talked about that way back when we were picking the jury, that we were just going to insert Shat Therian, and that's what I would propose to do. In fact, I've already told my judicial assistant to make that change. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
All right. The other thing that I'm not sure if it was corrected on your version, I think it was, and I'll raise this issue. The criminal complaint had the date here as February 22nd, whereas the information had February 23rd. The first draft that I looked at that I had my judicial assistant work on had February 22nd. We changed it to the 23rd. I just want to make sure, I think in your copy that you have, it should say the 23rd. I just want to make sure that that's the date we're looking at.
Mine
That's the
says February
information.
22nd.
Yeah,
It says the 22nd?
Yes.
Okay, so here's what happened. I made the changes in the version that she gave me. She didn't correct it in the version she gave you. But I'm aware of that issue. It's not something like, my God, I'm not expecting that we're getting all these typos. I knew about that issue. That's why I'm raising it. I fixed it in every other time I've read it to the jury. I had it as the 23rd because that's what the information says. But the first time that these proposed instructions were drafted for me to start reviewing was before we even selected a jury I was working on these, and it said the 22nd. So I had her change it. But clearly that didn't happen in your version. It should be the 23rd, Mr. Saunders, am I correct?
No, it should be the 22nd.
Okay.
Tuesday, the 22nd. The draft we have says Wednesday, the 22nd. I think the information's right. The criminal complaint was in error, and that's the state filed an amended criminal complaint fixing that date. In any event, I think based on the testimony, it should be February 22nd.
So the two-phase part of this trial is really weird. But even though the second phase is for the not guilty by reason of insanity, I still think they should have attacked the attempt or the intent portion of the intentional murder charge and moved for reckless homicide as a lesser included offense. And I'm not sure why that isn't done. Maybe it's going to be argued. I don't think the state, or I think there's real questions about the state proving intent.
Now I'm
I think
wondering
those questions would have been better
if I was mistaken,
answered
because I
if Schabusiness took the
recall
stand.
At the time I was preparing my initial instructions to give to the jury, I asked my judicial assistant to check with the information and make sure that the date that I instructed comported with that. So now I'm thinking she changed your versions, and I'm looking at the old version because mine says the 23rd, but yours actually has the right date. So I think the 22nd, because that is that's in the information. That's the instruction that I gave to the jury at the beginning. So we'll use the 22nd. Any objection to that, Mr. Freilich? That's what the information says.
Your Honor, just from my perspective, I'm looking at a criminal complaint that was filed on March 1st of 2022, and the charging date is Wednesday, February 23rd of 2022. You know, it's confusing. It's complicated because we don't know the exact date when this may or may not have occurred. Was it February 22nd, February 23rd? I don't know.
Sure. There's a couple of things I'd respond to that, Mr. Freilich. First thing I'd respond to that is the information is the charging document, not the criminal complaint. That's the first thing I'd say. The other thing I say is, instruction 255, which has been proposed to me, is the instruction stating state need not prove exact date of commission. We'll get to that in a minute, but I'm satisfied that the charging document is the one we need to follow because that's the official charging document as opposed to the criminal complaint. So I don't know what was heard at the preliminary hearing in this case or what the waiver was to, but that's what the charging document says.
Your Honor, just to, the court probably already knows this. I just want to make a record. The criminal complaint does have February 23rd of 2022 as the charging date, filed on March 1st of 2022, Brown County, Wisconsin. And then the information, which is the charging document, that has a different date, February 22nd of 2022, and that was filed June 2nd of 2022. For me, it's a little bit different because I wasn't the lawyer at that time. It was Attorney Jolly, but I'm just noting that all for the record.
What, and to what end? Are you asking me for something?
Well, I mean, if the state thought it was on the 23rd and then they changed it to the 22nd, it would appear to me that it's not clear what date this allegedly happened.
Okay. Well, what I'm indicating to you is that the charging document is the one that's going to be accurately reflected in the instructions. And I'm also noting 255, which we'll get to in a minute, addresses this very issue. So I'm going to change. I'm not sure if that's an official objection, Mr. Freilich, and I'm not sure what you're suggesting, but the instruction 115 is going to have Tuesday, February 22nd, 2022 in the city of Green Bay, Brown County, Wisconsin. And then where it indicates SRT, it's going to say Shad Therian. So 115 contains 110, first degree intentional homicide. It contains 1193, mutilating a corpse. And in that particular instruction, we need to look at the element piece. And it would seem to me that the word that has been utilized in this case is dismembered, but we have to make a alternative selection. Mr. Saunders?
Yeah, I have no objection to that.
Okay,
Dismembered.
Mr. Freilich, dismembered?
Are you asking whether to use mutilated, disfigured, or dismembered?
Yes.
Can I have a minute to confer with my client?
Like on a scale of 1 to 10, like how much did you chop him up though? Can we go all the way to mutilated?
Yes, we would agree with dismembered.
Okay.
That, Your Honor, that last comment was an objection, just to let you know.
Then the other selection we need to make there is in the very next sentence. This requires that the defendant acted with the purpose to conceal a crime or avoid apprehension, prosecution, or conviction of a crime. So, Mr. Saunders, does the state have a specific request?
I think conceal a crime fits the facts best. So
Mr. Freilich?
Agreed.
Okay. Conceal a crime will be the alternative we'll select in instruction 1193. Then we move on to count 3. That's instruction 1218A, third degree sexual assault, sexual intercourse without consent. Again, the changes from SRT to Shadtherian will be made, although there aren't any other alternative selections that need to be made. So that instruction will be changed. You'll get a chance to review the final version, and then that's the one that I would give. Moving on, I would propose to give instruction 140, burden of proof and presumption of innocence. 145, information, not evidence. 147, improper questions. 148, objections of counsel, evidence received.
So right now
over
they're going through
objection.
proposed jury instructions
150, stricken testimony.
and
There was
reconciling
very
them
little
between the
stricken
two.
Testimony, but I think on only one occasion did I strike any testimony, but I'm going to give 150 because I think it's appropriate. 155, exhibits I will give. 157, remarks of counsel I'll give. There's 158. I've already given that at various times, so I will not give that again. That's recording played to a jury, and it's supposed to be done at the time, and we did that, so I won't give it again. 160, closing arguments of counsel. I will give that one. Next one is 170, circumstantial evidence, and then what I direct the attorney's attention to is the bold or the capitalized instruction indicating that if evidence of flight, escape, or concealment has been admitted, see instruction 172. That's included here. I would propose to give both instruction 170 and 172. Any objection to that, Mr. Saunders?
no.
Mr. Freilich?
Oh, Your Honor.
Okay. On 172, we need to make some selections. The first line, evidence has been presented relating to the defendant's conduct after the alleged crime was committed or after the defendant was accused of the crime. I think the first option is the appropriate one. Mr. Saunders?
I agree.
Mr. Freilich?
I agree.
All right, option 1 will be selected. Okay, moving on, 180. There needs to be some work on that. I intend to give 180. The capitalized portion of the instruction indicates, add the following if a statement resulting from an unrecorded custodial interrogation is admitted at trial for a felony and no exception applies. I don't think that applies in this case because although there was custodial interrogation that was offered, it wasn't unrecorded. In fact, it was entirely recorded. So I think I take that paragraph out, but then continue on with the bottom paragraph. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
Taking off that bottom paragraph where it says continue with the following in all cases. You want to
No.
excise that?
No. The portion that says continue with the following in all cases, I would give it because, well, this is a part of all cases. The paragraph I would excise is the one just before it, where it starts. It is the policy of this state to make an audio or audio and visual recording. I take that paragraph out.
In the brackets.
Yes.
Okay, I have no objection to that.
Okay. Then I'll move on. I'll give 190, weight of evidence. 195, jurors' knowledge. I would give 200, expert testimony general. So there's some selections that need to be made there or at least addressed. It says continue with the following if experts have given conflicting testimony. I don't think that's the case, so I would propose to delete that portion. Any objection, Mr. Saunders?
No.
Mr. Freilich?
And the bottom bracket as well, the two brackets.
Right, that's the part that they're saying, continue with the following.
I'm just asking if you're going to take those out.
Yeah.
Okay, yes.
Okay.
The jury
255,
instruction
this
arguments
is
are
the one,
annoying because
state
like
need not prove
we don't
exact date of
see what they're
commission,
looking
specific
at.
date alleged. That essentially says if you find that the offense charge was committed by the defendant, it is not necessary for the state to prove that the offense was committed on the precise date alleged in the information. If the evidence shows beyond a reasonable doubt that the offense was committed on a date near the date alleged, that is sufficient. You're asking for that, Mr. Saunders?
Yes.
Mr. Freilich, any objection?
Well, it's kind of a conundrum because they file a criminal complaint with one date, then they file the information, which is the charging document with a different date. But then they're saying they don't have to prove the exact date. So I'm kind of confused on that, Your Honor. So I have lodged an objection to that.
Okay, I'm going to give 255. I'm satisfied.
I mean, they don't have to
that
prove the
date of
exact date.
information is
Then
the date that needs to be
the dates don't really
instructed
matter.
because that's the charging document.
They probably
I'm also
should matter,
satisfied that
but
this is an appropriate
apparently they don't.
instruction to give in light of, frankly, the entirety of the evidence that I've heard. I'm satisfied that, frankly, given that the timing, the time of day that's occurring, that knowing when one day flipped to the next may not be so easy to pin down. So I'm satisfied this is an appropriate instruction. I'm going to give that as revised. I'm then going to give 300 credibility of witnesses. There is an option at the end that says give the following paragraph only when the defendant testifies. Given that the defendant didn't testify, I would propose.
Harley
to
Kitten,
delete
she
that
attacked a
and
different
add
lawyer,
the
I believe.
Bracketed paragraph just below it. And, but then continue on with the last paragraph indicating there is no magic way for you to evaluate the testimony. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay. Moving on, 325, impeachment of witness, prior conviction or juvenile adjudication. I don't think anyone was asked that question, and I don't think anybody was impeached with a prior conviction. So I propose to take 325 out. Mr. Saunders, any objection?
No.
Mr. Freilich?
I agree.
Okay, that'll be out.
Thank you.
327, impeachment of defendant as witness, prior conviction or a juvenile adjudication. The defendant didn't testify. I propose to take that out. Any objection, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
That'll be out. 460, closing instruction, I would propose to give that. Then I would propose 484, verdict submitted for one defendant, 3 counts, separate verdict on each count required. I would propose to give 515, unanimous verdict and selection of presiding juror. And that's it. You'll have another opportunity to look at these after I've made those revisions, but such as they are, Mr. Saunders, any objection to the entirety of those instructions or anything I'm missing or that you'd like me to add?
Yeah, 2 additions that I would propose. Madam Clerk, do you have the copies? Okay, I have one for the court. The first is based on some testimony that we heard. It'd be our request to make clear that voluntary intoxication is not a defense. In the case, there's not a pattern jury instruction that really says that. There's a part of 755A that does have that sentence, and the state would ask that just that sentence be read, given the state of the law and the state of the voluntary intoxication defense.
Kevin Lawrence's likeliness for appeal. An appeal will occur. I haven't seen anything to merit
Directly
an
applicable, but
actual
as
appeal.
modified, I believe it's accurate.
That profile pic, what? This one? This is Muhammad. It's Anna Kasparian as Muhammad. I don't know why she did Muhammad face. I think it's very offensive to the Muslim people that she did that, but that's what she did. It's not up to me. I don't make the rules.
Mr. Freilich,
Yes.
any response to their request for 755A? Just so you know, Mr. Freilich, and I know you don't have the benefit of having your computer sitting right in front of you regarding 755A. 755A is an instruction that is titled as follows: involuntary intoxication or drug condition. So it looks as if Mr. Saunders has utilized that pattern instruction. Mr. Saunders, if I'm correct, you've utilized that pattern instruction to craft this, and he's proposing that this be given. Any objection to that?
No, Your Honor.
Okay.
I know the law.
Okay. So that's fine. I will give this modified 755A. Generally, other than sometimes rearranging where the closing instruction goes.
Kevin
I
Lawrence,
give these
welcome
in
to Paralegal.
numerical
Thank
order.
you.
That would put it right at the end. I don't propose to put it right at the end because the last one I generally give is 515, unanimous verdict and selection of a presiding juror. I think that is the best to have at the end. Proposal as to where we insert it, Mr. Saunders?
Proposal as to where we insert it.
Right after the
eternal
115,
question,
substantive
fellas.
Jury instructions. That makes sense.
Any objection to
We got
inserting it there,
options, I'm
Mr.
just
Freilich,
saying.
right after 115, the substantive instructions?
All right, if I could just have a minute. Yes, that makes sense.
Okay,
Oh, Scottabig,
very good.
today
Okay,
has
we've
not
taken
been
that one
boring.
up,
This
then,
part, arguing over jury instructions, it's not boring. It's just kind of awkward.
Before I move on, do you have a Word document with these on it that
I
you
do.
can forward to my judicial assistant?
Okay.
One of you.
But I've
so
thoroughly
that's-
enjoyed
I'm
this
gonna be heading
trial.
over there shortly
Great.
to finish these off, and we'll need it.
Mom Overlord. Yeah, I had to start halfway through the first day, but
let's look at you
the
don't have
rest
to
of
do
it,
that
yeah.
till we're done. But let's look at your other request then, Mr. Saunders.
Yeah, so obviously that issue or this issue has been addressed in litigation. There's a motion to dismiss regarding the state doesn't need to prove that a crime victim was alive or deceased at the time of the sexual intercourse. And I think the state just envisioned a jury having that question, given the two elements don't clearly explain what I think is an accurate statement of the law. So our request would be to add something to address that issue, because obviously it's the facts and circumstances that the state's alleging in this case.
Okay. Well, let me just before I turn to Mr. Freilich to take a look at his position on this. I'm just going to pull up the statute, because we did have this issue that was raised as at the motion hearing on June 13th. This was heard by the court. And I know at that point, I denied a motion to dismiss that count. And the assertion in that motion was that had been filed by the defense, that really the charge should be dismissed because at the time the alleged victim was deceased. And then we looked at the statute.
Are you going to dismiss one of the charges? That'd be interesting.
Okay, and I know it. So the instruction, the one that I'm proposing to give in any event that everybody's agreed to, 1218A, references the statute 940.225 sub 3 sub A, and so I've looked at that statute, and under 940.225. Sub 7, it indicates specifically this section applies whether a victim is dead or alive at the time of the sexual contact or sexual intercourse. Okay, so what you're proposing that be done in this case, because of issues that have been raised and frankly that were argued on that date, that it be inserted, that the following language be inserted. Quote, "It is immaterial whether Shadtherian is dead or alive at the time of the sexual intercourse," close quote. That's what you're asking to be added?
Yes.
Mr. Freilich, any objection to that language?
Your Honor, I know that the jury instruction says person. What about the statute? What we have here, and not to be crass, but human remains, body parts that are in different locations. So that was the issue that I had with that.
I'm sorry, your question,
What? That's your
you
argument?
said that the statute says person?
I know the jury instruction says person, but I don't know if the statute says that, but it talks about any part of a person's body. So it talks about a person. And what we have here is, a body part, body parts.
Statute says 3A says as follows: whoever has sexual intercourse with a person without the consent of that person is guilty of a class, it's guilty of a felony. So the instruction mirrors the statute as far as person. So when you get down to sub 7, where it says this section applies whether a victim is dead or alive at the time of the
She also
sexual
admitted to
contact
doing it
or sexual
prior to
intercourse.
chopping him up. So this is an even dumber argument.
They're using the word person, or using the word victim instead of person in sub 7, presumably, because at that point in time,
You've determined that the sexual assault acts did occur and that it's a presumed victim.
at that point in time, using the word
This is not the place to be pedantic.
could get confusing as to whether you're talking about a victim or a perpetrator. If you just said the section applies whether
Wait,
a
no.
person is dead
Come
or
on, Judge.
alive,
That was equally dumb.
you
The
need to perpetrate-
perpetrator's dead. He
I
can
don't
he
wanna
can be
get
accused
into
of a
all the
felony. No,
machinations, but
he's
it would
realizing
seem as
right
if
now how
the word
stupid
victim
that
is
was.
used in sub 7, perhaps for that reason. So the question, of course, is whether there's an objection to insertion of the language, "It is immaterial whether Shadtherian is dead or alive at the time of the sexual intercourse." Any objection to that?
I know that's in the statute, but is that in the pattern jury instruction that we have, Your Honor?
It is not.
It's not.
He's
So,
asking for it to be added in.
Yeah, he wants to add something, correct?
Yes.
I'm going to object to that.
Good.
Okay. I'm satisfied that, first of all, adding that language in is a correct statement of the law. It is. It's not as if modifying the instruction to something that's incorrectly outlines what the law is. It's an accurate statement of the law. Secondly, this is a bit of an unusual circumstance where typically when you see these assaults occur, you have someone in court testifying that they were the victim of a sexual assault. That's different, of course, when you have someone who is
A corpse.
deceased. So the circumstances of this case are a little bit unique. It's already been put into this case. It was
The only evidence in this case, by the way, is that he consented to sexual activity.
Appropriate addition in this particular case.
That's the only evidence. The
These
state did
pattern
not
jury
prove
instructions
that there was
are
no
not by
consent.
any means mandated by law to be used there.
The state did not elicit any testimony about a lack of consent in this case. This actually bothers
Look at
me.
them and modify them as needed, and I think this is an appropriate addition. So I'm going to grant that request. And so that will be added to instruction 115, the subpart under 1218A.
Were you guys having
Anything
sex?
else?
It was going there.
No, thank you.
We were going
Right,
there.
Mr. Freilich, again, you're going to get a final opportunity to review these, but any
But she should have
additions or,
testified to this, by the way.
changes that you're looking for besides what we've already discussed?
No, Your Honor. Thank you very much.
Okay. Let me just ask you then about the proposed verdict forms. Obviously, there are 3 counts. There'll be 6 verdict forms, 1 for guilty and 1 for not guilty for each count. Mr. Saunders, have you had an opportunity to review those?
I don't know that the lack of life is a lack of consent. Honestly,
No.
I don't.
Mr.
That's
Freilich?
why they need a separate statute for just sex with a corpse. If you want sex with a corpse to be illegal, just make it illegal. Don't involve a question of
Your Honor, I have
consent.
reviewed all the verdict forms. They appear to be in proper order.
My judicial assistant and I are going to get underway on these right
Bradley
away.
Vetch,
Mr.
why does
Saunders,
implied
if you can make
consent
sure
end
you
at
send
death?
A Word version over to her. I invite the attorneys to get up and move around if you want, but don't get far, because as soon as I'm done, I want to get back on the record. I don't know how long it's going to take me. So just stay close, but you can certainly move about the courthouse, okay?
I would assume
We're in
sex with
recess.
a corpse is covered in the defilement of corpse statute. This is, again, I have a conceptual problem with this. Not as justification for fucking a corpse, by the way. I think that should be very illegal, personally. I think it's weird. I think you should probably go into a meat grinder if you do it. But that being said, making the issue here is not about sex with a corpse. The issue is about consent. Sexual assault is about consent. There's no evidence that he did not consent to actually any of the activity that happened. The only evidence, in fact, is that he even consented to dying. Now, you can't consent to someone killing you in most states. You can't do that. There may be some weird, like, assisted suicide statute somewhere, but generally you cannot consent to your own killing. Absent that, there is no evidence. And remember, the state does not have to prove that he didn't consent. The state has to prove that he did not consent. Do you see what I'm saying? How do I word this? The state does not have to prove that he didn't give consent. The state has to prove that he did not consent. That's how you word that. That's the way. All of the evidence, because the only evidence comes from Taylor Schabusiness, right? That's all the evidence we have on this thing, because the state failed to elicit any further testimony on this subject. Maybe they couldn't. They could have asked the friend, somebody else, were they going to go have sex? This is the thing they commonly did. They didn't do that. They did not do that. So the only evidence we have is her interview room evidence. And in her interview, she says, he said, were you guys having sex? She said, things were going that way. He consented to the choke chain. As she's choking him, he says, keep going. Again, according to her, you could disbelieve her, but that's the testimony, and there's no contravailing testimony at this point. Where is non-consent? No evidence of resistance, no evidence of anything. Again, should fucking a corpse be illegal? Absolutely. Is it sexual assault based on non-consent? I don't think so, and it shouldn't be written into the statute that way, in my opinion. Very weird. Very weird. And I know people are saying consent ends at death. How? Where? Why? Why is that a thing? Like, when you're dead, how did you stop consenting? Do you guys believe the conceptual theory that consent is an ongoing process that is reevaluated every single second, and the moment some triggering event occurs other than a please stop, that it goes away? Like, because I don't know that I buy that that's a valid theory for criminal law. Again, as a conceptual theory, a psychological theory, maybe. But is there a foreseeable ability for someone to consent knowing that they, for example, some people say, well, when someone becomes sufficiently drunk, they are no longer consenting. How do you know that? Like, how do you know when that point is? Or if someone is unconscious, they're no longer consenting. Well, what if the person consents to consensual activity ahead of time while they're unconscious? You run into a problem. And I don't think we've resolved this issue. And I think it's an interesting and critical point in the concept of criminal law. Again, really easy to make these sort of structural ideas around consent for elementary discussion and academic discussion, yes. But for criminal law, remember, we're not talking about just, does this kind of make sense? We're talking about you lose your liberty because of this. Now, let's imagine you are in a consensual sexual encounter with someone who does say, choke me, right? Choke me out. I love being choked. And you're like, all right. And you go to town and they momentarily lose consciousness. They don't die, but the choke goes a little too far. You cut off the arteries rather than doing like a windpipe choke, and they black out for a second. And you don't realize it for a minute, and then they come back to, but the sexual activity has not stopped. Have you raped that person? Criminal rape? And if no, why not? If the idea that a lack of consciousness is an automatic cancellation of consent, then you are guilty at that point of rape, period. And that gives no agency to the person giving consent. It gives no ability for the person who is supposed to be the receiver of consent to even have a reasonable chance of stopping it, because it's almost guaranteed that you'll continue into that, even if you notice and then mitigate later. So it's really weird that and then further, when you're dead, there's nothing there at all for consent to matter. Again, sex with corpse is wrong. Bad, make it illegal. I don't care. Not an issue for me. No corpses I'm looking to bang. But once that person is dead, that body is just meat. So absent a specific law making it illegal to have sex with a dead body, consent shouldn't enter into it. Because it's not like you stop consenting. And remember, the purpose of a lack of consent in sexual assault law has nothing to do with the act of sex. It has everything to do with the trauma associated of being violated in a way that will damage you going into the future. You have been violated in this most sacred of places against your will or without your ability to give it. That presumes that that trauma will be realized. When you're dead, there is no realized trauma. There's nothing. From a secular point of view, you're meat and are rotting. From a spiritual point of view, you're removed from that body and onto something different. So why is this part of a sexual assault crime? That bothers me. It doesn't belong there. To me. Rumbles down? Fuck. Seriously? Your entire argument denies the value of a will and directives to follow after death? You're wrong simply? No, it does not. What are you talking about? Wills and the transference of property, which is the only thing wills do is convey property, right? That does not continue on after death. The transfer of property rights happens at the moment of death. It may take a while for the effect of the transfer of property to occur, but the transfer of the right happens at the moment of death. It is not something that carries on beyond death. So that's an incorrect assessment. And we can maybe have a long discussion about that at some point, because people don't really understand the nature of property rights and ownership, because they're like, well, until something moves to someone, I own it. Well, no, I can give you a property interest in something now and retain part of those rights, called like a life interest, for example. For me, I could give you a book and say, this book is yours, but I'm maintaining a life estate interest in it. So it's yours. Now you own it. You actually have the right to alienate all of it, but I have the right to possess it until I die, because I didn't give you that particular right. And that will go like that. You own the thing, even though you don't have it, and you can't sell it, but you can sell your interest in it, so that when my interest goes away, your interest transfers to the other person. Property rights are critical here. This is again about the ongoing trauma that is done to a victim of some type of violence. And an assault on the consciousness is violence in the same way that a punch to the face is. Which is why we allow assault in general as a concept to be something that damages someone. It's not the violence that damages them. It's the threat of violence, the fear, the apprehension caused. That's an infringement on your rights. But when you have no ability to apprehend fear, when you have no ability to endure trauma and suffering because you're dead, you can't threaten a corpse. And that's maybe the more appropriate analogy here. If I pull a gun on a corpse and point it at it, and I shoot the corpse, did I commit murder? because that's what we're arguing. Did I commit assault? Did I put the corpse in reasonable fear of imminent death or bodily injury? No. If I shoot the corpse, I may be desecrating, mutilating, or violating a corpse in some way. Sure. Those laws exist. Sexual assault is not appropriate for this case. And I think it's a very dangerous precedent from a criminal law standpoint. Again, different from psychology, different from everything else. I think it's a very dangerous precedent to hold people criminally responsible to the point where their liberty is taken away by the state for consent being automatically revoked during points of time that are 1, hard to determine in some cases, 2, impossible to determine, or 3, involuntary. You're a woman having sex with your husband. He has a heart attack and dies. You don't notice. You continue having sex with him. You've raped him. Sexual assault. There you go. Go to prison. That's insane. It's an insane prospect. And that should bother everyone. Again, I know in this case, she's weird. She's done funky things and she should be prosecuted and convicted for all of them. I'm just saying that the law in this is inapt. Radioactive Girl Scout, that's completely different. Why? Wait a minute. Why is that completely different? Now, if he was not consenting to sexual activity prior to death, you have a better argument. Better. I don't think it's great, but it's better. But remember, this isn't about when sexual activity occurs. It's about when consent stops. Because if you are having sex with your husband and he has a heart attack while you're in that cowgirl position, going to town, and you don't notice, maybe it's reverse cowgirl, so you're looking the other way, he dies, and you keep going. Under this standard, you have literally raped your dead husband because his consent ended when he died. Well, I didn't know. Well, that's too bad, isn't it? No consent because consent stops. Do you see the conceptual problem with this application of law? It should bother you. Not because it's not wrong for her to have sex with the corpse. Of course it is. But those situations are obviously different in concept, but they're not different in the element of the crime. So make better laws. Make better laws. Did she pull a Chandler Halderson, take a taste? I think she had to have, at least a little bit, right? They got most of the body, but that doesn't preclude her. I think didn't she admit to drinking some of the blood too? I'm wondering if Rumble is going to come back up. Not quite sure. Here's the interesting thing. StreamYard says I'm still streaming to Rumble. But anyway, okay, so very interesting questions. I think her lawyer, and again, I mean, this is the application of the law as far as I can tell. I think her lawyer had a duty to propose a better argument. By the way, the court's here. It's just nothing's happening. Rumble never went down. I mean, for me, Rumble is down. 500 service unavailable. It is streaming to the app, just not the website. Now, getting back to that conceptual discussion on sexual assault with a corpse or whatever. And sure, you might get a prosecutor who exercises prosecutorial discretion and refuses to prosecute, right? Like the woman in that case, and they should. But do you want to rely on prosecutorial discretion, or should we just clarify the law? I mean, to me, we just clarify the law, make it a better law. And I think, and if you go, well, it should be a better law, but it's not the law here. Tons of it should be a better law cases have turned into a better law with a finding of not guilty for the person accused because the law was unclear. So, LOD 689, how should it be worded? It just shouldn't be part of the sexual assault case. Sex with a corpse should just be illegal. If we're opposed to necrophilia, I think most people are, make sex with a corpse illegal. Now, should sex with a corpse be illegal? People can offer arguments. I'm not delving into that one. I mean, there's lots of libertarian takes on it that would probably disturb people. I personally don't have a vested interest in sex with a corpse being legal or illegal. I could care less. So it being illegal is fine, but just make that the law. Sexual assault is a different law with different impact. Remember, sexual assault's about the victim, not the act. It's the victim. Sex with a corpse is about the perpetrator, which that would be the libertarian argument against it, right? Who are you harming? Yourself? Who cares? You're a libertarian. Like, that's the concept. But sexual assault is about the victim of the assault having to deal with the aftermath of that. And we want to go ahead and stop that behavior and discourage that behavior in other people. So we have a criminal thing that says you're actually a danger to society because you might victimize another person. But you can't victimize a corpse. It's not the corpse. You can argue that if you defile a particular corpse that maybe you have no right to or doesn't belong to you, like you dig up someone's corpse and have sex with it, maybe that should be illegal because like it's offensive to the surviving victims or something. Like these all make sense. There are ways to write laws around victimhood. There's just generally no victim in the vanilla concept of it. Now, Shad's parents, are they victims to the sex with a corpse? Sure, which is why maybe sex with a corpse that isn't explicitly yours should be illegal. Sure, fine. Like, but because there's victims there, it's like it's offensive to his memory. It's kind of gross. Gives you the wigglies. I'm all good with it. But it's not sexual assault. Shad wasn't a victim of sexual assault according to anything the state has produced. The only testimony elicited about his consent was that they were going towards having sex. He wanted the choking as part of the sexual act. And then he just happened to die soon, like first. Grouchy old geezer says, if sex with the corpse is sexual assault, is sex with the steak bestiality? I don't know. It's a really fucking weird one, isn't it? But you know what? We need to do something real quick here. If you're like me, you're getting worked up over all this stuff, you need to calm down. I actually have a solution for you. And that is cbdistillery.com. Look, CB Distillery offers CBD and Delta 9 THC products where legal, ordered and mailed to you for various things. You need help sleeping? Take some good old CBD or THC gummies, knock you right out. You need help being awake? You got general pain relief issues. They have different blends of CBD and THC for all of these things. Look at this. You die for a little bit. Someone sexes your corpse. You come back to life. Your butthole's a little sore. A little Delta 9 THC mixed with some CBD to soothe the nerves will go ahead and get you up and walking just as fast as the feeling returns to your legs. CBDistillery.com is actually running a very special right now. If you use promo code RUMBLE, you get 50% off. This offer is going to end pretty soon. So if this is something you want, go ahead and do it. Look, in all seriousness, guys, I've tried the tincture, this thing right here, the tincture you put under your tongue. And I have tried the gummies. These are nighttime gummies. These are just CBN and CBD. This is before Minnesota legalized the Delta 9 THC. So it's just CBD gummies. And these knock you right out. I mean, or knocked me right out. I don't know. And I have narcolepsy, so maybe that's an unfair standard, but it actually made me feel tired. That's the rare part of narcolepsy. Once you lay down, you fall asleep. But until you lay down, you might just Rumble just popped back up for me, and it was clearly down because it's down to 1,100 people. It was up around 4,000 earlier. Anyway, once I lay down, I'm right to sleep, but I don't feel tired until I lay down most of the time. These gummies, if you have trouble getting tired, getting to that point, they will do the trick, or at least they did for me, I should say. Look, there's a couple states where it's not available. Obviously states that have CBD or THC products that are not legal, they're not going to send them there. But CBDistillery.com, again, 50% off if you use promo code RUMBLE. If you've ever wanted to try these types of products, this is the time to do it. And they're a good company. They're like organically sourced, good products. They're not going to give you're not getting fentanyl in your gummies. Okay. You're not getting fentanyl. Now, are you going to get a little Schabusiness in it? You take the gummy, all of a sudden you're going to wake up beheaded? Yes. Yes. I'm not going to lie. That is the caveat, is once you take the gummy and fall asleep, when you wake up, your head is going to be separated from your body. But because you've had the soothing power of THC and CBD in your body, you're not going to mind. It's going to be okay. So there you go. With that, thank you. Thank you to CBDistillery.com. Again, promo code RUMBLE for sponsoring the stream. Really appreciate it. They help all this go. They help make all this happen. Okay. Awig says also won't mind because you would be dead. Well, how do you know? Have you tried being decapitated, Awig? Oh, you're so fucking smart, aren't you? Well, you'd be dead. Have you even tried it? You're just ignoring the testimony of people who've been beheaded and are still alive, I guess? Rude. Okay, so here we go. All right. Where were we? Let's hit some of these other super chats. Okay, so today's Tom's lawyer says, first he said, I'm not disagreeing with you on the system, but anger in this case is misplaced. Defense has the opportunity to produce statements to counter the cop witness. They could request the witness produce, etc. And I don't know the full procedure around that. Again, I do think a mistrial is inappropriate in the case of that witness. I just think some effort should have been made by the court, by the state, or by the defense. I think all three of them have a reasonable duty to do some part of enforcing that subpoena. The defense should request it enforced. The state should proffer some details to the court, even if it's sealed, as to why he's not able to make it, that the defense could consent to. But it sounds like the defense is like, we have nothing other than them saying it. And the judge should say, well, we can issue a warrant or we can demand an offer of proof.
Giving 100 opening instructions. I'll note that on the next page, I've inserted 602. I indicated that that's where I thought it was most appropriate to insert 602. So I'll give 100 followed by 602. Then I'll give 103, evidence defined. 115, one defendant, 3 counts. Changes that have been outlined in there, we've talked about. It'll say the counts will be listed as Tuesday, February 22nd, and I've revised The initials used for Mr. Theory.
I'm going to step away for a second. I have to make a quick phone call,
I've made the
and I have to do it soon. So let me do that, and I'll talk to you guys in just a minute.
1193.
But I'll keep the court running.
And then, of course, we move into
Allahu Akbar. Death to
1218A,
infidel.
and I have inserted the language that was requested by the state. Mr. Freilich, I believe, objected to that. I ruled, however, that I was going to give it, and that sentence is, of course, under the subheading meaning of did not consent. It's the very last sentence, and I added that in. Then I'll give the modified 755A. That was
Yeah,
agreed
make a phone
upon,
call, by the way.
and designed by Mr. Saunders. I will give one third.
I got to call in some prescriptions. I have to do it now.
Presumption of innocence. 145, information, not evidence. 147, improper questions. 148, objections of counsel, evidence received over objection. 150, stricken testimony. 155, exhibits. 157, remarks of counsel. 160, closing arguments of counsel. I'll give 170, circumstantial evidence. I'll give 172, circumstantial evidence, flight, escape, concealment. I will give 180, statements of defendant. 190, weight of evidence. 195, jurors' knowledge. 200, expert testimony, general. I'll give 255, state need not prove exact date of commission. I'll give 300, credibility of witnesses. I'll give 460, closing instruction. 484, verdict submitted for one defendant, 3 counts, separate verdict on each count. I'll give 515, unanimous verdict and selection of presiding juror. We'll then select the alternates. A couple of things I want to take up. First of all, I did want to, because we didn't bring this up at our instruction conference, but it's not too big of a problem. I asked my clerk if she could hand one of those to each of the attorneys. This is what Mr. Freilich and I had spoken about earlier, 315. And Mr. Freilich, I know you didn't have a copy of that, but you can have a brief moment to review that with your client and take a few minutes to talk with her about whether or not you and she would like me to give that.
Okay, Your Honor. Thank you. Your Honor, I have reviewed instruction 315. I'm fine with that. And I showed it to my client.
Okay, and I appreciate that, Mr. Freilich. I think I need more than just I'm fine with that. This has got to be something that you either ask me to give or ask me not to give. And I'm going to have a colloquy with your client about it. Do you need some time to speak with her about it? Because if you do, I can leave the bench and come back in a few minutes.
Yeah, maybe that would be a good idea, Your Honor.
All right. We'll take about 5 minutes and have a conversation with her, Mr. Freilich.
Thank you.
What did I miss? What did I miss? Are they done for the day? I saw them stand up. Are they coming back? Another 5-minute break? Again? Like, what for? They just had a break. All right, anyway. Okay, back to these chats. Back to these chats. Today's Tom's lawyer followed up. Oh, excuse me. Followed up with, the prosecutor's job is to see justice served, but also as an advocate for people they obviously believe in charges they brought and have a right to argue so in court. You may be of that opinion, but I will humbly and firmly and repeatedly disagree respectfully with that opinion. And the only reason I will do that is because we have incessant and repeated evidence that that is not true in both the highest and lowest profile cases on the planet. I mentioned Kyle Rittenhouse earlier. Not only does any legally learned, honest observer recognize that Kyle Rittenhouse was obviously engaged in self-defense on the night that he shot 3 people. But a further reading of the criminal complaint drafted against Kyle Rittenhouse abolishes any doubt of that being true. And yet, Binger and Krause still went on a quest to convict him of a crime that they knew by the drafting of the complaint, they knew he did not commit. And in doing so, they attempted to break the rules of evidence, violate his Fifth Amendment rights against self-incrimination, among other things. But that's a high-profile, politically charged case. So I'll speak from experience on a case that I was on, that happened here, and is of no profile, with defendants who are completely mundane, normal people. The Minnesota Drug Task Force, or at least the Southwest Minnesota Drug Task Force, something like that, multi-county area around here, joint operation of drug agents, received a hot tip from a confidential informant who happened to be a criminal informant that they just happened to omit being a criminal informant when they wrote their search warrant request, because they didn't really want to explain about the interest in that criminal informant in trying to get some leverage in an ongoing case on child protection against the county. But let's skip that part and pretend it didn't happen, because though that was bad news by the cops, that's not really, I guess it's not really relevant to the underlying issue. They believed that there was meth at a particular household, and they used this warrant to justify a search of the garbage can. Now, let's also ignore that the criminal informant was present on the day of the execution of the search warrant, and the evidence that they collected for the presence of methamphetamines was actually from that criminal informant placing it in the garbage can right before the cops would pick it up. Let's ignore that too. Hold on. I'll get back to this.
I've advised her that if the case went to a jury trial, she has a right to testify. She has a right to take the witness stand. She has a right to testify in her own defense. But anything that is said could possibly be used against her. So she understands that she has a constitutional right to testify. I also told her that she has an absolute constitutional right not to testify. She has a right to remain silent. She can invoke her Fifth Amendment privileges against self-incrimination. And we've talked about this at length on numerous occasions, several times today. We've reviewed this jury instruction 315, and she's indicated to me that she wishes to exercise her right to remain silent. Before, when you asked the question, I wasn't quite sure what you were asking. But I agree to the court reading instruction 315 to the jury. Thank you.
So you're asking that I read this instruction to the jury?
Yes.
Okay. Ms. Schabusiness, you have a right to have this instruction read, or you have a right not to have the instruction read. And that right belongs to you and to you alone. Do you understand that?
Yes, I do.
Okay. Your attorney indicates to me that he would like me to have this instruction read to the jury. Is that correct?
Yes.
And you agree with that?
Yes.
You feel you need any more time to talk to him about that decision?
No.
Okay. I'm satisfied. Well, first of all, Mr. Saunders, any further inquiry you'd like me to make regarding 315?
No.
Mr. Freilich?
No, Your Honor. Thank you.
I'm satisfied that Ms. Schabusiness has indicated that she would like me to read 315 to the jury. And as a result of that, I'm going to do that. The only other topic I want to take up with the attorneys, and then of course I'll ask generally whether you have anything you want to raise with me. Oftentimes I get a request, I usually read these in order. Oftentimes I get a request to have 160 closing arguments read just before you give the closing arguments, which would mean it's right after 315. Before closings, and then obviously after closings, I read 460. Any objection to my reading 160 just before closings, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay, I'm going to have 160 then. I'll slide that in just before 315. Strike that, just after 315. Okay. Mr. Saunders, are there any other topics or issues regarding the instructions that you'd like to bring up with me?
No.
You're satisfied with the instructions and the order in which I propose to give them?
Yes.
Mr. Freilich, any topics you'd like to raise regarding the instructions?
No, I would not, Your Honor. I'm in agreement with the form of the instructions.
And the order with which I propose to give them?
Yes, I am.
Very good. Then, before I ask you about durations of closings, I guess what I would just indicate is I intend to bring the jury out. I intend to instruct them right up through the closing instruction. Attorneys can close. There will be potentially some rebuttal closing. And then we'll select the alternate and the deliberations will be underway. Anything to bring up before we do that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay. Then with that, we'll bring the jury in.
Okay, so I'm going to answer this in a second. Scott Roush says, in Wisconsin law, consent is lost if either party loses consciousness. Sort of. That definition comes from State v. Curtis, which says that the criminal jury instructions say that it felt the common meaning of unconsciousness included the loss of awareness caused by intoxication, the taking of drugs, or heavy sleep.
Principles of law, which
Not
you are to
death.
follow in considering the evidence and in reaching your verdict.
There's more to it.
It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. In this first phase of the trial, you have heard evidence that dealt solely with the defendant's conduct during the alleged incident. You are to determine only whether the defendant is guilty of the charges of first-degree intentional homicide, mutilating a corpse, and third-degree sexual assault. If you find the defendant not guilty, the trial will be over. If you find the defendant guilty, the trial will proceed to the second phase, where you will determine whether the defendant was not responsible by reason of mental disease or defect.
They'll still have to do closing arguments. I don't know if they're going to do those today.
Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. The first count of the information in this case charges that, count 1, the above-named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did cause the death of Shad Therian with the intent to kill that person, contrary to sections 940.01 sub 1 sub A, 939.62 sub 1 sub C Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, the defendant caused the death of Shad Therian. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill Shad Therian. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that her conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent.
I genuinely don't think they
Intent to
proved
kill must be
intent,
found,
even though I
if
think the
found
jury
at all,
will find her
from the
guilty.
defendant's acts, words, and statements, if any, and from the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Shad Therian with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The second count of the information charges that count 2, the above-named defendant on or about Tuesday, February 22nd, 2022,
Knowing what
in the
she
city
was
of Green
doing
Bay, Brown
could
County,
kill
Wisconsin,
him
did
is not
dismember a
intending
corpse
to kill him.
with the intent
That's
to conceal
reckless
a crime,
disregard. That's
contrary to
reckless
section
homicide.
940.11 sub 1 and 939.62 sub 1 sub D of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 1 of the Criminal Code of Wisconsin is violated by one who mutilates, disfigures, or dismembers a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant dismembered a corpse. Second, that the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The third count of the information charges that, count 3, the above named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did have sexual intercourse with Shad Therian without that person's consent, contrary to sections 940.225 sub 3 sub A and 939.62 sub 1 sub B of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense be charged beyond a reasonable doubt. Third degree sexual assault, as defined in section 940.225 sub 3 sub A of the Criminal Code of Wisconsin, is committed by one who has sexual intercourse with another person without consent. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant had sexual intercourse with Shad Therian. Second, that Shad Therian did not consent to the sexual intercourse. Sexual intercourse means any intrusion, however slight, of any part of a person's body or of any object into the genitalia or anal opening of another. Emission of semen is not required. Did not consent means that Shad Therian did not freely agree to have sexual intercourse with the defendant. In deciding whether Shad Therian did not consent, you should consider what the defendant said and did, along with all the other facts and circumstances. This element does not require that Shad Therian offered physical resistance. It is immaterial whether Shad Therian is dead or alive at the time of the sexual intercourse. If you are satisfied beyond a reasonable doubt that both elements of third-degree sexual assault have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. An intoxicated or drugged condition is a defense to criminal liability only if it is involuntarily produced. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. An information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing the testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. During the trial, the court has ordered certain testimony to be stricken. Yes, disregard all stricken testimony. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the attorneys are not evidence. If the remark suggested certain facts not in evidence, disregard the suggestion. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. Whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was actually restated here at trial. And whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all of the other evidence in determining how much weight, if any, the statement deserves. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than the testimony of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. If you find that the offense charge was committed by the defendant, it is not necessary for the state to prove that the offense was committed on the precise date alleged in the information. If the evidence shows beyond a reasonable doubt that the offense was committed on a date near the alleged date, that is sufficient. It is the duty of the jury to scrutinize and to weigh the testimony of each witness and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based upon the witness's race, national origin, religion, age, ability, gender identity.
You must avoid
sexual
your
orientation,
unconscious
education,
bias.
income
Oh,
level,
okay.
or any other personal characteristic.
So fucking dumb.
In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit the testimony. Then, give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence and under the instructions given to you by the court. We're now ready for the attorneys to give their closing arguments. I want to speak briefly, however, to both the attorneys that are giving the closing
They're not going to
arguments.
do them today. They're not going to do closing arguments today. It's 4:07. Yeah, they modify them for this specific case, and then okay. All right. So getting back to this, I want to finish telling that story while I have a second. Criminal informant. Criminal informant happens to be present when they're gonna do the search and happens to place the items in the garbage can that will be the evidence that they use to
Ladies and
justify a full
gentlemen,
raid on the
in
house.
the event you were wondering, you are going to get a copy of these instructions during your deliberations, because I know they're lengthy. Having said that, Mr. Saunders, are you prepared to give a closing argument?
Yes, Your Honor.
Very good.
Oh, they're gonna give them now.
I want to start with something that we heard yesterday, or actually Monday, during opening statements. Counsel told us that there's always two sides to every story, and with all due respect, this is not one of those stories.
What?
This is a story that pretty clearly shows what happened. It's a story of the defendant taking a dog collar that was around her friend's neck and pulling it so hard and for so long and with such force that it caused his death. That in that moment, she made a deliberate choice to end her friend's life. She then, after the fact, degrades his body, engages in sexual acts with him. This is a story of the defendant then dismembering him and leaving his remains all over the house for his mother to find. And this isn't the state's story. This isn't law enforcement's story. It's the defendant's story, as you heard today, right? So as we go through this, it's easy to sit here and say, yes, the defendant confessed, and it's true. She confessed to every single element that you will see that the state needs to prove. But we didn't just stop there, right? We could have been done with this case on Monday, later interview, and called it a day. But you should expect more, right? We have the burden of proof, and obviously we called a number of witnesses to establish what this story shows.
Close to
So I wanna walk
objecting on
through
that.
story. And I know there's a lot of law that was just read to you, but I'm a
Yeah,
visual,
I
so I like
know.
to
There's a
see
lot
kinda
of
what we're
law
looking at
out
here.
there for
So
you
as I
guys.
go through these three offenses, there's really, as you'll see, 6 things the state needs to prove beyond a reasonable doubt. Not every fact that was testified to, not what time somebody got to Scott Holmes' house at the end of the night. The 6 elements. Are
I
what
don't
the
like
state
this
needs to prove beyond a
nonchalant
reasonable
style he's
doubt.
got. I don't like this at
So
all.
first, count 1, first-degree intentional homicide. First, that the defendant caused the death of Shad, and that she, second, acted with intent to kill him. Okay. And again, as I already mentioned, as we go through these elements, you heard earlier this morning that the defendant is acknowledging every element that we hear. Okay?
I don't agree with that.
Independent of the information you heard today, with the investigation you heard, the DNA, the other information, Dr. Tranquita's testimony, I would argue would prove all these elements as well. But you have on top of that the defendant's admissions to all these elements. Okay, so the defendant caused the death of Shad. I mean, that should be fairly clear here. Obviously, she admits that. You heard Dr. Tranquita's testimony of how Shad died, the cause and the manner of death, strangulation, excessive force being placed on the neck, producing his death. That was the sole cause of death that we heard. So let's talk about intent, right? Because that admittedly sometimes is a tricky topic, right? We can never know anyone's intent truly. And as you're told, you're not going into the mind of somebody, right? Kind of looking at all the facts and circumstances that you see. In this case, you have the benefit of the defendant opening up her mind to you and telling you what her intent was here. But you also
Only
have
if you
other signs,
disregard the other statements
so
she
what does
made.
intent mean? That somebody had the mental purpose to do something, right? Some volition. Or that they're aware that what they're doing is practically certain to cause that result, right? And you heard both, really, from the defendant.
I think he's just
So I
mad
wanna
she
walk
removed
through
another
that
target
because
from the dating pool
There's
for
a lot
him.
of points in that interview where the defendant is telling you exactly what her intent was in this case, right? His face was turning purple, right? She describes that and how he's coughing up blood. And you know that's accurate, right? Because you heard Dr. Tranquita's testimony and you saw those photographs. She's seeing that in person, and yet what does she say? I still didn't stop. No, she felt a heartbeat at one point, right? She talks about feeling his heartbeat, and she kept pulling more, and he wouldn't die. I just wanted him. I was like, damn, right? She admits even that Shad's struggling in this moment, that he's fighting back, right? You heard from Dr. Tranquita as well about how it looked like at one point there were signs of that, where the collar slipped up along the tongue. She's telling you, I was waiting for him to die. I liked it. She figured I'm already this far, and she's pantomiming the act. It's like she's starting a lawnmower. That's how hard she's pulling on this chain, right? Took 3 to 5 minutes, she thinks. And again, that's consistent with Dr. Tranquita, right? This is not an accident. This isn't a whoops. This is an intentional act, right?
I mean,
I don't need to prove that she went to that
You're
house with
ignoring
this
that
intent.
she said it
We're gonna
was an
talk about that in
accident. She
blood
didn't
here.
want him to
Kind of
die.
talk
She
through
didn't
that
intend for him to
concept of
die.
how,
You're
as
ignoring that.
instructed, intent can be formed in the instant before an act, the instant before the pull of a trigger, the instant in this case, before Ms. Schabusiness decides, I'm going to go further and pull on this chain so hard that it causes the result that we saw in Shad, right? So we have the mental purpose, right, from the defendant's own mouth, and that's consistent with everything else we're seeing in the case. But you also have Detective Kempf asking her, I mean, in that moment, did you kind of realize if you kept pulling on that chain that he would die? She's like, probably, yeah. Yeah, she was aware of that, right? So that goes to this kind of the second either or part of intent, right? Was aware that her conduct was practically certain to cause that result, and it's probably obvious as you sit here of what's going to happen when you're pulling a metal chain like that hard for that long, seeing the result of what's happening to another person, that is going to be the result, right?
Right.
So
I don't know. Is that right?
you're told you can't look into a person's mind. The defendant told you exactly what her intent was in this case. But as
Again,
I mentioned,
only if
you
you
also have
ignore her other
indicators,
statements
right?
about
Dr.
intent.
Tranquita's testimony describing the amount of force that would need to have been done to cause the injuries that he's observing, right? Down
Stop
to the
saying
inner
right.
neck muscles, and he was talking about how strong and thick those neck muscles are, and there was hemorrhaging that deep. That's how hard and how long and how much injury the defendant was
Problem
causing.
is, I have no faith in her defense
Right,
attorney
this
to
isn't
deliver
an accident.
closed.
If it's an accident, you're not going forward. You're not seeing this result and keep pulling. You're calling for help. You're stopping.
Calling for
You're
help.
certainly not after the fact, after you finally finish then cutting up his body, right?
That has nothing to do with
You
intent.
have all the evidence in this case points to intent, right?
Cutting up a body does not point to intent in any way
However,
unless you
after the
actually can
fact,
do
like I
that.
said, if this was an accident, something happens, right? You call for help, and that you have the exact
I would
opposite.
object
You
to
have the
that.
defendant cutting him up and cleaning up, getting rid of the remains, pouring it down the shower. We heard a lot of testimony about that. Kind of wiping up with the Clorox wipes, which the defendant is acknowledging as well. So you have the defendant's statement in the case, and it lines up with everything else in the case, right?
Just
Even
go ahead and
little facts
object.
that she's remembered.
What are you going to do,
telling
cause a
you,
mistrial?
right? The timeline of the February 21st night, right? We heard from AJ Gannon. You heard the stipulated testimony from Mr. Tomes. You heard from Mike Therian. It's all consistent. Yeah, they were coming and going. You then heard from Steve Hendricks about, yep, they got back sometime in the early morning and I let them in. Defendant's telling you that same thing. Steve is talking about how at one point during the day on the 22nd, she comes up and asks for her eyeglasses. And we heard the defendant talk about that as well. We heard Detective Graff testify about that. So everything she's saying is consistent with what we're objectively seeing, what law enforcement is finding. And in some respects, the defendant's leading the investigation, right? Because when they get there, when law enforcement gets there, we saw Officer Wanish's body.
I would take that line, everything
We heard from
she's
Detective
saying
Scanlon and even
is
Dr.
to be
Shankita about
effectively
how it was
believed and run
really
with that
hard
in
to
my
determine what
defense.
exactly happened when they first got there. And all that information is being provided by the defendant. Okay. So it's an intentional act. She had the mental purpose. We heard about that. It's not, as I talked about, it can be formed at any time before the act, right? It doesn't need to be premeditated. That's not the law in this state. And it's really important too to not confuse this with motive, right? We heard evidence about motive, right? And her interest in Jeffrey Dahmer and all that entails. But intent doesn't mean motive. This is what intent means. And we proved intent, right?
Just
She
casually
caused
dropping the
his death.
Dahmer
She
in
acted
there.
intentionally, and she told you as much. So those are the two elements. Those are the two things the state needs to prove beyond a reasonable doubt. Count two, mutilating a corpse. So again, there's two elements for this crime. First, the defendant dismembered a corpse. Second, did so with the intent to conceal a crime. So the first element, I think, is pretty clear, right? And we heard extensive testimony from many people, and we saw Dr. Tranquita's diagrams, and obviously I can't imagine this element is going to be in dispute, right? And so again, though, we have this concept of intent, the purpose to conceal a crime, right? And I mean, as you're instructed, you use your common sense.
This
Like,
one seems obvious.
why is
She's
somebody going
definitely
to
guilty of
length?
this.
Not only cutting up a body, we heard from Dr. Tranquita about the multiple sort of start and stop kind of signs, the total evisceration of Shad, bagging him into other bags and attempting to carry out. Like, that's the intent, right? We use our common sense that's why you're doing that.
Right.
But again, she was asked about this. The
Why are
defense-
you rambling through this?
Remember in that
This one's a
February
slam
28th
dunk.
interview, the second interview with Detective Graff and Detective Scanlon. She's saying exactly what her intent was, right? It was because there's other people in the house. Like, what am I going to do? Leave the body and have mom find it? She admits, again, this was her intent, and it's obvious with our common sense, but it shows that the state has proved both elements of this crime as well. Okay, count three. It's third-degree sexual assault. So the defendant had sexual intercourse with Shad and did so without consent. So let's talk about the first part. Sexual intercourse is defined in this state as inserting any object into the genital or anal opening of another, or engaging in oral contact with the penis. We heard about both, right? The defendant admitted to both. She's talking about how she's put the dildo in Chad's anus after she killed him. She's talking about how she was sucking on his penis, and there were other phrases used to that effect. So again, we have for both elements here, the defendant's admissions. And we heard from Mr. Scott, didn't we? We heard from Mr. Scott about the DNA testing that was done, right? And for some of the reasons why, even though the defendant's DNA is on that dildo in Shad's house, Shad's DNA wasn't found on there, and nothing excludes that possibility. And again, everything the defendant's telling you is consistent with other things you're seeing. So there's no reason to believe, a reasonable hypothesis to believe, that she's not also telling you what's happened in this case too, right, for this count. And the second element, did not consent. I mean, that, as you're instructed, is kind of inferred by the fact that at the time that the defendant's telling you she's engaging in these acts, that Shad's deceased, right? So he's not in a position to consent. Okay. So those are the two elements for count 3. So in total, 6 elements for the 3 offenses. And again, you're given a lot of law on how to assess credibility of witnesses, and that's good, and you should follow it. Really, you kind of just use your common sense as jurors. And again, the defendant's telling you what happened, and there's nothing in the case to disbelieve what she's saying, right?
Nothing to disbelieve what she's saying. Run with that. I would 100% steal that
As I
line.
mentioned earlier.
If he's
There's
going to say
other
there's
evidence
nothing
that
to
kinda just
disbelieve,
only should
here.
bolster the
I
conviction
didn't
and
mean
the
to,
defendant's
didn't try
guilt.
to, didn't want him to die.
Right, we heard from Kevin Scott, who heard or testified about the DNA testing he did. Shad's blood on the defendant's hands.
We were going to have sex.
Clothing and sweatpants.
Consent.
About how the knives that were found had Shad's blood on them. Right. Even absent her confession, I mean, there's ample evidence here to convict on all 3 counts. You have many witnesses coming in to talk about the integrity of the investigation, how law enforcement didn't just take the confession and go home, right? We do more, right? Send things in for DNA. We speak with other witnesses. We corroborate the defendant's timeline of things. You heard all that. And that's really important, right? We have the burden of proof. We talked about that, and we embrace that burden of proof.
We
You
embrace
should
it.
hold us to that standard as the state to prove something beyond a reasonable doubt. And that's why we call
You have
people
to.
from
Not you should,
past
you
to come up
have
and
to.
talk for 5 minutes about, yeah, I received this piece of evidence and it was fine. And I returned that piece of evidence and it was fine. Right? Because it's important. We want to show that law enforcement did a thorough investigation in this case. And they did.
And they
Because
did.
we have the burden of proof. You're instructed on what the burden of proof is and what it's not, right? It's a reasonable doubt, a reasonable hypothesis consistent with guilt, consistent with innocence. You should find the defendant not guilty. You're not searching for doubt. You're ultimately searching for the truth. So even if it's a heavy burden, it doesn't mean the decision is difficult in cases. You are instructed not to search for doubt. You're to search for the truth. And there's not a reasonable hypothesis in this case consistent with the defendant's innocence. There just isn't, right?
Sure there is. Well, not with her innocence, just not with her guilt on intent.
There's one truth in this case. There's one side of the story, and it happens to be the defendant's story as well, but it's consistent with everyone else's story. It's because that story is the truth of what the defendant did to her friend Shad. And based on that, we would ask that you return guilty verdicts on all 3 counts. Thank you.
At least he kept it short.
Mr. Fairley, are you ready to make your closing argument?
Yes, I am, Your Honor. Thank you.
So in the Rumble chat, real quick, someone is raising that she's admitting to intent, et cetera, because we're taking her at her word here. But you have 2 different words being said by her in the same statement. Remember, there's a different balance of
Well,
burdens.
as
We're
the
taking
attorney
all of
for
her statements as
the
true,
Taylor, Denise Schabusiness,
then her counterbalancing arguments
to,
weigh in favor of reasonable doubt, because
share
it's
with
not
you
a
that,
50-50 scale
I
here.
believe this case
It's a
is
95-5
a puzzling, unclear,
scale.
confusing, and bizarre set of facts. It is unknown what really happened between February 22nd of 2022 and February 23rd of 2022.
He's going to fuck this up bad, though.
What we do know in this case is that numerous law enforcement officers officers testified. We had detectives, we had police officers, we had Dr. Trankita, and DNA experts, forensic specialists, lots of different people, some citizen witnesses. I'd ask that you consider setting aside your emotions and decide this case based on the facts that have been presented. You've sat here for the last 3 days. You've been here in court. I know that you've listened very closely, but don't assume anything. When you deliberate about all of the facts. What we do know is that law enforcement officers on February 23rd of 2022 went to 829 Stony Brook Lane in Green Bay, this small Cape Cod home, and made contact with the occupants, Tara Pakinich, Stephen Hendricks, and Ava Wheelock was woken up, but they were all sitting at the kitchen table, and officers came in to see what was going on. There was a concern, obviously, that there was a bucket down at the end of the stairs. And we heard from Detective Groff that this was an ongoing investigation, law enforcement. They were trying to piece this together. It was an unusual situation. So they were trying to find out what happened.
So they led her to
Unfortunately,
confessing while she was under the
it was,
influence of
Officer
substances.
Plonky and Officer
Fucking dumb.
Marsh, they testified. They came here. And
Give him the
indicated
death
they went
penalty.
down to check out what was in the basement, and there was a head. It was the head of Shad Thurian in that black Fleet Farm bucket. And the investigation continued on. But what I submit to you, ladies and gentlemen, is that there really are no eyewitnesses as to what really happened down in the basement.
I mean, no one's
There's
hot. How
Taylor
can we know?
Schabusiness there, no other people there.
No Taylor
And so
Schabusiness?
that'll be something that you'll have to consider and think about.
What did you just
Then
say?
Law enforcement realized that there was a secondary scene, and that was at 2353 Eastman Avenue, apartment 1 in that parking lot. And you saw the video. The officers, I think it was Officer Garth Russell.
Well, no one saw her down there.
Thank you. The officers walked up and they parked a distance away, and they walked up in the snow, and they saw a line of cars in front of the apartment complex. And they saw that they saw a minivan. It's a gold Town and Country Chrysler minivan, and that was a vehicle of concern. Had some snow on the back windshield. There were vehicles on either side. And the officers walked up, and they heard or they saw some lights on the van. And then they saw someone come out the front door, and it was my client. It was Taylor Schabusiness. At that point, she was arrested by Officer Russell, and another officer then realized there was a male inside of the apartment number 1 down the hall. Ended up being Scott Tomes, and he was told to lay on the ground and held at gunpoint, and then he was arrested. So 2 people were taken from the apartment building and taken down to the police station.
Might have been the other guy.
There was a search of the Eastman Avenue apartment. We don't have any body parts there. I would submit that there really wasn't anything of evidentiary value there. And that was that. Later on, officers and detectives realized that minivan was something that they were concerned about. So that was taken down to the police storage garage. And then we found out that from Dr. Trankita and some of the other forensic specialists, Andre, I believe it was investigator Andre, and Zarnecki.
You
So
believe?
they donned Tyvek gear, protective PPE equipment, and they methodically investigated the back of the minivan, and they found the crock pot box that was in a laundry basket sitting on a seat, and there were human remains in there. Nobody saw Taylor Schabusiness driving this minivan. So these are some of the facts that you gotta think about. Don't rush to judgment, but talk about it, analyze it. As jurors, you have to analyze the facts that you hear and you have to apply the law that the judge gives you. It's a daunting task. So then we hear, you saw the video, the interview between Detective Groff and my client,
video
Taylor Schabusiness.
or whatever.
She was taken down to the Green Bay Police Department. Photographs were taken of her and clothes were taken. And she was put in a yellow suit and then later a blue suit, but she was asked questions. And you got to remember what she said and what questions were being asked. She did say during the interview, I can't think right now. I'm effing nuts. She said that she was up all night, that the body would rebuild itself. She said weird, odd
This is for your
things.
next phase, bro.
Consider her credibility. Consider what she says. Consider what she said to Detective Groff or Detective Scanlon. She said stuff, I would submit that she said things that didn't make sense. She says, I have no idea to some of the questions that the detectives asked her. You remember seeing the video on the screen. I'd ask that you recall that she had inappropriate laughs, inappropriate smiling, odd responses.
Point to the statements that undermine the elements of the crimes, you
I
fucking
would submit
dummy.
that she indicated that she did not have sex. She did not have penis to vagina intercourse with Schabusiness. She
That's not
indicated
a-
that she came to the residence and they went downstairs and within 5 minutes they got
It's
to
not
it.
a required element, you idiot.
She talked about during the interview with Detective Groff rebuilding muscle or rebuilding into muscle. Sometimes she wasn't responsive. She talked about hearing gunshots. But
Look at
I
her.
believe Detective Groff said that
It's like,
there
what
were no
the hell is he
gunshots in the
talking
area of
about?
Stony Brook. Eastman Avenue was some other place. She said she was paranoid.
She has no idea what defense he's raising.
She said weird things like, I don't like open spaces. I don't like open spaces.
Maybe she'll unintentionally peg and kill him too.
No clothes came off. No kissing. She said that she allegedly put the dildo into Mr. Therian's backside, his butt area.
You
his
just
anal
admitted
area.
to the element of the crime.
There's
Thanks.
no DNA. We heard from Kevin Scott, DNA
No,
expert.
there actually was DNA. It was just
He must have done real well in
non-inclusive,
school.
but it wasn't
Chemistry and all that.
exclusive.
But the swab from the dildo, item J1, it says the possible contribution of DNA from Schabusiness is inconclusive due to the complexity of the mixture. I would argue that his DNA is not on the dildo.
You would argue that. Just say it's
there's-
not on the dildo.
I would
I'm
argue
not
that
confident.
even though the state is charging out third-degree sexual assault, there is no shred of evidence to support that particular charge. And I'd ask that you take that into account. No evidence at the Eastman Avenue apartment. When Detective Groff had my client come down to the Green Bay Police Department with Detective Kevin Kempf, they were talking with her for a while. The interview was maybe 3 hours or so. And then they took a break because Ms. Schabusiness had cuts on her thumb, scratches on her palms, other cuts on her fingers.
Where'd she get
Some of
those?
them were deep. You saw the pictures.
Not from the
Yes, I
knife
believe
she
they were
used to
published.
cut up a body.
And
if
she was taken
wasn't
over to
around.
St. Vincent's Hospital for medical evaluation. I would submit that the blood on her hands may have been her own because of the deep cuts that she had suffered or that she had. The defense had subpoenaed Mr. Scott Tomes. He was unavailable, and he gave an account of that night. And he had indicated, at least on Monday night, that would have been February 21st, that Taylor Schabusiness and her friend Shad came over. He had seen Shad before, but didn't know his name. And then he thought that they hooked up to do meth. And then he talked about his vehicle. And he talked about that Taylor Schabusiness had used his vehicle in the past and
Here
didn't get
comes,
permission on that particular night.
The
And
other
he
guy
indicated
did
that he
it
was,
theory.
Drinking. And then he indicated that Taylor Schabusiness returned to his house around midnight with his vehicle, went to her bedroom, and he had a suspicion that she may have been high on drugs. And then he had indicated that Taylor had the bedroom and that he would sleep in his chair. So that's, something else that you have to think about. We heard
You have to think about,
from
please, maybe.
Lieutenant Buckman.
Think about other things.
He was
if you
a
will.
veteran on the Green Bay Police Department, and that he was doing some investigating, and he wasn't sure if Taylor Schabusiness was a suspect or a victim because it was an ongoing new investigation. So that's something you have to take into account as well.
This guy took the seeds of reasonable doubt and shoved him into
the
Shad's
state
severed pee
brought
hole.
up some photographs, a picture of Taylor with her phone. And young girls, I submit, they like their phones. So do all kids, young people. They
The
like their
young
phones. And they
people,
look
they
up
love their
things on the
phones.
internet
Those young people,
for
they
a
look
variety
up
of different
stuff.
reasons: shock value, curiosity. But we have a situation here where
Those crazy
Taylor
Zoomers.
did do some searches about Jeffrey Dahmer. I would submit that that's a ruse, that doesn't necessarily mean anything, and that people search the internet for all kinds of things on the internet, and that it's for shock value. So that shouldn't really play any part in this case. I would ask that you discount that and set that aside.
Why are you calling attention to it? They breezed it in clothes.
Now, I would
They
argue
literally
that
just
I
breezed
don't believe, I
past
would argue
Dahmer.
that it's not a clear case here. Was this an accidental death? Did Taylor
Final-
Schabusiness kill Shad Therian?
Wait, what?
Was there intent to kill Shad Therian?
Point to all her statements where she said no.
Did Taylor Schabusiness have the mental purpose to kill Shad Therian?
Point to all her statements where she said she didn't. Please, come on,
Different
do anything.
theories, different things for you to think about. You are all like analysts. You have to assess and decipher the facts.
Point them to
Facts
the
here are very
facts.
complicated, confusing.
Tell them what they
unclear.
are. Oh,
Two
they've been
different
listening to
locations.
shit all day.
No
Tell 'em.
eyewitnesses. Taylor Schabusiness, we learned that she went to school with Shad Therian, middle school,
So?
Bayport High School. They were friends. They hung out. You heard from AJ Gannon. He hung out with them as well. Can you trust what someone says when they're hopped up on meth? On drugs? The state wants you to look into Taylor Schabusiness's mind to find out what her intent was.
No, they said listen to
That's
her
a
words. It was
difficult
much
task.
better. No, it's a much better argument, and I hate that
Did
guy.
she have a clear mind on February 22nd of 2022 as to what was really going on? Accidents can happen.
Objection, Your Honor. Lack
When
of
accidents
noose in the
happen.
courtroom for this guy.
People can make other choices in a panic. Something for you to think about. this sexual assault charge, how can you have sexual intercourse with the facts that have been laid out and presented to you? It's mind-boggling.
Fact, she had sex with the butt of the corpse, homie.
How can you have sex when genitals are in one place and body's in a different place?
Because she shoved something in his
It's
butt.
foggy. It's cloudy. It's hard to imagine. Almost impossible.
It's
Try and
literally
figure
an
out
element to
what
shove
did or didn't
something in the
happen.
butt.
I would submit to you that no sexual assault occurred. I'd ask that you find her not guilty of third-degree sexual assault.
Oh my
You
God.
can't rely on everything Taylor
Just attack the
Schabusiness says.
consent.
Think about that, please. She chose not to testify under our Constitution of the United States of America. She doesn't have to testify. That's what the law provides. You don't
The
have to
judge
take the witness stand. You have a
already
right to
instructed
remain
on
silent,
this.
and you can't use that fact alone against her.
No, you can't
I
use
would
that fact
argue
against her at
that
all, not just
Based
alone.
on all of the evidence and the testimony in this case, that you find my client not guilty of all the charges. Thank you very much for your time.
That was the worst closing you could give for this. There are facts to work with. There are elements to attack, and he didn't do any of it.
This case is puzzling. This case is bizarre.
Why are you even
This
rebutting
case is in
just
absolutely
everything
no
that
way
guy
unclear.
said? But just decide for
It
us
is
because
crystal
he was
clear
so
what
dumb.
happened to Shathirian. And we know that. We know that because the defendant told you. She told you what she did to Shathirian. Is it bizarre? Is it unnatural? Is it strange? Yes, absolutely. People do bizarre, unnatural, strange things. They engage in criminal conduct. People kill other people and they dismember them. That's what Taylor Schabusiness did. And we know exactly what she did because the words from her mouth told you with specificity what she did.
This guy's got the best demeanor of all
Do we
of them.
trust always what Taylor Schabusiness says? No, but as Mr. Saunders told you, we trust, but we verify. We didn't stop at taking her statement. We corroborated. She guided the investigation with the specificity of her statement.
Way better argument.
How can we not trust her statement when she describes in detail the mechanism of injury, which is exactly what is described and confirmed by Dr. Tranquita? Excessive strangulation over a period of time with layers of injury, exactly as she described it. Described that his tongue would be out. She described that. Dr. Tranquita described that and showed you that. She described his struggle. He's struggling for his life and she continues to pull that chain, demonstrating her intent to kill Shathirian. And we know that because we see that in the physical evidence.
He could have provided
We see
counter
the
argument
marks on
for
Shad's
this
tongue.
from her.
We see the
and he
damage to
didn't.
his neck. She described to you what she did with his body after she killed Shad. And we know that it's true because the body parts were exactly where she told you they were. Detectives are finding everything she says on scene, and you saw it with your own eyes, that just what she told you is exactly where those things were located in that residence. She wasn't cloudy. She wasn't unclear. She wasn't hopped up on drugs. She knew where to find the drugs. She knew where they'd find the pipe. She knew where they'd find the chains. She knew where they'd find the knives. She knew the name of the bag where the body parts were going to be located. She could tell you that she put the organs in plastic bags. She could tell you that she cleaned up with Clorox wipes and she put them in the bags as well. She could tell you that his lower extremities were in the car. This is the most specific confession anyone could ask for, and it is corroborated in detail by the work of the Green Bay Police Department. This is bizarre. This is strange. This is unnatural, but it is in no way unclear. We know exactly what happened. We know exactly what Taylor intended to happen for all three of these offenses.
This guy's doing fantastic, by the way.
She
He's
engaged
way
in
better than the other
intentional
two.
conduct in each of these acts. You are asked to look at each of the 6 elements, and there are only the 6 elements that Attorney Saunders described to you. That as to count 1, she did cause Shad's death. There is no doubt she had the mental purpose to do that. And that she knew that her conduct was practically certain to cause it. She described to you how she visualized him struggling, blood coming out of his mouth, but she did not stop. He's turning purple, but she did not stop. He's coughing up blood. He's pissing himself, in her words, but she did not stop. This was a deliberate choice on her part to kill Shad Therian, and she knew that her actions were going to cause that. And in fact, she was asked whether or not she liked it, and she confirmed that she liked it. She was asked whether she was sexually aroused by killing him, and she said she was. Her mental purpose was clear. As to the mutilating the corpse, again, there's no doubt that she intentionally did that. She described the detail. She described her frustration as she's mutilating this corpse, and she described her purpose in doing so. How else am I going to get the body out of the house? How else am I going to get away with this if I don't cut this body up? And she didn't just cut it up and leave it there. She cut it up, she packaged it, she cleaned up after herself. Her purpose in dismembering Shad was clear. She wanted to attempt to get away with this crime. A crime that she intentionally committed, a crime that was not accidental, that was not a surprise to her, that she didn't wake up from this nightmare and then call the police and call Shad's mom. No, she made the second deliberate choice. After deliberately choosing to kill him, she deliberately chooses to dismember him and attempt to cover up her crimes. And likewise, the sexual assault is equally clear. There's no doubt that she had sexual intercourse. And for counsel to say that we can't merely accept the word of the defendant, you're asked routinely in sexual assault cases, juries are asked routinely to take the word of a crime victim with no physical evidence. We don't have to take the word of the crime victim. We have the word of the defendant who confesses to this crime and tells you exactly what she did, again, with specificity, and tells you, you know what, I did this and I did it with that dildo. And here's where you can find the dildo.
Hit that
It's in
lawyer.
the wall. It's in the box. I put it away. And what happened? They found it in the box, put away exactly where she described that it would be. And she clearly was sexually aroused by this whole incident. And she described that to you herself. So clearly it follows. It makes sense. It's logical. It is reasonable that she did exactly what she told you she did. There is absolutely no reasonable hypothesis consistent with her innocence.
There
The
is,
only
just not
hypothesis, the
presented.
only choice that you have before you here today is to find Taylor Schabusiness guilty of each and every count for which she is charged. All of those elements have been proven beyond a reasonable doubt, and I ask that you return a verdict of guilty. Thank you.
Are you just now realizing you had the worst defense attorney performance
has been argued by counsel. The court has instructed
ever?
you regarding the rules of law which should govern you in your deliberations.
Just ask
The
not
time
to
has
go
now
back.
come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 6 forms of verdict will be submitted to you concerning the charges against the defendant, Taylor Schabusiness. 1 reading, we the jury find the defendant, Taylor Schabusiness, guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, guilty of mutilating a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of mutilating a corpse as charged in count 2 of the information. Another reading, we, the jury, find the defendant, Taylor Schabusiness, guilty of third-degree sexual assault as charged in count 3 of the information. Another reading, we, the jury, find the defendant, Taylor Schabusiness, not guilty of third-degree sexual assault as charged in count 3 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the
Guilty.
information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have a question, the court will talk with the attorneys before answering it, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with this verdict. Now, ladies and gentlemen, this is the unfortunate time, because now is the time when we select the alternate jurors. Let me tell you what the process is going to be. The computer has selected
Very
4.
unfortunate.
We're going to read those names here shortly. If your name is read, I'm going to ask that you simply stand up and go have a seat in that first pew right there, because I'm going to want to address you, first pew right here, because it's open. And I'm going to address you after the other jurors have been excused. The remaining 12 jurors are going to participate in the deliberation process, and you will accompany the bailiffs to the jury room. If you're selected as an alternate, your participation in the case at this point will be concluded. I will make sure, however, that you
The odds on this case, man, if you bet a penny on not guilty and you win,
so at this time,
you'd be
I'm going to
Jeff
ask that the
Bezos.
clerk read the names of the 4 jurors that have been selected by the computer randomly.
Nicholas Rozek,
Ha ha ha! Just named the jury. Sure.
Sean,
There's another one. Nicholas Rozek. Now you got Sean something. And now they're showing them. They're showing them. Come on. I mean, ultimately doesn't matter because they're not jurors anymore. They're off, but absolute idiocy. Who's running the cameras? Is it Long Crime running the cameras? I think it's Long Crime running the cameras, right?
will, to the utmost of your ability, keep all jurors sworn on this trial in some private and convenient place, subject to the direction of the court, until they have agreed on their verdict or are discharged by the court, and that you will not, before they render their
Long
verdict,
Crime is
communicate
the
to any
least
person
competent
the state of their
organization
deliberations
in
or the
this
verdict
entire
they have
industry.
agreed upon, so help you God.
God, they fucking suck.
All rise for the jury.
They're a constant dumpster fire. You have one job. We're going to read the names right now. Maybe mute.
Might be seated. I want to first address Mr. Rozek, Mr. Lynette, Mr. Beerhalls, and Ms. Schrader. I want to thank you very much for your service on this case. You've all paid careful attention. I've been able to observe all of you throughout the trial, and I
Just
really
named all of them
appreciate that, and
again.
so do all
Good
the
job,
parties.
Judge.
At this time, your service in this case is completed. Many jurors ask if they're allowed to discuss the case with others at the conclusion of their service. Because your role in this case is over, you are not prohibited from discussing the case with anyone. However, you should know that you do not have to discuss the case with anyone or answer any questions about it from anyone other than from the court. This includes the parties, the lawyers, the media, or anyone else. If you do decide to discuss this case with anyone, I would suggest that you treat any discussion with a degree of solemnity such that whatever you do say, you would be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of the parties.
Oh, man, I'm
Finally,
good at
should
that.
any of you have any questions before you leave today, please let the bailiff know before you leave. And you can confer with me at any time before answering any questions asked by anyone if you choose. The bailiff is standing right back there.
To be clear,
I'm
the
just gonna ask
cameras
you
are
to
run
get up
by
and
Law
then
and
accompany
Crime.
her out that door, and if there's
Court
anything
TV
that
is
you
just
need to
using the
retrieve,
feed from Law and Crime.
But again, thank you for your service.
Law and Crime's employee is running the camera that docks the alternate jurors.
Anything to take up before we recess? Mr. Saunders?
No.
Mr. Freilich?
Not at this time.
Very good. Then we are in recess. I'd ask the parties to remain very close here to the courtroom for at least 30 minutes. Oftentimes, if questions come in, they come in early. After that, if you just simply leave a cell phone number where we can reach you, then you're free to depart. But I'd still ask you to remain close to the courthouse. But at this time, then, we are in recess.
Thank you.
So there you go. I mean, that was an atrocity of a close by the defense. But let me just say, for anyone who suggests that she had ineffective assistance of counsel, no. Perfectly effective, competent counsel under the standards of reviewing counsel. He picked a strategy and he argued the strategy. The strategy was shit. It was garbage. Everything about it was bad, but it was a comprehensible strategy argument for reasonable doubt. I would have done it way differently. I didn't even take notes, and I would have constructed a better closing argument while his was going, because there were several instances that he could point to and say, all right, the state wants you to take her at her word, but they're very convenient in leaving out words that they don't want you to listen to. First of all, she's under the influence of substances. She states it. Trazodone, methamphetamine. She's under the influence of these substances while she's doing this. You must factor in her ability to make reasonable decisions at the time that this is happening. Now I'm going to ask you to listen to what she said. They told you about this and this because they're the state. They believe she's guilty, and they're going to frame their arguments using just pieces of the evidence that they think are convenient to their case. And they're going to hope you forget the others, and they're going to rely on me not to pick up on them. But let me go ahead and tell you why the defense gets to go second. Because I get to tell you about all the stuff that the state conveniently omits from the record in the hopes that you weren't listening or that you weren't paying attention. Now, I know you guys are very good jurors. I know you guys have been sitting attentively through this whole trial. I'm very glad and thankful that you were paying attention to what was being said by everyone and listening. And I know you guys have been taking notes. But let me just point you to a couple points in her interview that are really important to understand here. She said, I did not want him to die. I did not intend to kill him. I loved him. I did not want this to happen. She said that when he was approaching that point, when his face was becoming discolored, that she saw him look up at her and say, keep going. And did she say she knew that he could possibly die? Well, of course. The moment you put your hand around your own neck, you know at some point you could possibly die. But did she want him to die? Did she intend that to happen? It's pretty clear that she never manifested that intent. She never wanted it to happen. Did she make some mistakes? Sure. Was she under the influence of drugs that may have impaired her ability to make rational and reasonable decisions on something like, how long can I apply this consensual sexual asphyxiation? That seems to have happened. Shad Therion unfortunately died. My client did not want it to happen. My client wanted the sexual encounter to continue. Not a death, not a murder. Intentional homicide is not appropriate here. And as the state said, you don't have to search into the mind of the client. It's been given to you. She has told you her intentions. And why do you have any reason to disbelieve her? She told you where she was. She told you what she did. She admitted to the death. She admitted to the dismemberment. She never admitted to intending to these things. This is an unfortunate accident, but it's not intentional homicide. And I would ask you to apply your reasoned doubt, taking the state at their word to find her not guilty. That's what she should have done, or he should have done. Way better defense. Hit on the actual elements. Use the state's arguments. That's why you go second. Is the jury going to buy it? In this case, I said a long time ago, I don't think she walks away with less than intentional murder. Said they'd probably find her guilty. The facts are too salacious. Everything sounds convenient for her. But if you're going to make an argument, you don't go, what? She might not have been there. No one saw her do it. That's insane. That is insane to take that as your tack on this case. She admits to being there. She tells you in detail how she was there, where everything was. She tells you where to find the body. She tells you where to find the dildo. She tells you about the knives she used. She tells you everything. Like, I mean, she said it was foggy and she doesn't know. Dumb, 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 dumb. At least attack the elements of the crime. Put reasonable doubt in front of them instead of just saying it's there. Don't pay homage to reasonable doubt. Show them where it is. Because there is reasonable doubt in this case. Again, if your evidence of intent is she said he could die and she kind of liked it versus I didn't want him to die, I didn't intend for him to die, remember the burdens are unequal. The state has to prove beyond a reasonable doubt that intent. If it's balanced 50-50 between them, and tell the jury this. Tell the jury if there's a conflict in her statements, I'm sorry, you have to apply reasonable doubt. Absent some other evidence that she had intent, you need to find in favor of no intent. All things being equal. You have to understand that she's having trouble communicating to the officers. She says it's a little bit difficult. Benefit of the doubt goes to the defendant. She is presumed innocent, and she has told you that she did not manifest that intent. And the state has said you have no reason to disbelieve what she said. So take the state up on their words and do not find the intent. Now, again, this should be in the context of making a motion for lesser included, reckless homicide, because you still get to argue insanity after the fact. Lots of procedural defects, in my opinion, from the defense here. This is not on the court, and it's not on the prosecutors at this point. This is on the defense attorney. And he gave the shittiest closing statement he could have possibly given, in my opinion. But that's my opinion. What does it matter? Not a lot. Not a lot in the long run. I just really, really wish that we would have demonstrations of competent counsel. That's it. Whiskey Sour says, your rant about the government reminds me of Thomas Paine, quote, government is a necessary evil in the best state, at its worst, an intolerable one. Stay groovy. It was a bastardization of Paine, yeah. Twisted Tragedy, they have to pick the alternate jurors before deliberation. If they go into the second phase, do the alternates continue to sit even though it wasn't their verdict in the first phase? Seems kind of weird. I don't know how that works, actually. Again, this two-phase thing is strange to me. I don't like it. I wish it wasn't done this way. I think they should have just argued the whole thing at once with all of the evidence presented to the jury, because I actually think that the insanity evidence that they'll present could show, again, reckless homicide, even because they're not going to win on insanity. Very clear. I have never, ever entertained the idea that she is insane, that this was done because of a mental defect. She's guilty, in my opinion, of reckless homicide by the elements, clear as day. First degree reckless homicide. Not guilty by insanity, no. But the insanity evidence, she's bipolar. She's on drugs that could have riddled her brain or whatever. Here's the mental effects of trazodone plus methamphetamine combined. They impair decision-making. They distort reality, whatever it is that they're going to argue. Those things all play into a reckless argument. And I think mitigating the ultimate outcome in this case was the more appropriate defense decision than trying for an outright victory that you weren't going to win. No way you should walk away from killing, dismembering, and raping a dead guy without going to prison for almost forever. It's either forever or almost forever. My argument is that it should be almost forever in this case, because I don't think it rises to first degree intentional. Drunk driving is a plausible defense as well. No, there's a specific drunk driving statute. And by the way, the drunk driving statute is effectively reckless homicide. If you're drunk driving and you kill someone in Wisconsin, I'm pretty sure it doesn't actually manifest in first degree murder in the same charges for it. You're going to get effectively a reckless homicide for that. Okay, so we've got A. Sib, welcome to Paralegal. Scott Rauch, welcome to Lawyer. Alex Jones says, I can see this whole scenario being an ICP song. Tina Lewis says, the only right these people are respecting is her right to not testify. All of her other constitutional rights are being totally ignored. It's sad, really. Worst part is that she's clearly given up. And to be clear, yes, I rant about the government, but the reason you have a defense attorney is to effectively help you in preserving the rights, because we cannot trust the government to do it. And her defense attorney failed, specifically on the witness that he wanted to bring in. He failed to help her enforce her right to examine and examine that guy, to question him. He failed. And his theory that he tries to present at closing is that it could have been that guy. Did you catch that? Well, she always asked before taking the van. She didn't ask this time, and she wasn't there. So the inferred implication is that it was the guy, the other guy, the missing witness. His case is stupid. His case is retarded. But this guy is a critical element of the case. He says it's him. And he doesn't push to have the court enforce the subpoena. Why? Why? Bad lawyer. Psh, bad lawyer. Phoenix Aram. Hey, Nick, did you hear they banned lolling in Hawaii? They want to keep it to a low. Ha. Godspeed, Boomer. Hope you're doing all right. I was doing better until that dad joke. Twisted Tragedy follow-up question. If they aren't keeping the alternates, which they are not, if she's, I mean, they're dismissed and named now, so I don't think that's happening. If she's found guilty, what if one of the jurors can't finish the second part of the trial? That's an auto mistrial, right? Since they don't have alternates now. You can't quote me on this because I don't know. I don't know. See, MLS Law Show. Thank you. That's what I've been saying. MLS Law Show says, argue that it wasn't intentional. He had plenty to go with on that. There was no evidence of intent at all. Now, I do think the state had evidence of intent. I just don't think it was sufficient to overcome their burden of proof. Personally, that's my opinion. But no, I'm right with you. I'm right with MLS Law Show. That guy's a practicing defense attorney. Listen to him. Don't listen to me. Listen to that guy. I would much rather have that guy defending me than Dopey on the camera there. It's terrible. But yeah, as far as the alternates go, don't quote me on this. But I think for that second phase, if you had a juror unable to finish, they would probably just finish with 11. I don't know on that, but I think that's how they would just do it. Or maybe they'll pick new alternates. I'm not sure. This two-phase thing is not something I'm familiar with, so I don't want to like speak too much on it. I don't know. Okay. Next, we've got Gassed Grunt says, what's the rules for name changes? I want to change mine to prosecutors or faggots. Figgots, so they have to say it every time they mention me. I don't know. Can you have a rule on a name change? That's actually okay. Let's talk about that for just a second. There's a group that applied for a trademark called the Slants. They're an Asian band, but their trademark was initially rejected because it was considered racist, right? Slant being a pejorative, derogatory label for Asians because of their slanty eyes, which helped them do math. That was the allegation. They took that to the Supreme Court and won. They won their case. The trademark was not able to infringe on that speech. Prosecutors are figgots, for example. Seems like a criticism of government. I don't know what reasonable basis they would have for preventing your name change. I mean, how do they get, if commercial speech and no prohibition on hate speech is sufficient to guarantee a trademark, could they deny a name change based on your government or your criticism of government protected speech? That's a very interesting question. Go for it. Do it. Okay. Let's go to Rumble here. Ben Dustin says, you're alive like a Frankenstein monster struck by lightning. 6'4" midget says, I have a theory. Schabusiness getting spit roasted by victim and red shirt guy. Then she wanted to spit roast red shirt guy. He says no and leaves. She then gets mad, takes it on the victim. He also says the bald-headed prosecutor has a literal mushroom stamp on top of his head. These are both true. I accept your theory without criticism. Schulzenator says, keep going on that rant. Can never be said enough. I think Law Nerd Clips said she clipped it. So you can check out Law Nerd Clips for that rant later if you just need a little bit of material. Two Eye Strung says the lawyers disagree on the language in the plea. State says it will allow future charges for crimes related. His lawyers say no deal unless the language is fixed. So that's the Biden, Hunter Biden. I'll be looking into that for tonight. Daisy Domergue says two-parter. I used meth for a month after several traumatic events. Went to jail for a day after destroying apartment in a blind rage while working up the courage for suicide. My mind was intact only enough to stop me from killing someone else. That night in jail, I decided to leave the country and never come back till I knew I had recovered. Took 5 years, temporary insanity. So there you go. There's a firsthand meth account. Ben Dustin says, the evasive detective meme is so bad. It makes me think a person who strangled her boyfriend in foreplay prior to molesting his corpse and chopping his body in bits was totally justified. Again, completely unreasonable for the detective to answer in the way he did. It bothers me when the government does this, and they do it all the time. Razor Wire says the cop is very jaded with the responses. I get that being in the field, he's in, you hear and see some terrible shit, but to seem not surprised by it, what the fuck? All right. Tyler Reeves. Oh, we covered that one. Chicken Richard says, thank you for the opportunity to hear a fair legal interpretation that even I can understand. I learn a lot every day and appreciate everything you do. Hey, you're welcome. You're welcome. Steel Leg of History. Welcome to Paralegal. Also says, I sent you a DM on Instagram. I need some help on something whenever you get a chance. It's okay. I know you're busy. I had a surgeon mess up my knee. Ooh, not fun. Rick Nikita, what mode of transportation will you be taking to Nashville? Asking for a friend. It'll be red. It'll have a racing stripe. Actually, two. See you there. Harry Dresden, PI. It always makes me laugh when they ask to identify the defendant. The real question is, would you hit it? Brady, welcome to Paralegal Salt. Hey, she's knocked to fuck out. She doesn't give a fuck about this case. Cicada Mania says, Taylor reminds me of Kim Deal from the Pixies. Salt A says, the courts and the Popo better mind Schabusiness. Sir Ian, message retracted. That's probably a good one then. Fire PA 498 in the voice of Mark Richards. I just killed my ex. Not the best idea. Killed his girlfriend next. How'd I get here? I just killed my ex. I still love him, though rather be in hell than alone. Jesus Crisp. Has she accused the state of kink shame? Should have gone with it. Better defense than her lawyer raised. Magnus F. Hansen says this chick doesn't read as devious enough to cover up rape, murder, and dismemberment as a drug-fueled pegging accident and subsequent freakout. That's a sentence I never thought I'd have to write. Me04120 says more like an unbreaded knife. Boom. Jacob, your opinion I thought was the only one that matters. Well, it is, but I have to lie and say it isn't. Russell Hall, this is fascinating. Now talk about Hunter Biden. I probably will tonight. I have to look into it, and I have to somehow find the time to do that. John Nussbaum says, what about extenuating circumstances? He wants to be pegged, disregard for his own life. Would that be a factor? He wants to be pegged equals disregard for his own life. Would that be a factor? It should be. Actually, if someone wants to be pegged, whatever happens to them next is irrelevant because they're done. They're done. They're transhuman at that point. Like, I'm not going to kink shame the fact that you want to be pegged. It just means that you're not worthy of constitutional, legal, moral, or ethical protections at all and should be in the dirt. Okay. DCV Titan, congrats to Kevin Spacey on being acquitted on all 9 counts in London. Lisa Franceschi, my first donation. I'm no longer a virgin. Oh, Lisa, happy to help you out with that. Thank you so much. Pinochet's helicopter tour says, in Minecraft, say I wanted to off an ex-tech mogul named Gil Bates. In the process, a bodyguard is iced along with Gil. Would murder one apply for the bodyguard? Most likely, yes. Unless he's also a communist and both of them are thrown out of the helicopter. The Silverleaf, why in the hell would a friend do this? We need full transparency, and now this. I hope this will not ruin videos moving forward. Wait, what? Why in the hell would a friend do this? We need full transparency, and now this. I hope this will not ruin videos moving forward. The Silverleaf, I have no idea what that means. Ruin videos moving forward. It's Erica J. You missed a lot, sir. I know, I did. That was the juror debacle. Jenny LJ, thank you for the sticker. Roving Cyclops, defense lawyer sounds like a super low IQ guy trying to argue his way out of a DUI roadside. Q Revere, just a thanks for that rant. Thank you. Talking Trash and Truths, Mitch McConnell just had a health episode on air at a press conference. They think he had a stroke, not sure. Oh, good. We get one too. We get Cocaine Mitch stroked out to battle that Pennsylvania senator. Calling meeting. Me04120 says Daryl Brooks never got an opportunity to cross-examine the red SUV or the state of Wisconsin. Oh, the text from the friend of the juror. Hope it doesn't ruin videos of the courts going forward. Makes sense. Thank you to Valdejean for that. I assume it's Valdejean, like Jean or Valdejean. I like Jean Valjean. Spectre says, I swore an oath to support and defend the Constitution of the United States. I don't have a choice. I have to defend the guilty's rights, innocent until proven guilty. Reform convicts. Civilian oversight with accountability is the only fix. Ninja Work 111. I'm not trying to simp for the government. I'm trying to simp for the victims. They're not victims of the accused until the accused is found guilty. Let's see. Holy Ozone says, yes, sir. Always appreciate your input. Thank you. Oh, Shoot, today's Tom's lawyer. I missed your first chat. Sorry about that. He says, I agree about overreaching, but why so mad in this case where defendant has opportunity to challenge everything? If witness was so important to defense, and defense could demand warrant to produce, right? I assume so, but I'm very muddled on why that didn't happen. That's the thing that I'm very confused about. Why he didn't ask for that and why he agreed to the stipulated facts. He said that the prosecutor told him right away, so demand a warrant or demand proof. I agree with you on that. But it's frustrating to me that the judge isn't asking for proof also. But I hold the defense attorney most accountable for that. Unless there's something I don't know. Tara Rayner says, Hunter's plea deal fell through. No immunity in future charges. Got an awesome screen grab of your face last night. Glad you and the family are safe. Thank you. Koof says, thank you all for not killing yourselves. I agree. Gamor says, you protect the obviously guilty for your own sake, not theirs. Sent from Australia. I hate it here. Think about it. Think about it. Just something for you to maybe think about there. Jesus Crisp has a two-parter. Has anybody seen the plaintiff in the courtroom? Grounds for dismissal based on maritime law. If there was a fantasy Ricada trial stream draft, I'd choose Brooks as defense attorney for Schabusiness. Kevin Lawrence, welcome to Paralegal. Van Saucy, the defense attorney sounds like Joe Pera. Grifty says, can I just refresh everyone of the morals of this story? 1, don't do meth. 2, men, don't be little sub bitches. Scarlock, Bob Iger is currently in the process of chopping up Disney and defiling the corpse. Is he giving Disney the Schabusiness? Is that a thing now? I hope so. J. Cal, she said he started to struggle during her choking, kind of implies retraction of consent. I disagree. Again, look, I'm not into choking and strangulation, okay? Not my thing. I don't want to be choked by anybody. It does not bring me sexual gratification in any way. But that said, if you're into that sort of thing, the struggle and the adrenaline and the race, I think, are part of it. Believe me, I'm into all sorts of other fun stuff, but not that. Like, that's not my thing. But my brain tells me, like, if you're into that, like that moment, like that's the thing that probably does it. Otherwise, why are you doing it? Like, I think that's the thing, that thought that maybe, no, like, I think that is the adrenaline and endorphin release for people. But I don't know. Maybe someone who's into choking can tell me. If anybody wants to talk about it, go ahead. Put it in the chat. That's just my thoughts on it. Clark, what is a transcribed interview? Heard it in regards to the Hunter Biden trial. It's an interview that they do that you just transcribe it into text. Brian Schultz says, I was able to keep watching the Rumble stream, but chat wasn't moving until I refreshed. Then it was hard down. Hard-nosed Polak. I know a chick who passes out when she gets off. Yeah, actually, that's a thing because it relates to blood pressure. The act of orgasm can cause a significant drop in blood pressure for some people, and it can cause, blood to move away from a head and cause a temporary sort of passing out. In the same way that standing up can cause some people to pass out, or walking upstairs, or other things. Sure. Lee Bob, when will your next painting stream with the boys be? I don't know. I've got a little bit of a difficulty in scheduling it because of some logistics coming up, but I will try and figure it out very soon. Aiken says, Daily Mail UK streaming a bunch of criminal actions by men just under the headline about this trial. I'm guessing because men bad, more men bad. Men. Scott Roush, in Wisconsin law, consent is lost if either party loses consciousness. She continued after he's dead, which is well past unconscious. Further, she saw his face turn purple when spitting up blood, which is a clear sign of life-threatening damage is taking place, which she said she ignored because she wanted to continue. Sorry, but I can't agree with consent continuing through such conditions. I'm going to mildly clarify. I don't think Wisconsin law says that consent is lost during loss of consciousness. I think Wisconsin law more precisely says consent cannot be given by someone who is not conscious. And the criminal jury instructions guide on that specific thing says a deep sleep, drug use, or what was the other one? Hold on, I've got it right here, I believe. You get it? That's right. Here, loss of awareness caused by intoxication, the taking of drugs, or heavy sleep is the definition given by the criminal jury instructions guide in the case where they talked about sleeping as a means of unconsciousness, which is State v. Curtis, 114 Wisconsin 2nd, 691, 1988 case. If you want to look it up and read it for yourself, I just gave it a skim. Not saying it's 100% authoritative, but that's where sleep and unconsciousness is referenced in the statute. That's the case that defines it. So there you go. But again, I don't think the law says you lose consent. I think it says you cannot give consent. Techno Toad says this trial would be hilarious if she had Daryl Brooks as her lawyer. And again, I just briefly going back to that. To me, it's more about the inability to commit an assault on a corpse, just as a matter of the nature of assault. There isn't a victim at that point. The corpse cannot be your victim, in my opinion. That's my opinion. K-Tribe, she did not intend to kill him. They did intend to have sex, so she's guilty of dismembering a corpse. That's my opinion based on my understanding. Am I right or wrong? I agree with that. The jury will not. Fret Pound says, this chick is no Jodi Arias. Dick Ricada, I would argue, is Darkside Phil's favorite phrase. I hated that in the close. Jacob says he's doing a better job in convicting her than the DA did. Yes. And Red One says, I think Taylor attacked the wrong lawyer. That seems to be objectively true. Couple more over on locals. The Iceman says, can consent be removed in the middle of coitus? Yes, absolutely. If you are in the middle of having sex with someone and they say, I need you to stop, consent is removed. But typically, for the purposes of criminal law, in my opinion, consent continues until affirmatively stopped. Because if someone says, well, I stopped consenting. Well, how? I just did. I don't buy it. And if you want consent to cease when someone becomes unconscious, I think there's a lot of problems with this, but if you want that to be the standard, write it into the law. Very simple solutions for all of this stuff. I argue it's not in the law. I think the law says you cannot give consent when you're unconscious. Not that it ends when you're unconscious. That's my opinion. That's my read. Ogonzo says, too bad jurors have the collective IQ of a potato. I 100% guarantee that the jury will think the Dahmer evidence is not only relevant, but they will think it was key. Poor Queen will likely be convicted for murder when it's clear as day. It's manslaughter. The prosecution barely focused on the Dahmer evidence at all. And to be clear, I think an appeal will be raised. They're almost automatically raised in life sentences without parole. And I think the Dahmer evidence will be brought up, but I think the judge acted well within his discretion. I disagree with his decision, but I don't think it was an abuse of discretion. I don't think you win on that issue on appeal at all. Ogonza 1000 says, where did she get this lawyer? Wish.com. Apparently, public defense or an appointed attorney. Ogonza says, is the prosecution deliberately taking their case in closing, tanking their case? Prosecution did. I hated the guy's delivery, but it was way better than defense. He also says, Schabusiness clearly not guilty based on self-defense. I agree. Dark Omen, the FBI literally introduced the Whitmer guys to each other. They never met before the FBI created the kidnapping plot. If they do that to them, you're fucked if you don't stand up for the obviously guilty. I agree. Ogonzo Dumois still thinks Amber was innocent, FFS. And Rumble usernames, Nick, I'm pretty sure that with the questions about Taylor's appearance and behavior, the defense is attempting to show that Taylor was, hold on. Locals shows these weird. Taylor was not under the influence of drugs when she was apprehended. Rather, her long history of drug use caused her mental instability. I thought she also said she was under drug use when apprehended, or at least I think that was the argument for why they should throw out her interview in the motion to dismiss it. Finally, Chicken Nooble says, would she be guilty of element 2 on dismemberment if the crime of murder because it was an accident is not guilty? Because it references a crime, but there's no murder. Is there element 2? Her guilt in a crime does not mean that she's not manifesting the intent to cover up a crime in a weird way. If she's chopping him up because she thinks, holy shit, this is bad, that's manifesting the intent to cover up a crime, in my opinion. That's what I think the intent element is. Whether or not they were actually guilty of committing the crime, different story. And then finally, Simple Jack 420, better slicer and dicer, Taylor Schabusiness or Chandler Halderson? I think Halderson wins. They still haven't found much of those bodies, so I think they win. All right, there we go. There we go, guys. Thank you for that. I'm going to close up because I have to make a quick guest appearance over on Chris Gore's stream, where I will get to, I think, make some arguments against Star Wars being worth existing. So I hope you guys will maybe pop over there. Chris Gore. I'll try and post a stream link up on Locals. It's probably on Twitter. I will see you guys there, or I'll see you later. I'm guessing the verdict is going to come in while I'm not available for the rest of the evening. I will have a show tonight. We'll probably cover the verdict then, unless they send the jury home. I can't imagine this taking more than the time it takes to fill out the forms. So that's my thoughts. I think she's going to be guilty on all counts, and there's no way she wins the insanity case. From what I've heard. I mean, they don't even have an expert willing to testify she has brain damage. So basically they're going to go on bipolar, and they're going to go on some other expert who's going to testify to the fact that prolonged meth use could cause brain damage. It's going to be a massacre for her. Worse than what happened to her boyfriend there. All right, guys. Thanks for hanging out with me. This trial's been great. I'm going to continue covering the second phase as long as I can. You know, and anything else. If deliberation is going to tomorrow, somehow we'll cover the verdict when it comes out. So I'll catch you around. Stay tuned to Locals, recadalaw.locals.com, and Twitter. Wait, Twitter's dead. Stay tuned to X for announcements. See you guys later. Peace. Peace.